Hello.
List of witnesses what today.
Hmm. For injunction, my lord, they are digging the soil, my lord, and they are changing the nature of the land, my lord, during the pendency of the appeal, your lordship. Therefore, I filed application for my lord, that will be taken up on 15th, my lord.
Just take that, man.
Tenant suffered a ejectment wanted by Monday, day after tomorrow.
Is it 1 or 2 minutes? Just 1 minute. Where is it? Just call the counsel.
Sir, Shivaram.
Have you informed the other side?
Yes, sir, we have taken the signature, my lord. Yesterday also I moved the matter since there was no sitting, my lord. We moved the matter in the other court.
We will give a date. Let's see that. We will see it. Is it just see it?
Every day they are digging the soil, my lord. They are removing the soil, my lord, and they are entirely changing the nature of the land, your lordship. That's the
We'll see
reason, my
that.
lord.
We'll see that. Just one.
20th, sir.
It's 20th January.
Please.
But you have to inform the other side on this.
Yes,
Give it to-
definitely we will inform.
No. Ask him to take acknowledgement of the date. And that he doesn't know the date, not 28th. That he must.
Today itself we will inform.
Sir, date inform ಮಾಡ್ಬೇಕು opposite.
Today itself,
20ನೇ ತಾರೀಕು.
today itself I will inform, my lord. By way of letter, I will inform or sending message, your lordship.
Okay, yes.
The tenant suffered an ejectment decree in an appeal now, commercial appeal.
No, but this is a fresh appeal.
Yes,
Objections
yeah, all are clear.
all are clear. Was there any stay below?
No, my lord, there's no stay.
Where is the urgency?
But there cannot be a stay, my lord, because this court has to consider the appeal.
No, that's right. But was there any stay below during the suit?
But I am a tenant, defendant tenant.
Oh,
The
sorry.
defendants.
Just give it to him.
If I may.
This is ours only. This will be ours only, not it of it.
Your lordship is
Just give
maybe
it, just 1 minute.
Sir, 27 1.
That is it. You have noted the date?
Please,
Lordship, I appear for the appellants. I had filed a suit for partition and separate possession. My suit was dismissed.
Just 1 minute, man. We'll just check up. Caveat was there in that.
Sir,
Just ask him later. Yes, sorry.
My suit was dismissed. I have agreed by the judge.
For the suit for?
Partition and separate possession, Your
Okay.
lordship. My suit was dismissed. I filed the appeal. I apologize. The appeal is of the year 2022. I received an NOC wakalat last month. All office objections are complied with. It's yet to be admitted, Your lordship.
See, just take it. But objections are clear.
All are cleared, Your lordship. Everything's-
Just give it whatever is convenient to us.
Okay, wait. No,
For caveat,
no, Your lordship.
just give it convenient, maybe in February also.
29th January, madam.
Next,
Great.
who else? Yes,
My
ma'am.
lords,
I'm for appellant, my lord. This suit for partition. So I'm filing for the memo for posting on 16th one.
Just see it, ma'am. This is also late.
No, okay, wait, madam.
No caveat.
Just give it what is convenient.
30th of January.
my lords, suit for specific performance has been dismissed. The appeal has been filed within time. Unfortunately, the respondent has conveyed and sold the property. I have filed an application for impleading, my lords. That had to be considered. There's some urgency, my lords.
Third of February.
Please, my lords, much obliged.
Select suit for ejectment, my lord. I have submitted the execution warrant is issued, my lord. Nearly more than 30 employees are working. I seek my lord to have this matter.
When was the decree passed? Is it a pending appeal?
Fresh one, my lord, set to be
The
admitted
decree passed.
in December, my lord.
Now they file execution.
Yes, my lord.
When is the date now?
15th, my lord.
When was the order passed for eviction, this thing?
In the last month, December, my lords, in
What was
third
the
week
order
of this.
passed?
Order was passed in within 15 days, I should vacate the premises and hand over the vacant position.
What is the last date for that? What is the, when is the 15 days expiring?
15 days expired in the first week of January itself, my lord. On Wednesday, my lords, on 15th, my request.
So 15.
Great. my lord.
My lord,
Yes, ma'am.
yes, my lord, the commercial appeal which was disposed of, my lord,
Yes.
where the parties were relegated to arbitration, there has been a slight typographical error in the judgment, my lord. Because instead of the word challenging the order under section 9, the word conceding the order under section 9 has come in, my lord. That can be corrected. Because we had conceded to the arbitration and I think by para 2, my lord.
Proceeding is an order passed under section 9.
My lord, the challenge in the appeal was to an order passed under section 9, my lord.
That's right.
Yes, so we had conceded to the appointment of arbitrator. So I think the challenge was to an order because I'm still challenging the order.
Para 2 now, you have a copy?
Yes, my lord, I
Read
have.
it.
Yes,
Exceeding the order passed in is on an application filed under section. I have not said conceding. Conceding is the order was passed under section 9. That was conceded. It's a conceded position.
no, my lord, we have challenged the order passed under
That is
section 9. We are
different.
aggrieved by that order against.
Hey, But the appeal was challenging what order?
The section 9 order itself.
That's what we have said. We have not said
That is
anything.
that meaning.
That's the meaning. I don't think it's required. Okay, just give it back. Yes,
No, this is a pending commercial appeal of the year 2021, my lords. I'm asking for it to be listed because it's not come up in over the years, not once been considered on merits, my lords.
see, move after next week. Let's
After
say
next week,
Next month, move it. Maybe.
Because I'm happy for any date that this honorable court is happy to. I'm not asking for a date this week or next week. Any date is, that's all I'm looking
Know which date we'll be able, just take that.
Sir, opposite.
To do it, I think better would be mention it next week.
Please, my lord.
Next month,
Please,
first week February.
please, my lords. I'll do that. I'm great.
Lordship, CH1 matter, Your Lordship. Connected matter is listed on 16/1/2025 before.
What is the matter about?
Matter is about the writ appeal, Your Lordship, disposed of. As per the order of SLP, they have relisted the matter before the Honorable High Court, before CH1. Connected matter is also supposed to be listed, Your Lordship.
Total one matter.
Is it coming today?
On 16/1, Your Lordship.
Total one matter.
Is it court hall one matter?
Yes, Your Lordship.
Then mention it on Wednesday, 15th. Mention it on 15 before the court one. So it's the next day. na?
Yes, Your Lordship.
Mention it.
My lord, this is an RFA, my lord. I am a respondent, my lord. Recovery suit, my lord. I am the plaintiff in the trial court. My decree got, decree got allowed, my lord. But the respondent, defendant have appealed before my lords, and my lords have stayed the order subject to the condition of payment of 50% of the amount, my lord. But they have not done it, my lord. Hence, I am moving the,
You filed execution.
my lord. I have filed the execution, my lord. But there is a stay, my lord. By this, I have endorsed from other side also.
You have to inform the date.
I have informed, my lord.
Just give convenient date.
My lordship, this is
3-2.
Obliged.
Sir, sir.
This pertains to the court hall number 1. Actually, court hall number 1.
Yeah, okay.
This actually the wrong date was given on the 28th. It was listening in the communication. It was meant for 20. So it has been given 28th.
So you better mention it before the court hall one day after. That would be better.
May I make one submission? Lord, I have challenged, I appeal for the ESI. I have challenged the order of recovery of stipend granted to the applicant inadvertently, my lords. That application has been allowed and the said order has been challenged by the ESI.
Is it this court or court?
Yes, total 2.
Court hall two?
Yes.
No, what, you have challenged that interim order,
A final order, my lord,
That's a
passed
final
by
order.
the Central Administrative Tribunal.
saying that give the stipend to the,
Stipend inadvertently paid to the applicant, which has been sought to be recovered, my lord.
That has been set aside.
That has been allowed, my lord, by the court.
In favor of the.
Yes, yes. Any date?
Urgency, any contempt file.
No, my lord. He has not initiated any date.
But
Any-
objections are there?
No,
Office
complied, my
objections.
lord. All objections have been completed.
Don't give any.
Sir, 4-2, I have to serve the other
Date,
sides.
I have said. Date, please.
Just say that no objections have been complied. Just say objections have been complied with.
Yes, my lord.
My lord, this matter pertains to Portal 1. I got the order from this honorable court with a direction to extend the time in the fifth ACMM court, Bangalore, my lord. I approached the learned magistrate. I submitted the order of this honorable
Sir,
court
we'll
on
be
8th
able to-
January 2020. Wherein the learned magistrate allowed the borrower to contest in the matter. This is a matter pertains to SARFAESI. They filed a complaint under section 340 of CRPC against me to take a cognizance against the authorized office, where there is no adjudicated powers for the learned magistrate. On 8th, when I submitted the Honorable High Court order and all, requesting to extend the time for execution of the order, the learned magistrate directed me to serve the copy to other side. So therefore, for non-compliance of the order of this honorable contempt file.
Contempt have filed.
Yes, ma'am.
Actually, before, day after tomorrow, before court hall 1. Okay, better would be.
One matter for plaintiff's appeal.
Appeal.
Plaintiff's appeal. My suit was dismissed. The suit for declaration and injunction. The trial court dismissed the suit since I have not proved the possession. So now the respond by virtue of the dismissal of my suit, now the respond to alienate the property. So it will maybe taken up next week.
Any objections?
No, I have completed everything.
Just give it this thing, no objections are pending.
Yes, I have
Yes.
written.
You have said so?
Yes. Office of the.
Just give it.
RFA, my lord. In this suit for money recovery suit, my lord. Decree passed against me only, my lord. I'm challenging the order, my lord. And the appellant is, the respondent is the
What is the
instated.
decree about?
My lord?
Decree is what?
Decree for the entire amount, my lord, with the interest of.
Recovery suit.
Yes, my
Oh.
lord. The respondent is instated the execution, my case, my lord. Last week, each warrant also issued, my lord, kindly urgency.
What happened on 8?
Each attachment warrant is issued, my lord.
Just take it.
Intimation, other side also,
Stay
my lord.
object. Any objections pending?
No, madam. 2022, madam.
It's a pending matter.
Connected, other one connected, madam.
How much is the decree for?
Madam, the decree for 9 lakhs, 9 lakhs, 10 lakhs.
The other side is appearing
Yes, madam.
in these proceedings.
Yes, madam.
You will inform them also. Will
Yes,
give you a date.
inform, madam. Through phone, I will inform.
You will inform the date.
Yes, madam.
You'll-
Today, today itself.
All connected.
Yeah. 16, you will get-
Sir, 16,
madam.
Just ask him to inform the other side.
sir, other side.
Inform, madam.
So
Date ಬೇಕಲ್ಲ.
let's see court hall 1.
Portal 1, list number 2. Serial number 1.
Please, my
serial
lords,
number 1, Akshay Kumar.
please, appearing for the learned counsel for the appellant, my lord. A short question is involved, my lord. If at all, my lord, is sir, lots of pleased to hear matter, your lordship can dispose of the regarding the condition in the tender, my lord.
We'll have it before court hall 1.
Yes, your lords may kindly fix one, any date, my lords, with this urgency is there.
Just give it.
17-2, sir.
Please,
Serial
my
number-
lords.
Serial number 2,
This case, I represent complainant, my lord. Short accommodation, maybe. We will settle the matter, my lords.
Re-notify.
3-2. Serial number 3, Shri Jagan Mohan. Serial number 3, 4-2. Serial number 4,
For complaint, my lord, in this case, my lord, they have filed an affidavit stating that they will revoke the suspension of the complaints, my lord. But still, they have not implemented, my lord. Kindly.
What are instructions, ma'am?
My lords, I represent the state government. They have a council. The university has their own council. They have filed the affidavit.
But so far, no, not
Contesting
implemented the order.
response.
Kindly started maybe given. This week maybe.
28-1, serial number 5, Ganesh Rao.
My lord, I am appearing.
Five
Lord,
two.
one application is filed, the cast title of A3, that name spelling mistake is there, that is to be allowed. Instead of Rajiv Kumar, instead of Ranjiv Kumar, Rajiv Kumar is typed. So that IA is filed.
We'll have it before court 1.
5-2, serial number 6, Srimati Manjula.
Fair for accused in the second case, my lord.
24-2,
Fine. The 26th it may be taken up. 26th, I will not be in station.
26-2,
26th.
26-2, Raja sir.
My lord, one kind submission in a written appeal, the counsel for the appellant, they have served appeal memo on the advocate who is appearing in contempt case, my lord. That may be held sufficient. Memo has been filed to that.
You have served him.
Please, my lord.
Okay.
That's all.
Next.
Just 27-2, sir.
Much.
7, Rajeshwar.
The response. That's 10 days time be granted to the accused must will file a response.
5-2,
Happy for the company.
Yes.
5-2, sir.
He wants time to file compliance.
They have to comply the direction of the.
Wait for some time.
That's what he's saying.
Short accommodation.
Yes. Just give it.
5-2, sir. Serial number 8, Shrikant.
We notify.
19-2, serial number 9, Sri Lokesh. 19-2, 10, Sri Manu Kulkarni.
Writ appeals pending, may I just pass on the numbers to the court master, they listed on the 20th, put this bit tagged along.
28th,
Just pass on the numbers to the court. Great.
So we just have it on 29th.
20th, very much.
Sir, listed on that day.
Those are listed on the 20th, this Friday.
Yes.
Great.
20th.
I'm sorry.
11, Sri Krishnamurthy.
We notify.
5-2, 12, Sri Swami.
We'll be held on 17th of next month. 17th of.
We notify.
28-1, serial number 13,
On which day?
17-2.
17-2, 17-2.
The paper publication has.
Madam, sir.
Serial number 13,
I appear for the complainant, my lords. The accused is not letting the complainant talk to the child, my lords. A short date be granted. So that I mean.
That's the order.
Yes, my lords.
We notify. Just give a short date.
21-1,
Please, my lords. Much of.
14, Sri Devi Prasad Shetty.
Same also, my lord,
My lord.
21. There is a specific direction, my lord, to come, government to file an affidavit stating that what the steps have been taken, my lord, after issuance of the direction
There is
issued by
an
the
application.
single judge, my lord, to conduct the election process, my lord, within specified period.
Application for extension is set out to hearing today, my lords, before the learned single judge for extension of time. My lords may kindly take it up after 3 weeks.
21-1, my lord, next week, my lord. Today it is there.
Today it's listed
Today it
serial
is
number
listed.
77.
Last Friday it was listed, my lord.
1 minute, please.
Sorry,
We'll
ma'am.
know the fate of that application today.
Yes, we
We'll
will.
have it next week.
Please,
My lords, week after next, my lords. If it is not it's
No,
serial number
ma'am.
77.
because, my lord, my request is, my lord, it is an election process. Election, my lord, was directed to conduct the election.
Okay, give next
Please.
week, ma'am.
Please, 21-1 may kindly.
Just give next.
21-1.
Much of.
15, Sri Siddharth Suman. 15,
I'm appearing for the petitioners, my lord. We have received NOC wakalat from the petitioners. I will argue the matter, my lords, on short accommodation.
Just give it after 2 weeks or 3.
6-2,
Much obliged.
16, Srimati Veena. 5-2,
We notify.
17,
For the
accused number one,
your lordship. The day before yesterday, I filed my wakalat in this matter for the accused number 1. 2 weeks time may be granted, your lordship.
We notify.
10-2,
My lord,
18, Sri
my lord,
Manivandan.
16, my lord, I wanted withdraw, my lord, 16.
Which one? Serial number 16, my lord. Contempt.
6.
Yes,
We'll
my
have
lord.
it. What is the date?
Withdrawal. I want to withdraw that, my lord. Withdraw is not pressed, my lord.
Who is the other? When you are there?
My lord,
Srimati-
central government, my lords. So GST matter.
It's a contempt proceedings, my lord.
Yeah, you want to
I want to withdraw the application.
This those metals.
Theos metal. Yes, my lord. Yes, my lord.
Just say that Learned Counsel for the appellant seeks to, the petitioner seeks to withdraw the contempt petition. Dismiss as withdrawn.
Yes.
Just take the name. Show and so says.
KG comments.
KG comment. Serial number 18, Srimati Vannan.
Appearing on behalf of complainant, my lords, if your lordships permit me on 27th of this month, my lords.
Just re-notify.
27.
NR but presenting.
9.
Not in this case. I'm NR but presenting myself.
Notice
But
has been
not-
issued to
I'm
the.
denying this allegation and I may require longer time because 200 pages I received only yesterday.
But non-filing is there.
You are the respondent.
Yes,
Yeah,
ma'am.
NR but is my name.
Okay. When do you want?
At least end of February.
Please give it.
My lords,
No,
already
no,
property has been,
What is the urgency?
my lords, already property has been encroached by an adverse side, my lords. And also there is a trespass of 40 to 30 members who are already staying in the
What is the
premises,
date
my
given,
lords.
ma'am?
And most.
27, 1, sir.
Okay, we'll have it on 27 one. Let's see that.
Obliged, my
Okay.
lords.
Next.
19,
My
Srimati
lord,
Kamath.
appearing for the appellant, my lord. Appearing for the appellant, my lord. But copies of the appeal memo along with the IAS have been served on the respective counsels of respondent number 1 and 2, my lord. These are the same counsels who have appeared for the respondent 1 and 2 before the learned single judge, my lord. My lord, kindly the
Okay.
names of the counsels be shown, my lord. The first counsel is Mr. Pradeep Patil for respondent number 1, my lord. And the second counsel is Mr. Hetty
No,
for
just say
NNC.
that they have to file wakalat, na?
My lord, my information is that they have filed the
We
wakalat.
don't know.
Please, my lord.
Just say that Learned Counsel for the appellant states that the copies, the paper book or the appeal paper book has been served on counsel for respondent number on the counsel for the respondent number 1 and 2 who appeared before the learner single judge.
Please, my lord.
Okay,
Please,
next.
kindly have it after 1 week.
So, what is the, chalo, de do. Just give it. What is the urgency?
There is no urgency as such. my lord.
Not everything should be 1 week. It should be
Please,
4
sir.
weeks also.
Any day.
Just give it date.
4-2. Serial number 20, party in person.
They posted on 16th or 17th of this month. Please,
What, why?
my lord, time bound supreme scale has been denied by making adverse view as poor my.
We will look into it.
No, my lord.
Just say re-notify.
Please, my lord. Short date, my lord.
Just
16th or
give
17th of
convenience.
this month, please, my lord.
See, let's have a convenient date.
Please, my lord.
30th January.
Next.
Serial number 21.
Lord, I'm appearing for the.
matter. The advocate is in another court.
See, we will give a short date. It may not be possible.
Okay.
Okay? Just re-notify.
27-1. Serial number 22.
Hearing for the accused. Bank has preferred an appeal, a writ appeal, and this honorable court had directed that issuance of notice in the appeal would be a defense in the contempt. May I just place that order on record, Your Lord?
Item 22.
In item 22.
Who appears for the other side?
Shri Sangamesh.
You appear. What is the date in that?
The date is 20th February.
Just re-notify 20th February.
20th February. 23.
Great.
Complaint, date after 4 weeks.
Re-notify.
24th February. Serial number 24.
Re-notify.
10 to 25.
Re-
Balagangadhar.
Re-notify.
11-3. 26.
Hearing for the state, my lord.
Re-notify.
Requires some hearing.
Re-notify.
29-1.
My lord, 29, I have some personal difficulty, maybe 6th or 7th Feb.
When do you want?
6th or 7th Feb, the week after.
6-2.
6 is okay. Grateful, grateful.
Next.
T7, Shri Prakash Shetty.
My lords, I appear for the petitioners. My lord, this is a forest land. They are trying to remove the tree. My lord, this matter was on last occasion for final disposal. It is posted. I want lordship may kindly have short date, my lord, any date on 27th one or my lord, any. This is a forest land, my lord. There is a threat of removing the trees in the forest land by the.
29-1,
Please, my lord, much obliged.
serial number 28.
But in this case, am I permitted to comply the office objections, my lord? Case is dismissed for non-prosecution for non-compliance of office objection. Am I permitted to comply the office objection, my lord? So that
Just re-notify on this.
12-2,
Right.
29. Shri Ganapati Bhatt,
Re-notify.
25-2, 30.
Happy for respond number 1 minutes.
Re-notify.
27-2, 31.
Re-notify.
Shrimati Purnima, 3-3, 32. Party in person, Shri Ramesh Nayak,
Re-notify.
4-3, 33.
Before the
Shri Usma.
petitioner, this is with regard to the payment of the compensation to the people who died in COVID, my lord. They are the employees of the State Transport Corporation. They were asked to do the duty. They contracted the disease and they died. My lord, the government declared the compensation of 30 lakhs per head. They did not, till today, they have not been paid. It is why.
27-1,
Much okay.
34. Shri Pradeep Kumar,
Re-notify.
5-3. Serial number 35, Shri Ganesh Gowda,
Appearing for the appellant.
Re-notify.
4-3, 36.
Please, my lords. I am for 36.1, 2 and 3. Lease is going to expire on 18th of this month. Matter may be taken upon either on 15th or 16th of this month, my lords.
Re-notify.
21st January,
I think 18th is the last date that lease is going to
Already
expire.
been
my lords.
cancelled, my lord.
16th, sir, 16th January,
Please, my lords.
37,
Re-notify.
25-2,
38, re-notify.
38, 10-3, 39.
Re-notify.
39. Lord, order is complaint. My lord, the year 2023. Lordship, my kindly give a short date, my lord.
Just re-notify.
29-1,
Wait,
40,
My lord, unauthorized occupation of government land by month end something. 40.
Re-notify.
30th January, 41, government advocate,
Just
Complainant is a senior citizen, my lord.
20th February,
42.
Short date be given, my lord. It is not implemented, the day has been directed within 4 weeks, has been complied. It is not, after delay of 270 days, you file a writ appeal, my lord. A senior citizen, my lord, 80 years is old, my lord.
Which matter? 41?
41.
We have given the date now.
sir, 20th February, sir.
Alas, planned out. The short date, my lord.
What is the urgency?
80, the senior citizen, my lord, the complainant is 80, see, age of 80.
When was the matter listed last?
The last date of it, last date was posted, but on that day, court was not sitting, they
Give
say,
a shot.
29th January,
Next.
42,
for the complainant, my lord. The complainant is a senior citizen.
My lord, I appeal for appellant.
Just give a date, ma'am. Otherwise they possible. Just give.
30th January,
Next.
43, Shri Rangnath Joyce,
I'm sorry, my lord. The oversight, my letter has appeared my matter.
It's all right. Doesn't make any difference.
Sir,
You have
this is my-
noted the
but
date
come-
now.
come.
sir,
You have noted the
30th
date in
My lord.
42?
30th January, sir, yours. Serial number 42. 43, Shri Rangnath Joyce,
I appear for respondent number 5 minutes.
Re-notify.
5th of March, 44,
Appear for
first
respondent, ma'am.
I have to file my statement
of objections, ma'am.
Short date, my lord.
44,
There is a
45.
direction, my lord, I show.
10th February, serial number 44, 10th February, 45,
Appearing for respondent.
appellant, my-
Respondent.
New respondent.
Oh,
Re-notify.
short accommodation for filing the statement of objection on the whatever they are filing.
5-2, 46, 46,
Re-notify, 47 re-notify.
18-3, 20th-3, 48,
8 re-notify, 49 re-notify.
20th-3,
It's a shorter date.
49,
48. It's the KSPCB matter, my lords. 48 maybe a shorter date, my lords, in February.
So, we give you, what is the date given?
sir, 20th March, sir, for 48,
Give it shorter, we'll give it in February, ma'am.
11th of February,
50,
Obliged.
51.
49,
49 either on 15th or 16th of this month.
This is the same issue.
Identical, not same.
No, but the lease is expiring.
No.
And in all these matters, my lord, there's cancellation of the lease, my lord, basically by the government that has been impugned in the writ petitions.
Date. Oh.
Already there's cancellations, my lord.
3rd of
The previous
February.
matter.
Sir, 3rd of February, seal number 50, Shri Saravana,
For the petition in this case, my lord. Date may be
Re-notify.
18-3,
interim order may be extended. by the-
Interim order, if any, to continue.
51, Shri
Hello.
Prashant Gaudar,
Re-notify,
25-3, 52,
notify.
26-3,
That's it. All are-
list number 1, serial number 1,
Malad.
Mantraya,
Serial number 9 concerned, Malad. I'm the state appeal, with lordship permission, I can take, Malad. Serial number 9, list number 2, Malad. The state appeal, Malad. State appeal, we have also filed the additional documents, Malad. So it had to be reached this honorable court, Malad. So the shocked accommodation, Malad. This,
Number 2 is Court Hall 1.
no, 2. List number 1, Malad. Court hall number 2, Malad.
Will come. Just say 4 weeks to remove objections.
Your lordship,
I make one word. List number 1 million, serial number 56 and 57 and 58
I
connected.
appear for respondent. to this.
Other side has no objection. There are other matters have already been posted to 6th March. Matters are also to be connected and
You said 50,
56, 57, 58.
56, 57. Oh, these are Nimhan's matters.
Already last date of hearing.
Lords, in this matter, I may be permitted to make submission, lords. In this matter, there is some urgency. I'm requesting for a shorter date so that all the matters may be connected and
But
taken up
this is
together.
slated for
Once we have
final hearing.
given there, now we'll have it along with.
Lords, only urgency is, my lords, our increments are withheld on the count that petitions are pending before this honorable court.
Doesn't make any difference. We can restore it.
My lords, CAT has already caused the impugned articles of chapter.
Well, these are the matters relating to.
Just say 56, 57, 58, re-notify. Which date you said?
6th March.
6th March.
In fact, on the last date of hearing, the colleague was here and he made a representation and the matter date was taken. And I have informed him in the today morning, stating that he has no objection. Now his colleague comes and says that he wants some.
Lords, I'm asking for a shorter date, nothing else.
He's,
Lords, these matters may be connected with these. matters.
we have given 6th March.
Please.
Okay?
your lordship, serial number 25, your lordship. I appear for the appellant, your lordship. I have informed the other side, there is slight inconvenience from my end, your lordship. It may be posted, any shorter date,
At the
shorter.
request of counsel for the appellant, re-notify. Just give it in March.
Interim order may be extended, kindly be.
Interim order if any to continue.
Number 40.
24th,
We'll just come back, run through the list fast.
serial number 1,
6 weeks to comply with the objections.
1st of April, serial number 2,
But I filed the written arguments in 1 minute.
Submissions.
I am for respondent. Respondent 1 to 3. I will also file
So
the.
for the party seeks further time of 2 weeks to file written submissions. Re-notify and give it in March.
4th of March, serial number 3, Sundar Raman,
Kindly reissue notice, your lordship.
Issue notice on what?
I number 1 and I number 3, your lordship.
Let
Continuation and.
fresh notice be issued to the respondents, to the respondent on IA 1 of 22 and IA 3 of 22.
2 weeks time will be granted.
Just give a date.
25-3,
Next,
4, serial number 4,
Paper, the
Kiran.
appellant in this.
service on the respondent is still awaited. Let service report be given to, service report be filed by the registry on the next date of hearing.
19-3,
Obliged.
serial number 5, Shri Nishant,
I appear for the appellant.
I've taken out paper publication and I filed an.
You have done it in all the cases?
Please, minutes.
Yeah, sure. Is it there in all the cases? You say that in terms of order dated
6/11/2020.
6/11/24 service on the respondent. Which respondents is this?
R1.
Respondent number 1.
Respondent number 1 has been effected through publication. The paper cutting has been filed
Page
along
40.
with an affidavit. There is no appearance for the respondent number 1 despite publication. Full stop. The service on the respondent number 1 in this batch of appeals is deemed to have been effected. Then say there is no appearance for respondent. Okay, re-notify the appeals on
5th of March. Serial number 6. Rajeshwar.
As per the last order, my lord, there's a direction given by this honorable court for the board of the KDB to take a decision, my lord.
what
In fact-
happened?
In fact, decision not taken, your lordship may have it after 2 weeks, my lord, by then we'll take a decision on the matter.
Just say that Mr. Sashikiran Shetty Leonard, Advocate General, states that decision is yet to be taken by the board of the KIKDB.
Please.
That is request re-notify. Have it after 4 weeks.
Please,
My lord, I request, my lord,
25th February.
third week, second week or third week of February, my lord.
Why?
The-
We'll have it for third week. Just say
Third
it
week,
after
third.
4 weeks will be third week only.
by then definitely a decision would have been taken by then.
Interim order,
18th February, sir.
Interim order, if any, to continue
please.
till the next date of hearing.
7. Serial number 7.
Lord, we have now transferred it to Bombay office, so the dispute may not survive.
Acha,
We have transferred.
you have done it.
There is an order also passed. I'll file it along with a memo. There is an order, decision made it has already been transferred.
What do you say then?
Milords, this is a totally new development, Milords. Milords, I am questioning the registration of ECIR back in December of 22. Whatever action has been taken pursuant to that registered ECIR, that becomes non-est. If Milords.
Then Mr. Yadav, once they have now transferred, whether we can entertain it, whatever you are your please.
I'll explain why, Milords. The ECIR, Milords, which was registered against me and the other co-accused in December of 22, that was registered without jurisdiction back then. Today, Milords, the subsequent transfer cannot validate either that ECIR or whatever action, whatever Milords.
But where will you urge that point?
Here itself, Milords.
How?
Because
Today there is no ECIR.
No, there may not be any ECIR, but that ECIR, Milords, which has been transferred and all that action which has been taken by Bangalore zonal office, that becomes non-est.
But will you contend there before the court, which has now, we will see, just file it, Mr.
Milords, this will, otherwise, Milords, this will be, Milords, setting a very wrong trend. Last more than 2 years, you've been, Milords, harassing me here in Karnataka, opposing my application, my writ petition before the learned single judge, opposing this writ appeal, and now you are saying after more than 2 years that we've
But
transferred to Bombay.
Tell us one thing, can we now decide that issue in
Please,
these
Milords.
appeals?
I'll explain why, Milords.
We will see it. Let you file it, Mr.
We will file it, my lord. We will
Just
file
give him a copy
it.
and
We'll
file.
furnish a copy and we'll file.
Milords,
I am
if-
producing the copy of the order, my lord, notwithstanding this transfer, my lord, if my learned friend wants to continue, but we are ready for the argument. We will file this.
I would like to argue
on-
my writ appeal, Milords.
No, today what he is saying is possibly now we have to see this also, Mr. Kamath.
Yes.
Now, whether that can be a subject matter before here.
True, true, my lord.
That would
True,
be,
true, true.
but what he is saying is that's what we are posing him.
But if I may read the order, my lord, it says, subject transfer of file from Bangalore zonal office to Mumbai zonal office. Kind reference is invited to HO letter dated so and so, whereby this office has been directed to transfer the investigation file along with all records pertaining to Sri Sital Kumar Maner and others, bearing number so and so to your good office place. In pursuance of the same, kindly find investigation file along with all records as mentioned within so and so. Further, a note on investigation done and pending works identified so far is also enclosed. So
We will only record what Mr. Kamath is saying, this ECIR now stands transferred from Bangalore.
yes, my lord.
With respect, my lords, the investigation and the record is honest. The investigation, the statements recorded under section 50, all the action which has been taken by,
Yadav, simple.
please, my lords,
When is the cause? Cause would be today.
please, my lords.
Cause would be today to urge that point.
No, my lords, no.
Whatever remedy you have, you will seek that remedy.
Yes,
Today, we may not be able to see that. That was a non-issue.
My lords, may I just, may I
The
just-
entire file itself has now gone to Bombay.
Okay, just hold on.
please, my lords.
Just say that Mr. Arvind Kamath, the additional Solicitor General, appearing for the respondent, states that a decision has been taken to transfer the ECIR from Bangalore office to the office of the respondent at Mumbai. That's right?
Yes.
Then just at the request of Mr. Yadav, re-notify.
Please, my
We'll
lords.
have it, we'll hear you. Just give it any February date.
Sir, 13th February,
13th February.
13th February.
Next.
Grateful.
Serial number 8, PN Harish.
Notice is awaited, and so far as office objection is concerned, madam, on 21, 22 and 24 itself, I made a submission. Not been considered. There are one line in Kannada language in Annexure C. And there is some mistakes in the names of the appellants before the impugned judgment. So I
Just
made a
say that as a
submission.
last opportunity.
Lord, I already made a submission on that office objections, my lord. I made a submission on the office objections because the
See, you
office,
have to serve R2, R8 and R12.
that is awaited, my lord. There is the office objection note is also there. That is, I am making submission for that.
What are those two office
That
objections?
one is Annexure C, there is a one line in Kannada. I will not rely upon it on, I made a submission. And the second one is, names of the some of the appellants is wrongly shown in the impugned judgment. I mentioned the correct name and I made a note in the appeal memo itself.
See, but that you need to possibly, get the impugned order corrected.
Because their names is wrongly shown in the impugned judgment. That is why in the appeal memo itself, my lord, I mentioned it, page number 9. In first note.
Are the names correctly shown in the,
In the appeal memo, their name is correctly shown.
but in the impugned order?
Impugned order, it is wrongly shown.
Yeah, that order need to be corrected. Otherwise, it will create confusion in future.
Yes, my lord, I agree with that. I will
And
make a
Possibly
application.
you have to think over it,
Yes,
whether you'll file an application there and get it corrected.
please.
That's how it should be. Then you file it on record appropriately, it will be taken. Otherwise, there will be a confusion in
Yes,
future.
yes, that will remain intact.
That's right. See, respondents 2, 8 and 12 are still unserved. Let fresh notice be issued for service on the said respondents returnable on. That insofar office objections are concerned, we say nothing, think over it, file an application, get
Please,
it corrected. Next.
5-3. Serial number 9.
Yes, may I just one small indulgence in previous matter, because would your lordship, Milos, indicate in the order that a copy of that order or whatever that.
No, that's the reason we have noted it, Mr. Yadav. I don't think the order says anything specific.
If
It's
you could
just
get a-
an intra-office memorandum.
Milos, if you could get a copy also, Milos,
So you have to call Mr. Kamath.
I'll inform him, Milos.
Just inform him, call him, then we will see. Just ask him to come.
Very well.
Opposition.
Serial number 9, Shri Nitin Prasad.
This is the state appeal, Malat, as well as the respondent appeal also. Malat,
Yeah.
Appear for the appellant in serial number 9, my lord.
9 is concerned, Malat, the delay is concerned, Malat, only 57 days is officially the correspondencing, Malat.
In 9.1 for the state,
Yes, my
That's
lord.
the state
State appeal. It's a state appeal, my lord.
Yeah.
Against the
What do you say
petition.
on this? Now, 1 and 3 have unclaimed. Furnishing now, respondent 4 and 7 need to be served.
We'll take stock. The lots of permissions, we'll take it there.
Say this.
My lord, with respect to serial number 9, may I submit, my lord? 9, R1 is unclaimed. That is the land tribunal, my lord. In
We don't require land tribunal.
yes, my lord, then maybe dispensed with, my lord. And 4, my lord, unclaimed, may your lordship may consider sufficient notice, my lord.
What is the report? 9.
There is R4, it says unclaimed. my lord.
Seven, 11.
Who is respondent number 4?
Respondent number 4.
AC Anand Swami, ma'am.
Whether it's a contesting party.
Is he the contesting respondent?
Yes, my lord. He is one of the petitioner in petitioner number 7, my lord. In writ petition.
Fresh.
Yes,
the
ma'am.
Respondent number 4.
Please, my lord.
They say that though the service report with regard to respondent number 1 and 4 in both the appeals depicts 1 and 4 and 1 and 3 depicts that depicts as unclaimed. The respondent number 1 being the land tribunal, notice to land tribunal is dispensed with. Insofar as respondent 4 and respondent number 3 in both the appeals, fresh notice be issued for service returnable on.
My lord, the delay may be condoned.
You want delay condone?
Yes, my lord, 5 days delay in.
Delay in 53 days.
Yes.
In 9, 5 days, my lord.
A state appeal.
Condone then both.
Yeah, please, my lord.
In just saying 183, there is a delay of 5 days for the reasons stated in the affidavit. Is condoned, and similarly IA 1 of 24 in 9.5 for the reasons stated in the affidavit, and the learner counsel for the respondent. You would be appearing for whom?
For the R3.
No, 1 minute. 1 minute. 9.1. 9.1. And notice in 9.1 should go to 1 and 3. There is no land tribunal. Land tribunal is on 7. 4 and 7. Delay condone, application disposed of. You do it, I'll correct it.
My lord, the concerned about the tribunal, my lord. So tribunal is also one of the party in the writ petition.
We'll dispense with land tribunal.
Please, my lord.
Do you require any land tribunal? They will not come and justify their own. That's respondent number
My lord,
7.
because this is the third time the tribunal is, in the tribunal member itself is, there is a dispute. And one of the commissioner, the assistant commissioner, he is in favor of the state, is saying that this land belongs to the government. But other 2 members without the inspecting, without intimating, inspecting, and they are given the report based on that, the tribunal, that's what I prayed, my lord.
We want to know whether the tribunal will come to this court and justify.
If it is there, my lord, according to my, the view, my lord, my submission to your lordship and prayer also, if it is a party is there, that will be better, my lord, so that the view of the tribunal members also will come to know.
Just do one thing, don't dispense with the service on tribunal, just a fresh notice.
My lord, till then not to precipitate the against the tribunal order.
What are they precipitating?
My lord, they are entitled to be asked for the land by this.
They file any contempt?
As of now, it's not.
When they file contempt, you can come.
My observation, my lord, so.
What requires observation? Tell us.
My lord,
Are you precluded to come?
No, say this, if they come to the contempt, then
Obviously, it goes without saying, you will, first thing you'll find.
much obliged. My name has to be.
Next.
26th March,
11.
serial number 10.
Humbly appear for the appellant. My lord, in this matter, the office has raised the objection that annexures P and R have been interchanged. Unfortunately, that mistake occurred in the rejoinder filed before the learned single judge. And so the same mistake has been repeated here in the writ appeal papers also. I humbly pray that that objection be overruled. Secondly, my lords, the appellants 1B and 1C, they have taken NOC wakalat from me after the filing of the writ appeal. So I have filing here with a memo to transpose them as respondents instead.
Now, what about the first objection?
My lords, the first objection, my lords, I humbly pray that it be overruled because there was an error or defect in the rejoinder filed by us before the learned single judge. And we mentioned one annexure as P instead of R and vice versa. Now, if we have to, and that objection has been raised by the registry. So I humbly pray that that be overruled because we have just repeated the very same records that were filed before the learned single judge. And no objection was raised at that stage.
Where is that objection?
What is exhibit P1? P1, my lords. Annexure P1.
So tell us one thing, this P and R.
Yes.
What you have filed were the annexures which were filed before the signature?
Yes. There is no problem with that. Only the interchanging, the nomenclature given is wrong.
But you have to file the translation.
I have filed a translation. Yes. Annexure. Please. My lords, at page 295, translated version of annexure P. Relevant translated copy of annexure P. Okay. And
Just say that insofar as the office objection
and at page 305, translated version of annexure R.
is concerned, the learned senior counsel for the appellant states that the annexures.
My lords, I'm not yet senior, my lords. I'm not yet designated. I'm still a very junior lawyer.
Then a counsel for the appellant states that the annexure P, the objection raised by the registry be overruled as the annexure which has been filed in the appeal as R, which is that annexure now?
P and R.
Annexure P and R were the annexures filed before the learned single judge.
In the rejoinder.
In the rejoinder. Good stuff. Noting the above submission, the objection is overruled.
Secondly, my lords.
Leaving all pleas available, just overruled. Yes, what is the second one?
Second point, my lords. The appeal is filed on behalf of appellants 1A, 1B and 1C. Now 1B and 1C, after the lodging of the appeal, have taken NOC wakalat from me and appear not to be desirous of pursuing the appeal. So I will have to array them as respondents instead. So I have.
Your lordships, kindly, my lords.
No,
My
just
lords,
1 minute.
please,
No, but
please.
you would be appearing for one of the appellants?
Yes, only 1A.
But now, we don't know, suppose, see, they want to pursue the appeal.
Yes.
Maybe through a different counsel.
Yes, my lords.
They can still pursue the same appeal.
Yes.
Why transposing them as a respondent?
Yes.
It's only that you would not be the counsel.
Yes, I will not be the counsel.
That's the
I will
only
not.
thing. Who appears for them? Anyone?
My lords, in fact, one more appeal has been filed, my lords, in WA 1126 of 2024
No, by whom?
by one other advocate, my lords.
No, on behalf of 1A and 1B.
No, my lords.
See, then, very well. We say nothing on that unless and until we are clear if there is a representation 1A and 1B, they say we will pursue this.
Yes.
Maybe through a different counsel.
Yes.
Clear.
Yes.
But transposing them means there is no appeal.
Creates a problem. Creates a
There
problem.
would be a problem.
My lords, I'll just file a memo that I'm only appearing for 1A.
But the only thing
That
is
is
you
it.
should ensure their presence on the next date.
Yes, my lords.
1A and 1B, that responsibility has to be there with you.
Yes, my lords.
So that then we can record it, whatever
Yes,
is there.
yes, my lords.
Tribunal counsel also states that the appellant number 1 and one B, one A and one B.
No, no, my lord, one B and one C.
One B and one C have taken NOC from him.
Yes.
And that as such, he shall not be appearing for the said appellants. There is no appearance for the said appellants. The learned counsel who is now appearing for
Appellant one A.
appellant one A shall ensure the presence oblique representation on behalf of appellant one B and one C on the next date of it.
Could it be taken up next week?
We will just see, we'll give it a re-notify on.
Yes.
Lords, may I request the matters to be clubbed, my lords? There is one more appeal.
You file a memo for that.
Please, my lords.
That arises from the same impugned order.
Please, my lords. Very
Just
same
file a
impugned
memo.
order.
File
Please,
a memo.
Please, my lords.
But you have to, you appear for whom now in this appeal?
I am for the respondent number 3.
But then you have to ensure if others are appearing in the connected matters, they should be notified.
My lords, they are not the necessary parties, my lords.
We don't know. We don't want later they come and say that we were not notified.
Please, my lords.
You see, that's for you to take a call.
Please, my lords.
Next.
My lords, could I humbly seek it to be listed next week?
Not possible.
Please.
Not possible. We'll give a date.
Yes.
Next.
13 to serial number 11. Srimati Vandana. 11.
Appeal for the appellant, my lord. My lord, I have filed an amended application regarding my lord. In the above application, it has mentioned as Karlapura village. It has to be mentioned to be an Chellahalli village, my lord.
See, you have to carry out the objections, we clear the objections.
Yeah, this is, the objections are, I should serve the copy. The advocate was not available, my lord. Today I will serve the copy of the amended appeal.
And the translation also you.
Translations I have filed, my lord.
You filed the translation?
Yes, my lord.
Just say that learned counsel for the appellant states that the English translation of the Kannada annexures have been filed.
My lord, kindly allow the amended application, my lord. Yes.
There is an objection with regard to that application?
I should serve the copy, my lord. The counsel in record was not available. I had served for the state, my lord. For the respondent number 5, the counsel was not available. I had tried several times. Today I will try.
Will you serve them? Will you serve him?
Through WhatsApp, I have been served, my lord. I didn't serve the hard copy.
Just serve a copy to him.
Today I will serve.
The learned counsel for the appellant states that he shall serve a copy of the appeal also on the appeal oblique application 4 of 24
Yes, my lord.
on the counsel appearing for respondent number 5
Yes, my lord.
within 1 week. Re-notify on.
11 to serial number 12.
My lord, so far as respondent number 1 is concerned, they've refused service. Therefore, it must be held as good service.
It says unclaimed.
Please.
How would you say so? How would you interpret it? Unclaimed, not claimed.
Lord, they were served in the suit. They are State Bank of India.
Just show what does it say?
Lord, R1, the cause list says refused.
R1 is.
R1 is refused.
Yeah.
Refused.
R2 unclaimed. Just say this. Respondent number 1 has refused the notice. Hence the service on respondent number 1 is deemed to be effected. Let fresh notice be issued. Now you are proceeding. Who is the contesting party, respondent?
First respondent is the contesting party. So far as respondent number 2 is concerned, he was set ex parte before the trial court.
So you don't want to serve him?
No, my lords.
Just that apart, the learned counsel for the respondent appellant submits as respondent number 2 was an ex parte, comma, you will not press the appeal qua him?
No, my lords. He should be a party, but service may be dispensed with at my risk.
The service to respondent number 2 be dispensed with at the risk of the appellant.
Lords,
Now, what is the appeal now about?
Lord, respondent number 3 state. Therefore,
Respondent number 3 is state, very well. Now, the contesting party was only 2 or 1?
one, my lords.
What was the interstate dispute?
My lord, the dispute is respondent number 3 state there is a check in the name of respondent number 2 issued by respondent number 3, which turns out to be a fraudulent check. Respondent number 2 presents that fraudulent check to his bank account, which is that of the appellant. I make the payment to him. Thereafter, about 8 months later, the first respondent, that is the banker of the State Bank of Mysore, then State Bank of India now, they realize that this check has been, this is a fraudulent check. Therefore, they file a suit against me saying, please refund the amount. The state appears and takes a defense saying, until and unless the State Bank pays me, the suit is not maintainable. Because State Bank is not the suffering party. The suffering party is the state, but state does not file a counterclaim. Therefore, the suit itself is not maintainable.
Who was the beneficiary under the check?
Beneficiary is respondent number 2.
And what is the role of the state?
Not role of the state is respondent number 2 forges a check in the name of the department. Therefore, their money gets debited. State Bank debits their account and pays me, which I in turn pay my customer. And my lords,
And that amount, their account has been debited.
their account has been debited. They file a written statement saying, until and unless I am paid, State Bank of India has no locus to file the suit because they are the suffering party. And in the plaint, they take a specific position that they are discharged from liability towards the state. If they are discharged, they can't file a suit. They filed execution, my lords. There is a delay. There is a delay of 21 days. May I show, my lords, the plaint?
Their account is in the State Bank of India, the state governments.
Please sign. It used to be, my lords, in the State Bank of Mysore, which now, my lords, has merged with the State Bank of
But tell us one thing now, once the money comes from State Bank of India to
Please,
the State Bank of India, from you,
Please, my
or
lords.
from whichever, the respondent number 2 also,
Please, my lords.
then their account shall be adjusted. They will, then the money get transferred. SBI can't keep it with them.
Lords, eventually they do. But, my lords, under the Negotiable Instruments Act, they rely on section 131. Lords, my respectful submission is, State Bank itself says that under sections 85 and 89 of the Negotiable Instruments Act, so long as the check on first blush looks to be an appropriate check, they are discharged from liability. The only liability they owe is to their customer, who is the state. Therefore, State Bank of India is discharged. Lords, therefore, in law, I bow down, my lords, to what falls from your lordship.
The state can go against SBI.
They should have filed a counter.
That will not absolve you.
Lords, my respectful submission is, they must have a cause of action maintainable in law against me.
Too technical, a perception.
Lord, ultimately, cause of action should be either under contract or in tort. There is neither. I have no relationship with the State Bank of India as per accepted banking practice, and they say so in their plaint. They say, I am discharged. State Bank of India is discharged.
And you honored that check and credited in the account of that gentleman too.
Yes, my lords, I did that.
He vanished.
Lords, what happened is, he started withdrawing money. I became suspicious. I blocked his account on my own without any intimation from them. So about 30 lakhs which was remaining, I have paid to State Bank of India.
What prompted the SBI to file a suit at their behest?
At their behest. They informed SBI saying there is forgery of the check.
That's right. So that's the reason once the SBI gets it, then they will get it.
But my respectful submission is, and second, my lords,
we are on in a larger question.
I understand, my lords. In a larger question, certainly, my lords, it's State Bank, so they will pay. But my lords, banking law, in this context, they are acting simply as a banker, so am I. And my lords, the question will then be, who is liable to whom? Because ultimately, some third party, respondent number 2, has played fraud on the state. There are two of us who are intermediaries. In these circumstances, should the state bear the loss? Or should any of the two banks bear the loss? Because all of us are intermediate, both the banks are intermediaries. That question, with utmost respect, my lords, has not been fully discussed. Secondly, my lords, I wrote to the State Bank of India saying, I have found this. You please take an order from an appropriate court and take the money. There is money lying in my bank account, in my customer's account.
How much was lying of?
Lord, about 90 lakh was lying. This gentleman, respondent number 2, had presented 2 such checks. There was another for Corporation Bank. They went to the learned magistrate. They made an application. They took away 60 lakhs.
But what made you suspicion about the whole?
He's about 1 crore comes into his account. 45 lakhs from State Bank, about 60 lakhs from Corporation Bank. Every day he starts withdrawing. Therefore, on my own, without any intimation, I blocked his account to verify whether this is a genuine transaction. Therefore,
So
I
by
could
the
say
time he withdrew how much?
he withdrew about 15 lakhs.
1.5 or
1.5 lakhs. 30 lakhs I have paid to the State Bank. In 2014, decree is issued for me for those 30 lakhs as well, including interest on those 30 lakhs. And now they have filed execution for the entire sum. In 2014, I paid 30 lakhs.
no, once you have paid, the claim is only to the extent of 30 lakhs.
Claim was 45 lakhs.
The 15 also.
15 also. So if at all a decree could have been issued, it could have only been issued for the 15.
You are ready to pay 15?
Oh my lords, I'm contesting it.
See, both. Possibly, once you have refunded that 30 lakhs to them, which was in your account.
Please, my lords.
So interest component has been added.
Lords, on that 30 lakh, I paid them in 2014. So interest stops running then and there. And that I paid without prejudice, because my lords, at that time, the question as to whether this is a fraudulent check was yet to be tested. I also owe an obligation to my customer, because if he comes and says, no, it's not a fraudulent check. Therefore, I said, without prejudice, this is the money lying in my customer's account. As an interim arrangement, I am paying this sum to the State Bank of India, subject to final outcome subject to the decision of the Honorable Court. So I've made that payment. Therefore, if at all, decree could have only been issued for 14 lakhs. And my lords, on banking principles, they have no cause against me.
Which are the judgments relied upon? This 2004-2 SEC?
Please, my lords. Lord, may I request your lordship to kindly see the plaint for a moment as to what is the case that the State Bank put before this honorable court, put before the honorable trial court.
Surprising why SBI has refused the service.
But after they have filed execution, they have refused service. So it is indeed surprising.
They are the contesting party.
They are not.
You sure that refusal? Let's just pass over. Let's see.
Please.
For
the appellant, the senior counsel, Mr. Nayak, is online.
I appear for the appellant's counsel, my lord.
In fact, I'm sorry, earlier I made a submission when the second list was called. My apologies, my lord.
No, it's all.
Yeah. Yes, my lord, this is appellant's appeal. We were directed to take paper publication that has been done in respect of R2 to R4.
Yes.
But I undertake to appear for R2 and R3. Please, lords.
You appear?
Please. R2 and R3.
R2.
R2 and R3.
What about R4?
R1 I appear, already appeared by local.
Yes, it meant to show us that paper publication.
Very short point, my lord, rejection of plaint. I am the plaintiff. A very peculiar order. Plaint has been rejected, partially rejected in respect of R1 to R3. And it has been ordered, my lord, to be returned, plaint to be returned.
Yes. Yes, what do you say?
My lord, the R2 and R3, my lords, are the DCP and the then ACP of the particular jurisdiction in which the R4, my lord, lodges a complaint before the R1. R1, my lord, does not register a complaint at that juncture, saying that there may be a civil issue involved. Thereafter, my lord, the R4 approaches the R3, who is the DCP, who in turn endorses to the ACP to take necessary action in accordance with law. The ACP thereafter, my lord, endorses further to the concerned jurisdictional police station, directing them to take necessary action in accordance with law. As per the said direction, my lord, the jurisdictional police inspector, my lord, R1, feels that there is a case made out and accordingly an FIR has come to be registered. That FIR, my lord, was challenged before this honorable court in a criminal petition, and accordingly this honorable court was pleased to quash the FIR. That FIR, my lord, was not challenged. The order was not challenged before the honorable apex court, and therefore it has attained penalty. Pursuant to that, my lord, the present civil suit was filed by the complainant, alleging that there is malicious prosecution against him. The police, my lord, that's the R2 and R3 in this case, DCP and ACP, have just acted in accordance with law. They've simply said that if there is a case made out, go ahead and register an FIR. That is to, my lord, the R1 in this case. The R1 also, my lord, has undertaken the same thing. The reasoning behind why it was quashed at the first instance was that there was already an investigation undertaken by the BDA concerned police division, and therefore a second complaint on the same cause of action would not be maintainable. That, my lord, averment was not made in the complaint, so filed either before all the three authorities, that is before the inspector or the ACP or the DCP. That fact was not at all brought to notice. As per, my lord, the Honorable Supreme Court judgment in Lalita Kumari, a cognizable offense was made out upon reading the averments of the complaint. Police just registered an FIR. At that juncture, my lord, no investigation was also subsequently conducted. Immediately, my lord, they approached the this honorable court and obtained an order of stay. Therefore, my lord, the learned trial court also found that, my lord, these police officials who are government officials in their capacity could not be prosecuted without obtaining prior sanction. As per the Karnataka Police Act, even under section 170, it was necessary for them to obtain prior permission. Therefore, my lord, the plaint is returned.
We will set up for hearing. Just say this.
Please, the paper books are filed, my lord. We will furnish a copy to my learned friend because he has appeared today.
Just say that the respondents 2 to 4 were directed to be served through publication. Publication has been effected. The paper cutting has been filed. We find there is an appearance for respondent number 2 and 3. There is no appearance for respondent number 4. The service on these Respondent number 4 deemed to have been affected. Full stop. List the appeal for hearing. Let the paper books be filed. Within how much time you will file the paper?
It's already filed, my lord. We'll furnish a copy to my lord.
Let the copies of the same be given to the counsels appearing for 1, 2, and 3. Within 2 weeks, list the appeal for hearing on.
Sir, 17 March.
TCR be requisition. You are filing the paper book now. We will not call for TCR then.
Yes, it is already filed, my lord. It contains everything.
Okay, thank you.
You filed everything in paper.
It contains everything, my lord.
Okay.
Grateful.
14.
Serial number 14.
Highly obliged.
I appear for the respondent in this.
Appellant by me, my lords.
Respondent.
Condonation of delay, 6 days delay in filing the appeal.
We'll condone the delay for 6 days.
Yes, ma'am.
This is an application seeking condonation of 6 days delay in filing the affidavit, in filing the appeal. For the reasons stated in the application, in the affidavit, the delay is condoned. And also the learner counsel for the respondent has no objection. The delay of 6 days in filing the appeal is condoned. First stop, let the paper book be filed within 4 weeks. Additionally, but just say 4 weeks. List the appeal for hearing on
20th February. Serial number 15. 15.
Minutes, I seek for a passover minutes.
Prepare for the respondent back, my lord. In this case that you have also filed, given one copy to that for this calculation chart. They have also given, my lord.
My lords, the director is to file the memo of calculation, including GST and excluding GST, my lords. We have served the copy, my lords. I seek for passover, my lords.
just say pass.
16.
I'll have to file the records, man. I will file it in the.
This is review petition. No.
Commercial.
Commercial appeal.
Yes, we can hear this matter.
Commercial, it was heard, my lord, and I was directed to file the entire records.
What happened? Is it
I
there
have-
with you?
It is available. I'll file it in the.
The learner counsel for the appellant states that the direction to file complete arbitral record shall be complied with during the course of the day.
My lord, I'll file it in 2 days, my lord. I'll get
Within
it.
2 days from today, with a copy to the counsel for
Please.
the response. Be notified.
4-2. 17. Zamir
But
Pasha.
defendant's appeal. So there is a
The
contract between.
service on, you are the respondent for this?
Yes, my lords.
Yes.
Lord, defendant's appeal, my lord, there was a contract, my lord. I was assigned interior work with the Wipro site, my lord, in Bangalore. Lord, for the supply of the materials, I am not, Lord, for the supply of the interior materials. Lord, as against which 10 purchase orders were issued, and Lord, some checks were issued as security purpose of payment. Lord, the plaintiff supplied and complied only with the 2 purchase orders. So that is for 3 lakh odd amount. As against that, my lord, payments were made. Subsequently, my lord, the important point to note here is, my lord, whatever the material enters the Wipro site is acknowledged by the Wipro company itself. Lord, there are these 2 purchase orders which are acknowledged by the Wipro site having received the materials. So far as the other materials were concerned, Lord, were not supplied. Therefore, the purchase orders were not acknowledged. As against those purchase orders, my lord, for which materials were not supplied, he filed a suit for recovery of money. And Lord, the trial court, without considering this crucial aspect, my lord, has decreed this.
Where is your claim? Where is your stand? You are the you are the defendant.
I was the defendant.
Where is the written statement?
Please.
Where is the plain? Where is the written statement? Is it on record?
It is, my lord.
Show us.
But
Their
I
claim with
suppose-
regard to the material,
Please.
where is the averment made by them? And what is your corresponding stand in your written statement?
Lords, may I, my lord, persuade your lordships with this delivery challenge, my lord, before I take your lordships to the written statement?
Now, was it part of the trial court record?
Yes, it were part of the records.
But is it not on record?
My lord, the trial court records are yet to be,
Just say that trial court record be requisition before the next date of hearing. You'll file the paper books also.
my lord, execution is filed. Let them not pursue it until
When
your
is the
lordships decide.
execution?
My lords, execution ordered for 10% and the honorable court also has ordered to deposit the amount and they have deposited.
How much they have deposited?
3,97,000.
They have deposited the complete.
Completely they have deposited. my lords.
So I don't press the
My lords, the
execution.
simple thing is, as my learned friend said, it is the material supply which I have done. So without, and the purchase orders is in the lower court, in the purchase order itself, it is evident, the material is supplied against PDC, post-dated checks. So once the material is supplied, checks are given. As agreed by my learned friend, they have given a part payment. And after that, the another part payment, which is 3,97,000 was not paid. For that reason, I have given the notice. They didn't bother to reply for the notice, nor any communication telling that amount is not paid until unless I filed a suit. So initially they have given PDCs. Now I deposited the PDCs. The half of the amount they paid, 3,50,000, what my learned friend said. So balance amount they said I'll pay. In a good faith, I didn't proceed.
Balance amount, he is disputing it.
That's what my lords.
The material balance, material, he is disputing it.
Right, my lords. What my 2 cents to this is, there was no communication prior to this until unless they come to the court. The lower court has recorded the same, my lords, if I just read for a minute. In point number 22, it says the defendant admittedly has not chosen to reply exhibit P22, that is the legal notice. And there was absolutely no reason for them to reply, stating that plaintiff could encash the cash as checks only on supply of the materials, or it was issued as a security as claimed during DW1's cross-examination. And further, it is proved beyond reasonable doubts in the lower court itself, my lords, considering all the facts, the honorable court has passed the necessary judgments. And also, my lords, in point number 21, page number 34, third line. The suggestions made to PW1 during cross-examination with regard to supply of building materials is contrary to the claim made in Exhibit D7, wherein the defendant categorically claims that the items were not supplied as per the given order. If that was the case, the defendant ought to have rejected the goods and returned the same or called upon the plaintiff to deliver the goods as per the purchase order. Admittedly, they have not chosen to do so. At least, not produced any documents to establish that such a course of action was adopted. My lords, their contention is only the checks were given as a security deposit, but whereas the purchase order doesn't tell that, nor the invoice says that. Invoice says bill to VM Interiors and ship to Wipro, which diligently I have performed my duties, my lords.
Where is the invoice?
Invoice.
These are the delivery challenge. Lord, having the material received by the Wipro, my lord, acknowledging with the seal. So these are the 2 delivery challenges, Lord, we have paid. So far as, Lord, the other challenges, Lord, or invoices they have submitted, Lord, the material was not received
But where is the stand taken?
in the written statement.
That's right.
My lords, invoices are in the exhibit 2 to 9 in the lower court order.
In my lord, in para 9, 10 and 11 of my written statement.
Which page is that?
Page number.
Lord, that will be the part of
Just say
trial
that
court
trial
records.
court record with requisition on the next date of hearing. You file the paper books also.
This, meanwhile, my lord, let them not
Don't
precipitate the
press it.
execution.
My lords?
Don't take an adjournment in the execution.
Yes, my lords.
When is the date?
25th January.
They say that and paper book shall also be filed. 1 week before the next date of hearing through e-filing. Good stuff. Then we have been informed that the date in the execution proceedings initiated by the respondent herein is 25/1/2025. The learner counsel for the respondent shall take an adjournment to a date beyond the date fixed by us in these proceedings. Okay?
Please.
But you file your paper books and this.
My lords, my lords, in the meantime, I may be permitted to withdraw the deposit.
File an application there.
Much obliged.
So that will
See,
virtually,
once,
yes.
surely they will put conditions. It's not that it is just making it. No, we are only saying that once that this thing is concerned, we can, this is a short issue, this doesn't really
Decide
take
it, yes.
time.
Much obliged.
Take it in, let us call for the record and we can decide it.
Much obliged.
I'm grateful.
Next,
3rd of March. Number 18.
For the appellant.
Respondent 1 to 3.
Lord, may I request my lord to kindly come to page 66 where the family tree is produced, be able to,
you're ready for arguments?
please.
Trial court record has come. Every documents are there filed along with the appeal.
Lord, along with the appeal, there are only few documents, not the entire trial court record.
So paper book file it, we'll call for the trial court record also.
Please, madam. But the only difficulty now is now they have filed FDP proceedings. In that proceedings, now it is set down for 16th of. That's the only issue. Otherwise,
It is in the initial stage itself.
Pardon?
It is in the initial stage, in the process stage.
Huh.
No concrete steps have been taken in the. appeal.
commissioner application is filed that is being heard. They want to precipitate that, see to it that it is divided, properties are divided.
Let the proceedings go on, my lord, in that event, my lord, then drawing up a final decree may be stayed for.
At least to that extent, drawing up a final decree stayed also probably, that would satisfy.
Now, you did not file against properties 3 and 4.
No,
No appeal.
no appeal.
No.
No appeal from our side.
Only 1 and 2.
Only one. In fact, it is only against one, item number
In fact,
one.
item number 1, my lord, where there is a will.
Contesting 1 only.
No, interested in one because the will gives me the right to get that property.
Just say that let the trial court record be requisitioned. No, we will not say, you'll file only the paper book.
Please,
Let paper books be filed within how much time?
3 weeks, my lord.
3 weeks with a copy to the learner counsel appearing for the respondents. All are served, no?
Yes, all us.
Good stuff. It is, we have been informed that the respondents have initiated execution, the final decree proceeding.
Please, my lord, FDP 17 of 2023.
Are pending consideration before the court below. Good stuff. If that be so, the court below can continue with the proceeding but shall not pass a final order. Okay? Till the next date of hearing.
Please. Lord, there is one more appeal filed by the defendant number 3, that is RFA number 1564 of 2023. If my lord is hearing on the merits, probably that should also.
Who is the appellant there?
Their appellant is defendant number 3.
Counsel, who is the counsel?
Counsel is not there.
See, if there is a different counsel, he has.
A
to
different
file it.
counsel.
And who appears for you are the counsel there?
No, I am not aware, but I have not filed.
See,
local appeal.
then
The same-
possibly you have to impress
Please,
upon
Please,
them
please,
to.
please. I would.
The counsels are different.
Please. For the respondent, probably the same counsel would be.
We
The
don't
appellant
Not
probably.
yet filed, my lord, no
He
instruction.
doesn't say so.
Please, please.
So we say nothing on
No,
that.
please.
But appropriately, it
Please.
should be decided along with this appeal.
Please.
Both should be decided
Please.
together for you to work out. Just say, give it a date, man.
14/3,
Next.
19, Rajesh Kumar.
Definitely.
7
Yes.
days delay, my lord.
I appear for the respondent. My lords, there's just a small procedural objection on the application for condemnation. My lord, this is an appeal filed under section 13(1)(a) of the Commercial Courts Act, which my lord says that effectively appeals have to be filed within a period of 60 days from the date of the judgment or order. My lords, the limitation period seems to have been calculated from the date of receipt of the judgment. And if taken from the date of the judgment itself, it will come to, my lords, 37 days. So, my lords, the application may have to be
On
refiled
60 days.
beyond 60 days.
What are the reasons given?
My lord, we had appointed a new the partners to the firm, my lord, had appointed a power attorney holder. Therefore, there was some delay, my lord, in.
No, the law is now settled.
Yes, my lord.
Should not be a huge or a large delay.
My lord, it's,
Bona fide, no negligence.
my lord, the judgment was obtained on was passed on 27/5/24.
Hmm.
And thereafter, my lord, we have filed this appeal.
So
And,
when did you
we-
apply?
My lord, we obtained the power attorney on 13/8/24, my lord, and we filed the appeal on 29/8/24.
Yes. Impugned order is dated 27/5.
Yes, my lord.
What is the date of application for certified? When did you get it? When was it ready? And when did you
Please, sir.
receive, when did you take it?
24/9/24, my lord, the last page.
See, we want these dates. Ultimately, we have to work out. Let's see what is the application says.
My lord, the application is silent on the date when the order was obtained. The order was passed, my lord.
But 7 days, even otherwise, 7 days.
My lords, my submission is it's not 7 days because
More than
they've
that.
taken they have taken the date of 7 days because they've calculated from the date of receipt of the order.
Okay.
Whereas as per the provision, they have to take it from the date of judgment.
My lord,
If it's beyond, my lords, so in our calculation, it'll be 37 days. My lords, they have to then justify those 37 days of delay in the application.
my lord is pleased to see ink page 112.
Hmm.
Copy was applied on 29/5.
Hmm.
I appeared on 28/6.
Yes.
Yes, lord. Copy was
applied
ready on.
Copy was applied on.
Copy was applied immediately, my lord, 29/5. Order was passed on 27/5. As per this endorsement, my lord, I applied on 29/5.
What is the date of filing?
29/8, my lord. 29/8.
Okay.
Is calculated by the office. 3, 4. Lord, normally we would leave the date.
Just show it to the copy. Just show. You just see this by the registry. Show it to him. Not him, here.
Respondent.
Now see those dates, that's the date of the judgment and date of filing is August. Total dates comes to 94.
Yes,
They have subtracted 60 days, that's the usual limitation.
please.
34, otherwise beyond 10. Copying branch, it was with the copying branch for 27 days.
Please. This,
So
my lords,
how they have worked out?
yes, my lords. My lords, our submission was that in respect of, so in the application itself, they have mentioned a delay of 7 days. So this was, as per the provision, my lords, the date of calculation has to start from the date of the judgment. Now, my lords, otherwise the administrative reasons are on record, and my lords, they seem to have mentioned those. So, my lords, then we'll, if it's the other reasons are, my lords, justifiable, there is no,
We'll delay that.
please, my
The
lords.
copying branch, it was 27 days out of 94.
Yes,
34, the remaining 34, because 60-day limitation. Just say this is an application seeking condonation of 7 days delay in filing the appeal for the reasons stated in the affidavit in support of the application. The delay of 7 days is condoned. Application disposed of. List the appeal for hearing on. The otherwise record is there, complete record.
My lord, we'll file a paper book, my lord.
You file the paper book.
We will file, my lord.
Let paper book be filed within how much time?
6 weeks' time.
6 weeks. Re-notify with a copy to the learned counsel for the respondents. Re-notify on.
10th March.
You appear for the, both the respondents.
Please, my
And two.
lords.
Next.
No, but the appeal is not yet admitted now.
Complaint.
My lords, it could be posted for admission on that date. Once all
No,
records.
They say admit, then paper books. Yes. Okay. Admit paper books, place for hearing.
Grateful.
Serial number 20. further reading.
I prefer respondent. Who's there for?
Lord, I appear for the appellant in this matter.
Yes, ma'am.
Yeah. Yes. Lord, I'm ready, my lord. If your lordship pass over, I will just make my submissions today. I mean, in fact, earlier I had made my submissions and respondent had to.
You're ready, we'll just pass over. Pass over.
Twenty-one.
Yes, Mr. Chinnappa. You're ready? Yes. Just, you have those judgments, anything which you are relying upon?
Yes, ma'am.
Tell us one thing, was it an application under section 16 which was?
There was no application under 16.
Why that impression, why that is being said in the impugned order? Which is this section 16 which is being referred to?
The petition. There is, if my lord comes to page 71. Let me see page 54 first. It proceeds that it is an award.
What is this paragraph 15, the last 3 lines, the reference is made. What was the occasion to make a reference to section 16?
Para 15.
Para 15, page, just say 43.
That is the judgment of the trial court. No?
That's right. He is laying a foundation on whether will he have the jurisdiction or not by referring to 16.
16, that's all.
Ah.
But that's not the arbitrator's award.
But nothing from both the sides.
No, neither the side. And I would respectfully submit, Lord, that it is only a respondent who can raise an objection on jurisdiction. Under section 16, it is only the respondent who can raise an objection to jurisdiction, not the claimant. Claimant can't come to arbitration and then say, you have no jurisdiction.
No, okay, this he has taken on his own.
Yes.
We take it that way. Yes.
Yes, ma'am.
Okay.
But then most interestingly, Lord, in the award at page 53, it is not as if it proceeds as if it is an order under section 16. It is an award. And therefore, my lord, challenge under 34. And proceeds as an award itself. And finally says, I have no jurisdiction, which I would respectfully submit could not have been done.
Yes, show us the arbitration translation. What would be the, so effectively he exercised jurisdiction under 16.
I don't know, my lord.
No, very well. If the orders to say that I don't have jurisdiction would be an akin to an order passed under section 16?
Yes, it could be akin. It would be akin.
Akin. What would be the remedy against 16?
Against 16, Lord, is an appeal under 37.
So, 37.
37 appeal.
So not 34.
Not 34. If it were an order under 16, it would be an appeal under 37. There's no difficulty. But if it's an award, and in an award, I finally say, because interestingly, my lord, the learned arbitrator says, if your lordship sees the paragraph, he says extensive evidence has been led Please see page 62, my lord. Running page 62, internal page 9. Extensive oral and documentary evidence has been led on behalf of both sides in support of their respective cases. Extensive arguments have been heard. It was only in course of arguments that it was unexpectedly noticed that the Memorandum of Family Settlement contains the above said arbitration clause 5, thought dated 21st June 2007, could not have come into existence on that day, and is clearly a document that came into existence on any day.
Still it was not put to the parties.
Not put to the parties.
He says during the course of argument.
It was noticed.
It was noticed. It was not put to the counsels or.
It was not, no, I won't say that. In all fairness to the learned arbitrator, they raised the point. In the reply submissions, after I had completed my arguments,
Oh, they raised the point.
they argued it saying, but the date is different. That's all. I mean, I then responded to it said, and pointed out that the registration happened on the 31st. Therefore, these dates are of no consequence. And then the matter was posted for award. It was nowhere said that I'm now going to hear on jurisdiction. That's where I'm saying is the difference. The difference lies in the fact that first, my lord, an arbitrator cannot take upon himself the obligation to determine jurisdiction unless it is raised by one of the parties, because 16 requires that to be done. And second, my lord, even if I raise a claim completely outside the arbitration clause and the other party does not object to it, then the arbitrator is required to proceed with the award. Then it becomes part of his jurisdiction, even if it is not part of the agreement. And therefore, it is not a scenario, my lord, where the arbitrator can suo motu exercise jurisdiction to say that I have no jurisdiction. Basically say I'll exercise jurisdiction in a matter where no one has raised the issue, but I'll raise the issue and say that I have no jurisdiction. But I would only say, in any event, an arbitration clause stands independent of the main contract. And standing independent of the main contract, unless you come to a conclusion that the main agreement itself is actuated by fraud and therefore is an invalid document, then of course the arbitration clause also will go. Because it is part of the main agreement. Without the main agreement, the arbitration clause cannot survive. To that extent, you can look at whether the main agreement is hit by fraud. But that is not the finding he makes. He says neither party had any criminal intent to defraud each other. But
he doesn't say anything on that main contract or the settlement.
On the settlement, nothing.
He doesn't say so actuated by fraud or nothing of that. Short of saying that.
He says the only thing in the honorable arbitrator's mind was the fact that the dates are different. And nothing more. But then it really misses, in my respectful submission, the point that the parties on a subsequent date went to the office of the sub-registrar, presented the document for registration, and therefore that could have only been the date which was relevant for the purpose of this case. Because there was nothing else. And therefore, my lord, in my humble submission, the finding on jurisdiction could have never been, in any event, it would run contrary, even if it's a wrong order, my lord, of the Supreme Court. A wrong order also is binding between the parties. It can't be that any other authority can subsequently alter a wrong order of the Supreme Court.
So the argument from his side is, he is a creature of a reference.
Yes.
The arbitrator. He says, but nothing precluded, maybe based on the orders which were passed to the learned arbitrator to look into every aspect of it, even including is a sort of a prayer under section 16 about the arbitrability that can be done. That's what he is trying to.
Yes, he's saying that, no? But please see section 16. How section 16 is triggered.
Now, what will now?
The consequence, no?
Yes,
the
what
consequence will be, lordships can't remand it back to the arbitrator, nor can your lordships appoint a new arbitrator unless the parties consent. And that seems to be not fairly settled. Now, if a new arbitrator is to be appointed, there are two scenarios which can emerge. The one is to say, because there's only a question of jurisdiction that the arbitrator answered, therefore, whoever next is appointed will start from that stage and continue and answer because evidence is already on record.
But how will that new be appointed?
Only by consent. It can only be by consent. If
then you will invoke the arbitration under the settlement. That's what, if ultimately the court comes to a conclusion, then the normal process, whatever has been laid down.
Correct. The second is, of course, your lordship set aside the award if your lordships are convinced that this award can't stand. If it is set aside, then parties are relegated back to starting the arbitration again. You have to restart the arbitration process because that is the mandate of this honorable court and the High Court. And the suit will come to a stall.
the suit.
Lord, my respectful submission is, my lord, during the course of the award, my lord, the arbitrator, my lord, also considers this question. Well, there is a agreement that has been put forward, which is antedated clearly. Now, having regard to the date, can I still continue with the arbitration as it has been mandated? This is the question that the arbitrator raises. And then, my lord, he looks into the evidence and then comes to the conclusion that making a reference to 21-6 at no point of time could be called as an accidental one, and rather it is an intentional date that has been fixed by the parties. It is on this premise, my lord, he proceeds further and says.
But tell me, what is the effect of the orders passed appointing an arbitrator which went till Supreme Court?
My lord, two things, my lord, my respectful submission. My lord, Section 8 order may kindly be seen, my lord, by the one that has been passed by this honorable court. My lord, along with the synopsis, my lord, the memo that has been filed by the appellants, my lord, on 3/12/2024. The said order, my lord, has been produced. I would respectfully pray, my lord, to kindly take the order of this honorable court, my lord, which has been produced at page number 62 of this said memo.
Order of 8 is much before 11 was passed.
Absolutely. Absolutely. Now, there are certain observations, my
And
lord,
in
which
11, no such plea was advanced on, the settlement having been obtained by fraud because of this, because of.
my lord, the precarious situation in which I was placed is, my lord, here, my lord, I have suffered an order under Section 8. The appellant, my lord, would not take any step, my lord, for the appointment of an arbitrator. I'm neither here nor there. My lord, it is at that juncture, my lord, I file a Section 11. It is resisted by the appellant saying that there is no arbitral dispute. And it is they who took the matter to the Honorable Apex Court, and where the Honorable Apex Court said that the contentions are kept open. Now, I must, my lord, have some forum, my lord, where I can get the resolution of my dispute. Now, throughout, my lord, I had been hoodwinked in one or the other way, my lord, where objection was taken at every stage. Now, this is how, my lord, the matter transferred. That's where, my lord, Section 8 order, my lord, I'll bring to my lord's notice. It would be of great relevance. My lord, page number 62, my lord, is where it commences.
You are only urging to say that all contentions were left open?
Please, absolutely.
Very well. Now, which are the judgments, Mr. Chinmay?
Yes, no, the judgments. Of course, the 7-judge bench judgment, not on the issue of. This has been summarized in chloro controls.
This is Cox and Kings.
No, chloro controls is summarized the 7th because after 2015 and 2019, I'm sorry, the amendment brought about a change. The change was that it's only a prima facie view that the court expresses and leave it. But in 2015, when the amendment happened and before that, when the 7-judge bench examined the question was what happens to a decision that is there? Is it administrative, judicial, or judicial again? Which is how the 3-5 came to 7. Of course, 3 and 5 said it's administrative, 7 said it's judicial.
Yes.
And then they said any judgment of this honorable, because at that point in time, your lordships recollect, after the order was passed by the single judge appointing an arbitrator, we would file a writ petition challenging that order because it was an administrative order.
That's right.
And therefore, writ petition, writ appeal, and then SLP to Supreme Court would again delay the entire process. Can I only request, my lord, to come to para 121, my lord? This summarizes it. The 7-judge, this is of course a 3-judge bench judgment.
No, what is the point?
The point is it's judicial, and once it is answered, the arbitrator can't go into it.
Oh, that's fine. That's the submission.
That's the submission.
Oh.
May I just point out, I have some company.
I'll come back, we'll come back. So judicial order, it cannot be gone beyond. But the only thing he accept, how would you answer that 8? The order in 8 by the Supreme Court leaving all pleas available.
No, 8 did not leave open those questions. The writ petition order said you can make an application under Section 16. It did not leave open those contentions. What it said, my lord, is, and I'll read that portion to your lordship.
Let's see which page is that.
Page 71, which my learned friend was reading.
Yes.
Last paragraph. Para 13, I'm sure. May I just read para 13 for completeness? In the instant case, the facts and circumstances are totally different. Petitioners are denying the existence of the memorandum of family settlement, whereunder a clause pertaining to reference to arbitration of all disputes is made. Whether such an agreement is in existence or whether it is validly executed, tainted by fraud or misrepresentation, can also be agitated before the arbitrator. The mandate of Section 8 is very clear. Whenever the parties have agreed to refer the dispute to arbitration, court is required to refer the same to arbitration, as it does not have the jurisdiction to entertain the same in the face of such arbitration clause. Therefore, my lord, this first finding is the finality to the existence of an arbitration clause is here. Jurisdiction is always mandated on the arbitration clause, not on the main contract. Therefore, you must show that there is no arbitration clause for an arbitrator not to have jurisdiction. But the arbitrator will have jurisdiction to decide two things. One, whether there is an arbitration clause, and the second as to whether the main contract itself is violated by fraud. Which is what possibly correctly they did as well. They said arbitration clauses become final. The appointment of arbitrator is final. The question as to whether this document itself is actuated by fraud can be examined by the arbitrator, which is why a prayer also to set aside this document before the arbitrator was made by them, which was not answered by the arbitrator. Then note the next paragraph. Reliance placed with the petitioners. Reliance placed with the petitioners on the judgment of the apex court in this regard, in the case of Hindustan Petroleum, is apposite. Observations made in paragraphs 14, 15, and 16 of the judgment makes the position very clear. Apex court, by referring to section 8 and 16 of the Arbitration Act, has clearly held that objection regarding the applicability of the arbitration clause will have to be raised before the arbitrary tribunal. Of course, one can argue on this is also an arbitrary order, with an arbitration tribunal concern. Apex court has further held that in the said decision, section 16 empowers the arbitrary tribunal again to rule on its jurisdiction, including on any objections with respect to the existence or validity of the arbitration agreement. Now, my lord, I only want to point out that your lordships will remember in the claim statement, they said the finding with respect to the appointment of the arbitrator has come to a finality. Therefore, they accepted the fact that there cannot be a ruling on the existence of the arbitration agreement. The only issue is, notwithstanding the existence of the arbitration agreement, a party is entitled to still say that the main document is hit by fraud.
That the arbitrator could have gone into.
That the arbitrator could have gone into. And the arbitrator could have then answered all these questions. Because their main issue, my lord, in the suit was whether the gift deed and the partition deed were hit by fraud, because that is the real division of properties. And the memorandum of family settlement was only a means to achieve that objective, because it does not do anything else except record that parties have agreed to those two documents. It's come to a settlement, and it has come and put a complete closure to all disputes between the parties. Now, if your ultimate attack was those two documents, and incidentally you also raised this, of course the arbitrator can answer all three questions. But the arbitrator cannot walk away from saying, I will not answer it because I believe I have no jurisdiction, because that would violate the judgment of the Supreme Court. And therefore, my lord, though this finding existed, in the claim statement, they made it absolutely clear that they have no challenge to the jurisdiction of the arbitrator by saying that the appointment of arbitrator has become final. And that's the statement specifically made in pleadings. The second point, Lord, I wanted to make to your lordship was, and your lordship pointed out to me yesterday, that they've raised some plea in the rejoinder to my objection statement. A rejoinder, my lord, in my respectful submission, is not pleading for the purposes of determining the question as to whether an arbitration or whether a contract is invalid or not. Because as your lordships recollect, in the claim statement, there's no statement, not one statement. There's one judgment, my lord, I wanted to place before your lordships of his lordship Justice Lahoti, as he then was. On the question of a replication.
Yes.
May I only request, my lord, to look at para 8 and 9. Order 6 of CPC deals with pleadings generally. Pleading shall mean plain to written statement. Pleadings are supposed to set out material facts. They are to be verified. Order 7 deals with the plaint. Order 8 deals with written statement. Rule 3 of Order 8 enjoins the defendant to deny specifically such are the averments of the plaint which he does not admit. An averment made in the plaint, if not specifically denied or only evasively denied in the written statement, would be deemed to have been admitted. Rule 2 enjoins the defendant to specifically plead new facts. Order 8, Rule 9 provides that no pleading subsequent to the written statement of a defendant other than by way of defense or set up of counterclaim shall be presented except by leave of the court and upon such terms as the court thinks fit. Court may at any time require a written statement or additional written statement from any of the parties and fix a time for presenting. Pleadings by way of rejoinder or replication not be statutorily found. It is a basic concept of pleadings. The defendant has to deny specifically every amendment made in the plaint if he chooses to dispute. As already stated, a non-specific or evasive denial in written statement must be taken as an admission of plain facts. The failure to file written statement, this is on the written statement, my lord. Then, Lord, para 15. I'm sorry, on the pleadings, my lord, on. Para 19, I'm sorry, that is a relevant paragraph. Para 19, my lord. A distinction between a plea requiring amendment of the plaint and a plea sought to be introduced by replication shall have to be kept in view. A plea which essentially constitutes the foundation of a claim made by the plaintiff, or which is essentially a part of plaintiff's cause of action, cannot be introduced through a replication. As already stated, replication is always a defensive pleading in nature. It is by way of confession and avoidance of explanation of a plea raised in the defense. It will be useful to quote from Salisbury's. So for the first time, you can't raise a pleading of fraud in a replication or rejoinder. And Lord, in terms of what, which is what your Lordship wanted to hear today, on what ultimately can be done, if the award cannot be upheld on the face of it, Lord, then the award must go. The consequences, Lord, will follow. One is, of course, the suit will have to go because it is based on the premise that there is no jurisdiction. Therefore, the suit cannot continue. The consequence will be in terms of Section 43 of the Arbitration Conciliation Act. This time period is excluded for the purposes of limitation, and the parties will restart the arbitration process. Or if my learned friend is agreeable, my lord, this can be done in a very simple way. The pleadings are there, the evidence is on record. An arbitrator can be appointed by both parties agreeing. And straight away, my lord, we can start from this point. Because ultimately, if he's right in his contention that the document is gone by fraud, then the new arbitrator will proceed from that stage and continue.
Is there any issue on that count?
I beg your pardon, my lord?
Is there any issue before the arbitrator? Was there any issue with regard to this settlement?
Yes, that also was one of the, because that is a prayer made.
No, let's see that. Is there any issue?
Yes.
Framed by the learned arbitrator with regard to even the settlement was obtained by fraud?
Not all three documents, they said, their prayer itself was that all three documents are hit by fraud.
Okay.
Gift deed, partition deed, and the memorandum of family settlement. The prayer itself was that. Therefore, he could have answered all those things. And he could have possibly said that the memorandum of family settlement is hit by fraud.
Could have answered.
The arbitrator could have answered it.
That's the prayer.
That's the prayer. In the pleading itself, if you lordship look at the...
Shows that.
Yes. The claim statement, Lord, at page, amended claim statement, at page number 24 of that second memo.
Just shows that.
4th January. Then 4th January.
Adu 4th January. 4th January. Prayer AA. 24, the amended claim statement, where this prayer was only added. That's the only thing which was added.
What was the foundational facts with regard to memorandum of family settlement?
Nothing. Not one word. In the entire pleading which is before your lordship.
And in the claim also.
Nothing. No pleading with respect to anything except for the statements with respect to that gift deed and PC page, para 6. I'm sorry, para 3. They say we didn't know what we were signing. We found out it was a gift deed and a partition deed. That's all.
But what does it say? What do they say with regard to this memorandum of settlement?
As a
do
matter
they
of fact,
allege?
not one word.
But the prayer is there.
Prayer is there, not one word, which is what our case also, my lord, as a defendant in a proceeding, I pointed out, you must plead fraud very clearly and say when it happened, how it happened, not one word. How in the absence of pleadings and evidence. Evidence also, my lord, is only a reflection of what is there in the pleadings. How in the absence of pleadings and evidence, the arbitrator could have made a finding which is in between fraud and high levels of integrity, and say neither party had any intention to defraud the other. That's the finding of the arbitrator. But then how does a document go away without it being hit by one of the provisions of sections 12 onwards of the Contract Act?
But tell us one thing.
Please, ma'am.
There is a prayer for family settlement be treated as null and void.
Yes, madam, please.
Then you proceed on the premise, the arbitrator can decide that.
My lord, now, the reason that I could have done is, because, my lord, there are two more paragraphs, my lord, which had to be read, my lord, in the Section 8 order, where this honorable court specifically said, including that document is something that you can canvass before the arbitrator. Because on this aspect, having regard to Section 16, he can
But there is
decide
a
it.
prayer with regard to family settlement being null and
Absolutely.
void.
Please, that is the premise on which, my lord, I opposed the Section 8 application. Since that question, my lord, had been kept open. My lord, I had to avoid it, my lord.
Right.
Yes,
But
please.
surely you would not, in that eventuality,
Please, ma'am.
your claim, so no, what we want to convey is,
Please, madam.
when you have also sought a prayer that memorandum of settlement should be also declared as null and void.
Please, madam.
That's right, activated by fraud, whatever you may call it.
Please, madam.
But the arbitrator has been appointed.
Yes, madam. Please.
Before the same arbitrator, you have made this prayer.
Absolutely.
Was he not within his rights to go into this aspect also?
My lord, my respectful submission is, my lord, what he could have, of course, said much more than what he has said is a different thing. But now, my lord, he understands from the perusal of the said agreement and the evidence that has been there, that it is an unfaithful document.
Right.
Now,
What being argued by him is.
Please, I quite see that, my lord. Now, he could have very well said that it is
Mr. Chinnappa
vitiated by.
drawing a distinction.
Please.
His appointment is justified. He is within his rights to go even on the memorandum of settlement. But he could not have said that memorandum settlement is actuated void. I don't have jurisdiction, or I could not have arbitrated. That he could not have said. That's the distinction.
No, no, I quite see that, my lord. Now, when I go before the arbitrator and, my lord, I take up various contentions, including, my lord, challenging of the document under which the clause, my lord, is incorporated. But I take various contentions. Now, what the arbitrator now says is, now, look, I cannot go into it because you have come up with a particular document for the arbitration, which itself cannot be gone into having regard to the antedating that has been done. This is what the arbitrator feels. And now this is how, my lord, he would rule on his own jurisdiction, having regard to the fact that that was one of the aspects that he could have looked into
Now, suppose
in the
for a
order
moment-
at annex.
Suppose for a moment, he was to agree with you.
Yes, ma'am.
On a different ground, not on this antedating, and would have said memorandum of settlement is actuated by fraud, null and void.
Please.
Whether he could have still justified his award? He could not have.
Yes, ma'am.
He didn't have the jurisdiction then.
That is where, my lord, he, my lord, fell short of what he could have otherwise done. He felt that proceeding further on the basis of this document in the circumstances would not be a proper course.
Well, so, but otherwise, if this minus this point of dating,
Yes,
he
ma'am.
could have still held or hold that memorandum of settlement was actuated by fraud.
Well,
He could have done it. Then what will happen to his appointment then? Getting the point?
Yes, my lord, I quite see that.
Okay.
I quite see that. Now, the aspect of a fraud, my lord, is being pleaded. On a threshold, my lord, he comes to the conclusion that I cannot go into it having regard to this fact. Now, date becomes crucial for him to come to that conclusion. All other aspects, my lord, he keeps it open.
By that date, difference in the date,
Yes, ma'am.
he's still at least reading between the lines, or it was his view
Please, ma'am.
that possibly this memorandum of settlement was also.
Vitiated. The reason is, my lord, on the very same day, two registered documents, my lord, would come into existence.
Okay.
One is a partition deed and another is a gift deed. Now, that can come into existence only on 21/6. Now, this document, though it has been purchased by the appellant on 22/6, bears reference to that document. So it could never have been, my lord, the intention of the parties to, or an accidentally, my lord, parties have taken that it must be given a date as 21/6. Because they also said certain amounts were paid on 21/6 itself.
What do you say on his submission that subsequently after this, even after 22nd 6,
Please, man.
the document got registered?
My lord, the,
Any infirmity
please, man.
which has crept in has been now met with, cleared by way of a registration.
My lord, in my respectful submission, my lord, the registration, my lord, will not take away the effect of the document because all registration, my lord, will relate back to the date on which the document has been executed.
Okay.
That is, my lord, the purport of section 47 of the Registration Act. Now, if at all, even the registration takes subsequently, the date of the document is 21/6 itself. And it cannot be so because, my lord, the stamp papers were also not available on that day. Now, this makes, my lord, the arbitrator to think, and he says whether I can wink at this and still proceed. And then he says, no, it can't be done because having regard to the fact that so many transactions have taken place on 21/6, then to have a document and then to enter upon the reference is something that is contrary to section 23 of the contract.
Will this finding of the learned arbiter or conclusion of the learned arbiter has any bearing on the partition and the gift deed?
My lord, yes. Now what happens is, my lord, the partition deed and, my lord, the gift deed that is alleged to have been executed, my lord, ultimately stems out of this family arrangement. Now this gives a larger framework, my lord, under which these two documents would eventually sprout off. Now, if the ultimately, my lord, the memorandum of family settlement itself could not be a faithful document, then, my lord, the fate of the consequential document is also something, my lord, that a shadow, my lord, would be cast upon.
Now, which are the other judgments, Mr. Chinnappa? You have any other judgments on registration, everything you are showing?
Registration.
We don't have. Now tell us one thing. Now you want to continue with the suit, otherwise you have
What has happened
instructions.
is, my lord, the reason is this. My lord, now, please see, my lord, the issues that have been cast upon, everything, my lord, have been put upon me at the instance of the appellants in the suit. Now, I have been, my lord, called upon. I just request, my lord, to kindly take the memo that I have filed on 3rd of December 2024.
Hmm.
My lord, page number 38, my lord, of the said memo, which I have marked as document number 5.
Hmm.
This is the issue that had been framed after, my lord, the revival of the suit and the pleadings being completed. Page number 38, my lord, of the memo that I have filed on 3rd of December 2024.
Page number 40.
Pardon?
Page number 40.
My lord, page number 38 is the issues that had been initially framed. And thereafter, my lord, it has been recasted. Now, initially, my lord, the issues at page number 38 is, read this, my lord, whether the plaintiffs prove that they are in joint possession, that is on me. Whether the defendant proves that there is a severance of status in the suit scheduled properties by the virtue of the partition deed, that was on them. Whether the defendant further proves that they became owners in possession of the suit schedule B property by virtue of the gift deed, this was on them. And hence, my lord, they filed an application saying that these issues will have to be recasted. And that is how, my lord, the recasted issues, my lord, would come into, would be framed. 46 and 47, my lord, of the very same compilation. Two additional issues, my lord, are now being framed. And also, my lord, at page number 47, please see the recasted issue number 1. Whether the plaintiffs prove that the registered partition deed and gift deed dated 21/6/2007 are vitiated by fraud and misrepresentation, as alleged in the plaint. Whether the suit of the plaintiffs is in the present form is maintainable or not. Now, this is at the instance of the appellant. Now, the question is, my lord, now, having come forward so much, now all that has to be done is, my lord, the evidence will have to be led and we can conclude the suit. Now, we are now, my lord, faced with a situation where, my lord, everything will have to start afresh. If at all, my lord, this award is set aside. My lord, that is in interest of none. My lord, having regard to the fact that we have subjected ourselves to the jurisdiction of the competent civil court, we are agitating the matter there. My lord, the public policy also would require, my lord, that ultimately the quietus could be given at the hands of the competent civil court.
How would you answer now what Mr. Chinnappa has argued? It would be from the stage when the arbitrator had left.
My lord, of course, made some research on that. My lord, it doesn't, my lord, at any point say that he can start, the fresh arbitrator can start from where the earlier arbitrator had stopped. There is absolutely no material, my lord, that is available in that regard. On the other hand, my lord, there are citations which says that once the award stands quashed or set aside, then the parties would be put into the position that they were there at the pre-litigation stage. This is what, my lord, these observations have been made.
That
So,
I agree with my lord that I only said by agreement of both parties, since my learned friend is saying that public policy demands that we must have quietus to litigation as fast as possible. Therefore, I'm saying the ideal scenario is you've led your case, I have led my case. Evidence is on record. We've placed every material that we possibly have. All affidavits are on record, all cross-examination has been done. By agreement, parties can always accept that we'll have the material and restart the arbitration from that process. Therefore, that will save time. It will only be arguments now.
That in other words, what he says is maybe in law that may be a position, but if you both of you agree, then it can start from the stage when where the arbitrator has left. That's what he wants.
And I'm willing, my lord, any arbitrator my learned friend nominates, I'm willing to accept and start from there.
You want to take instructions on this, on what he said, and maybe you have anything suggestion, you can talk to Mr. Chinnappa or the briefing council. Put it, we can have it tomorrow, not an issue.
very well, please.
Okay?
Please,
And very well, we'll have it tomorrow.
please, very well.
Just say this, we have further heard Mr. Chinnappa and the learned counsel for the response. To enable, or shall we say that to take instruction or just re-notify tomorrow?
Let it be re-notified tomorrow, my lord. I'll come
Re-notified.
with the instructions.
Very well, got it. A day after, that will be day after.
15th.
Yes. Yes, my lord. This we had heard, Mr. Nath.
Yes, my lord. In this, my lord, on the last occasion, directed me to furnish documents in respect of commercial courts, my lord. I have placed before the court, my lord.
What do you see? Just show the last order.
What did you say? What is our submission?
My lord, commercial court documents are produced, my lord.
Commercial
Court documents
Court
are produced.
documents.
Yes, my lord. All the documents are produced, my lord. On the last occasion, whether I have taken a contention before the commercial court or not, which was asked, my lord, has such a furnished entire documents, my lord.
Where is that? Just show us. The file.
At 26/11/24, I have furnished.
Which page?
On 26/11, I have produced, my lord, entire documents.
Yes.
Yes, my lord. Appeal memo, my lord. I have taken entire contentions, my lord, which was not answered, my lord.
Which page?
Grounds, my lord. At page number 14, my lord. Para 34, my lord. The impugn award is passed ignoring the vital evidence and finding award is not based on the evidence and further same is based on some irrelevant and arbitrator has not applied his mind and attending the facts and circumstances of the case, taking a decision in the award and further arbitrator failed to draw the interference with. Ought to have been drawn on the face of it and the facts are proved by the arbitration in the award.
Which paragraph you are reading?
34, my lord. On page number 50, my lord, page number 20, my lord. I've taken in respect of that letter exhibit D2. Para 51, my lord. It starts from 50, my lord.
May I read, my lord? The Honorable Arbitrator, without properly appreciating the contents of the complaint dated 23/5/2019, filed before BMRDA, arbitrarily without application of judicial mind, come to the wrong conclusion that because of the said aforesaid complaint, complainant cannot insist upon the implementation of the project any further after 23/5/2019, and they are not entitled for compensation from the said date on 23/5/2009. Hence, the said finding is liable to be set aside. The contentions of the complaint in next paragraph, Miller. Complaint against the release of 30% sites of sale in residential layout formed in survey number so and so, so and so by the developer so and so, so and so. May I continue with the reading, man? I am the absolute owner of the properties bearing survey number 95, 96, 97, so and so, measuring 9 acres, 22 guntas of land, situated at so and so, so and so. Pleased to inform that I have entered into a joint development agreement with the developer, so and so, so and so, for development and formation of residential layout in the aforementioned properties under the document bearing number so and so, so and so, and a rectification deed date of joint development agreement dated Basavangudi, Bangalore on 19/11/15. I have also executed power of attorney on the same day, 19/5/2014. Please be informed that the aforesaid developer has secured a sanction plan wide LOA number 44 of 14/15 dated 6/2/2016, issued by the Office of the Anekal Town Planning Authority for the formation of residential layout in the aforesaid properties. And further, on the same day, first stage of 40% sites were released for sale. Please note that aforesaid plan sanction is issued subject to conditions stipulated in the sanction order, work order, bearing number so and so, so and so, as per condition number 3, aforesaid approval, the second state of release 30% sites for sale shall be made only after the completion of civic works, that is roads, CD works, side drains, underground drains, water supply works, etc. Please to note that aforesaid developer till date has not completed any of the aforesaid civil works, that is roads, CD works, side drains, underground drains, water supply works, etc. And Anekal Town Planning Authority, without properly inspecting the residential layout and verifying the facts, have released second stage of 30% sites of the sale. And same is in violation of condition 3 of the aforesaid approval. Please to note that all the above illegal activities of the aforesaid developer as again as per the terms of work order and plan sanction dated 6/2/2016. I am therefore constrained to address your good self to seek indulgence in your good self to immediately take action against faulting developer and also officials of Anekal Town Planning Authority to cancel the order 30% site of sale in a residential layout formed in survey number so and so, so and so, till the civil works are completed as per terms of the approval and set right the irregularities, as also take action against the aforesaid developer. I request kindly take immediate action remedy in a wrongdoing of earliest order. That's what I have told me. The plain reading of the aforesaid document clearly demonstrates that issuance of Exhibit D2 of the claimant is to bring the knowledge of the authorities regarding non-compliance of condition number 3 of the sanction plan, Exhibit P12, that is release the second stage of 30% sites for sale without completing the civil works, that is roads, CD works, side drains, underground drain, water supply works, etc., and to cancel the till the civil works are completed as per terms of the approval, but the same is not stopped by the developer work in the layout. Honorable Arbitrator has failed to take note the fact that layout plan sanctioned and Exhibit P12 is issued subject to conditions stipulated in sanction letter work order Exhibit P13. The condition number 3 of the aforesaid approval clearly states that second stage of release 30% sites for sales shall be made only after completion of civil works. Okay.
Ma'am, just see, show the service report, ma'am, on. Yes. Okay, we reserve it.
Yes, ma'am.
Okay,
Yes, ma'am. My lord, I'll
you do
file.
one thing,
Yes, ma'am.
this, you have filed it,
Yes,
these
ma'am.
documents,
Yes, ma'am.
you'll do the e-filing also.
Yes, my lord, I'll do it, ma'am.
Huh?
Yes, my lord, I'll do it.
The. What is this memo at on 11/11/23 which you have filed?
My lord, that's in respect of proceedings which I have filed the documents before
No,
arbitrator.
have you, this is on record
This, my lord, this is also. on.
of our record also?
Yes, my lord.
Let me just check up this.
Yes, my lord. That's also there, my lord. That's before the arbitrator. And one more is of commercial court, my lord. Appeal filed before the.
No,
commercial-
these records were part of the arbitral record.
Yes, my lord.
Why do you say 11/11/23? It should be 20.
11/11/23 is in respect of arbitrator proceedings, my lord, arbitration proceedings. And thereafter I have filed
No,
one
Mr.
more in respect of commercial court, my lord, where I have filed an appeal, my lord, under 34.
It should be 11/11/24, not 23.
24, my lord, sorry, my lord, 23, typographical. error.
Just say that, learned counsel, these are part of the arbitral record.
Yes, my lord.
The learned counsel for the appellant has filed the arbitral record on 11/11/24 and 26/11/24.
Yes, my lord.
Stop.
26/11 is the commercial court documents, my lord.
Arbitral record oblique the record of the court below on 11/11/24 and 26/11/24, he shall also file the same through e-filing.
Yes, my lord.
Okay. In 1 week, we have heard the, despite service, there is no appearance for respondent number 1. We have heard the learned counsel for the appellant, orders reserved.
My lord, I'll file citations, my lord.
Just give it, ma'am, just take it.
Take it to.
Just said today also he has filed the list of citations in support of his stand. The same shall also be filed through e-filing. Next.
Three.
As per compensation, when the agreed terms are there, my lord, that has to be given, my lord.
Yeah, we have heard you, no?
Yes, my lord.
You can taken it?
Yes.
Yes, next.
I'll
Appearing for the
I'll
appellant.
e-file it, my lord. I'll e-file it.
E-filing also.
Yes, my lord.
Do the e-filings.
Yes, my lord.
Yes.
Lordship, for the respondent, if I may pray for a Passover in the matter.
The Passover may not be possible today. There is matter which we have fixed in 3 o'clock. That's possibly. We will Passover, we'll see it.
Please,
Passover.
please.
Good.
24.
That I appear for the appellant in this matter. The respondent approached the arbitrator after lapse of 8 years, my lord. In this regard, I have to get a copy of the judgment. If your lordships kindly pass it over, I will get the copy of the judgment.
No, what do you say?
Lord, the respondent approached the arbitrator after lapse of 8 years. 3 years is stipulated and there are certain judgments of the
It has already,
Honorable Supreme Court.
this set point, my lord, has been already adjudicated by the honorable arbitrator, because earlier one arbitrator was appointed. Subsequently, my lord, he did not, after filing of the claim petition, my lord, he did not take up the case, my lord, forward. And therefore, subsequently, my lord, through the department itself, my lord, one more arbitrator was appointed. He, my lord, commenced their proceedings and now concluded. Therefore, my lord, that order, that.
No,
discussion, my lord,
very really challenge it. He can't challenge it in between, no? He will challenge it, they will challenge it in 34 only. The limitation also.
Yes, that point was not raised before 34.
Before which, 34 it was not raised?
Before it was raised, my lord. Before the
Before
arbitrator
the
also it
arbitrator,
was raised.
appointing of arbitrator was not questioned, my lord, there in the 34.
I'll make it. There was an arbitrator who was appointed, claim petitions filed, everything. They have taken a plea that claims are barred by time. The arbitrator, possibly for certain reasons, he did not proceed with the arbitration proceeding. A new arbitrator was appointed. He continued thereafter and came with an award.
No, it was not like that. Fact is that arbitrator was appointed during the year 2006 itself, but the respondent did not choose to approach the file his claim statement itself, saying that he will approach the civil court. He filed original suit thereafter.
Okay.
And when it was pending, he again, after 8 years, approached the official for appointing an arbitrator.
What is the award? Where is the award?
My lord, it is at
Come to the award, page 50. Now, where is the point taken? Was it taken before the arbitrator?
yes, my lord.
What was that?
Kindly see, my lord, internal page 2.
Yes.
Internal page 2 of, my lord, the award. Second paragraph.
Time barred
Time
ground.
barred on the grounds of limitation. Preliminary meeting was held on the parties and so and so. Both basic issues such as languages.
How was the arbitrator appointed? Was the through
It
the
is down, my lord,
court?
down there. It is thus. It is down there, my lord, hit by the provisions of amendment. Then next page, my lord. For as the questions being time barred concerned, from the note of the claimant dated 30/10/2017, it is seen that the claimant has initiated the process of arbitration by invoking arbitration clause. Vide his letter dated 21/1/2009, even before the termination of the contract by the respondent on 22/2009, and subsequent intimation of passing of the final bill on 4/9/2009. Chief Engineer CPWD Vide his letter dated 19/2/2019 had even appointed one Sri A.P. Joshi, a superintending engineer of CPWD, as a sole arbitrator. For the reasons not on records available with the tribunal, disputes were not settled. However, it is clear to me that the claimant had raised dispute claims well in time and cannot be considered to be time barred under the law of limitation.
But what is the basis for him to say?
Because
What is the reasoning?
our claim petitions, my lord, was submitted to him.
When
We
was
had,
it submitted?
it is the respondent, my lord, who had not submitted their defense statement.
When did you submit the claims?
I submitted, my lord, on 9.
He did not submit any claim.
No, it was there, my lord. I have the details. I had submitted, my lord, earlier. Then, my lord, second time when the arbitrator was appointed, I furnished, my lord, the exact copies by changing the name. That's all.
How do we get that? He doesn't give the reasoning here. Where does he say the claims were filed in 2009? Where does he say the claim petition was filed in 2009?
He says for the
After
reason.
rescinding of contract, he did not approach the arbitrator. It was earlier to the rescinding of the contract.
It is clear to me.
Right.
He says, my lord, one line that claimant had raised dispute claims well within time. I had raised it.
How do we get that? Well within time means what?
I'll produce it, my lord, if it's quite.
In the point. In at least in paragraph 2, insofar questions of claim being time barred is concerned, from a note of the claimant dated this, and mind it, that's 2017.
Yes.
It is seen that the claimant had initiated the process of arbitration by invoking arbitration while letter, no dispute.
Yes.
Even before termination of contract by respondent 22/2009, subsequent intimation of passing of the file, no issue. But where does he say, though invoked in 2009, claim petition was filed immediately
Fine, I
thereafter?
have a copy of the claim petition. I shall.
Where does he say so? Then you
because,
may
my
be
lord,
right in saying that
I'll
you
produce
filed the
the-
claim petition in 2009.
I'll produce the synopsis, my lord, saying that when it was filed.
What, so it is, so you say it is not a case when you filed it subsequent to 2017. From a note of the claimant dated date, it is in claimant has initiated the process by invoking this. So when we want to know, when did you actually file the claim petition?
Yes, I shall submit.
And where is your, this thing stand in 34 court that claims were barred by time? What is the stand you have taken?
We have taken that it is time bar limitation as per the agreement.
My lord, I
He
have-
had to approach the,
Right, ma'am. Surely, but 2009, when they invoked, when the dispute arose, that is even before the termination of the contract, before the payment of the final bill, he has invoked the claim, invoked the arbitration clause, and according to him, he filed a claim petition also. Then how can it be barred by time? Where do you say so? Why do you say so? It is barred by time.
uh,
My lord,
Before the arbitrator, our reason that as per clause 25, it is barred by time, he had to approach the arbitrator within 120 days. But arbitrators finding that as per section 28 of the Amended Contract Act, we cannot raise such ground on the limitation point. But we have not taken the ground that it is barred under 137 of the Limitation Act before the arbitrator. And on the facts, also arbitrator has held that earlier one arbitrator was appointed and it was not continued.
What happened to the civil suit?
Civil suit, my lord,
They withdrew.
1 minute. Civil suit, my lord, I withdrew it. Because, my lord, the court insisted me, my lord, that having received the amount under the arbitration, my lord, I cannot go and continue with the case because that amounts to double payment. That is one, and it is barred by res judicata. Indirectly, my lord, even though the court case here, the honorable arbitrator, my lord, says that he, in the civil suit, my lord, I challenged class 2 of the agreement, levying of compensation on me, and my lord, forfeiting of my FSD. That was challenged for a declaration. That, my lord.
You filed a claim petition. File the claim petition which you have filed.
Before the.
File it.
No, before the suit, in the suit, my lord.
Not in the suit, before the arbitrator.
Arbitrator has discussed, my lord, those things because he did not touch that aspect of the matter. And therefore, my lord, suit was continued with class 2, the same page, my lord, page
Then
number
you
3.
withdrew the suit. You withdrew the
So I
suit.
withdrew this.
Then what, you revived these proceedings, arbitration proceedings.
This was held earlier, my lord. There is a decision on this, my lord. What has happened is, my lord.
Just 1 minute.
Yeah.
The counsel for the party shall file the list of dates. Okay, within 2 weeks, re-notify. Just give it in February.
12th February. 25 adjourn. 26, serial number 26.
Appear for the appellants, my lord.
One more submission, my lord. They have not deposited the amount of 50%, my lord. They have obtained stay. That stay may be, my lord, was subject to it, may be vacated.
Pardon, what do you say?
We have not
Stay was
deposited the-
granted, my lord, subject to deposit of 50% of the amount. They have not deposited. So this stay doesn't survive.
The order is subject to deposit, na?
Yes.
Yes, ma'am.
All right, go ahead. Whatever, there is no impediment. They have not deposited, they have not deposited. Next.
36.
My lords,
Shishupam case.
I appear for the appellants, my lords. My lords, at the last moment, the party has decided to go ahead with a senior advocate. We are in the process of appointing a senior advocate, requesting
What is
4
ground,
weeks of
huh?
time, my lords.
I appear for the respondent in this matter, my lords.
I request 4 weeks of time, my lords.
The request of counsel for the appellant re-notify.
27th March.
Obliged, my lords.
27, Vishwanath Shetty. 27,
I appear for the
Yes, Mr. Patel.
appellate counsel, my lord. The registration of the company was cancelled. Therefore, a question with regard to maintainability of the appeal was raised. In the meanwhile, we had filed an appeal before the company appellate tribunal for restoration of the registration. On 7th, restoration of registration on certain conditions has been made. We have given copy to my learned friend also. We are required to make certain deposits, or they have not issued the challenge, etc. It may take another 2 weeks to comply with that. Therefore, maintainability aspect would not remain.
Who has taken this objection? They had taken?
They have taken that objection. page 3. Order starts at page 4.
Yes. Yes.
Otherwise, on merits in the appeal, the first question would be, my lord, I had filed a suit for specific performance in respect of an MOU for joint development of the property. The civil court transferred the proceedings before the commercial to the commercial court. I would respectfully submit it is in no way a subject matter which can be brought to the commercial court. Therefore, as regards after this restoration, main appeal, there are on merits as well as on the jurisdiction of the commercial court is also a question to be considered. This compliance for restoration, I will be able to do it in another 2 weeks, my lord. There is a deposit
Just
of
say
about
that
9 lakhs
we
is to be
will only
made.
say this at the request of Mr. Patil, re-notify after 3 weeks.
Please,
Whatever need to be done, please do it.
please.
Date may be fixed. Date may be fixed.
Pardon?
A date may be fixed.
Yeah, we are fixing it. Just say that he has filed also a memo today in the court, bringing on record the order passed by the NCLT Hyderabad bench. The same is taken on record.
Seven two.
Let the memo be filed through e-filing as well,
Please.
within 1 week from today.
28.
E-filing.
May I please, your lordships, for the appellants in this matter, your lordships, we are challenging the order passed by the Honorable Commercial Court trial below, your lordships, dated 5/7/2024, your lordships. And I'm seeking an order for stay of operation and execution of the same, your lordships, on the following grounds, your lordships. Primarily, your lordships, the first point is limitation, your lordships. In the judgment, your lordships, if my lordships may take page 33, your lordships, of my petition, that's where the reasons start for the ground on limitation, your lordships. Here, the Honorable Trial Court Learned Judge, your lordships, observes that the defendant number 6 and 7 in the written statement have taken a specific contention that the final bill raised by the plaintiff is dated 31/5/2015 and the last email sent to the defendant number 1 is dated 3/9/2015, under which the balance due to the plaintiff has been confirmed and therefore the plaintiff ought to have filed the suit on or before September 2019 or on or before June 2018. The suit which is filed on 13/1/2020, your lordships. Here at this juncture, your lordships, let me take a pause and let me mention, your lordships, that there has been no clear application of mine by the Honorable Single Judge below, your lordships. If the same judgments
Were you appellant was a party before the court below?
defendant number 6 and 7, your lordships. So in the crux of the matter is, your lordships, the plaintiff and the defendant number 1 in the trial court below were incessantly placing certain purchase orders pertaining to procuring sand materials, your lordships, crushed aggregate sand materials, those items, your lordships. They were into that business. But now coming back to the point, your lordships, the Honorable Single Judge mentions that the suit is filed on 13/1/2020. Not just here, your lordships, in 3-4 occasions, your lordships. But if you take page number 27 of my petition itself, your lordships, that is also a part of the judgment itself. Page number 3 of the judgment, that says date of institution of the suit is 21/1/2022, your lordships. So there is a clear non-application of mine by the Honorable Single Judge, your lordships.
On what issue?
That the date of the institution of suit is only recorded wrong in the order sheet, not just once, 2-3 places.
Now what is the effect?
My,
What is the effect?
your lordships, that limitation in itself the institution of the suit and the rejection of the same should have taken place in limine.
Where is the issue of limitation was there?
Yes, your lordships, issue of limitation was issue number 4, your lordships. Right? So the honorable single judge considered the date in itself wrong. And the correct date is also mentioned within the judgment only.
They initiated execution.
No, your lordships.
They have
But we're fearing execution, your lordships. Also, your lordships, this is a classic example of the legal maxim, your lordships. Quod approbo, non reprobo, your lordships, which loosely.
Will issue notice on both the appeal and the stay application.
May the matter be stayed until final disposal. your
Deposit
lordships.
the money then.
20% I may be allowed, your lordships, because I'm not even liable. I'll explain your lordships.
It says jointly and severally.
At least I'll be assured of assured that there will no execution be preferred by
No, we can't say so.
respondent.
How can you? That's the reason we asked you, is there any execution? You said no. Very well, take a chance, serve them, okay?
No,
Or otherwise deposit it.
20% I can deposit.
Very well, okay. Thank you.
Grateful.
No, we are not saying anything.
Oh.
You will only serve them, otherwise deposit 75%.
Your lordships, when there's no liability on my part, I'll
That
explain.
liability, you are in a money decree.
Yes, your lordship. I'll explain my limited liability as per the partnership deed as well. And also the D4, exhibit D4. And the reason why I'm saying this is a classic example of a case of the legal maxim, quod approbo, non reprobo, which loosely translates to approbate and reprobate and having inconsistent positions, your lordship.
We look into everything.
Yes.
We will look into everything. You will deposit, the money will not be taken, but it will be lying in the court. Okay? You want to deposit, we will say so. Otherwise, issue notice, serve the other side. Let them come.
Grateful.
Okay, issue notice, returnable on. Next.
25 to serial number 29, 29.
For the respondents.
Please notes.
Yes.
Defendants appeal. Defendants appeal, my lord. Suit is not filed for injunction with regard to trademark violation, passing off, etc. Not the.
What is the stage?
Suit is decreed, my lord, Ex-parte.
This is suit.
Yes, my lord. In fact.
Why don't you appear? Service affected, everything affected.
Only one date, my lord. That date was wrongly noted, my lord, in the company. It was instead of 3/8, it was noted as 3/9. But 3/9 we have appeared. The court, within a span of about 40 odd days, suit is decreed, not 15/7/2024 is the order.
Should have been actually a 9/13 should have filed it on 3rd itself.
Please, my lord.
4th, he fixed it for judgment, na?
Yes, my lord.
Pronounce it on 4th.
Yes, my lord.
You had the knowledge on 3rd, according to your, now, we don't see any reason. What is the basis for you to say that you have noted 3/9? Where?
Not it is noted, my lord, in the diary, my lord.
Where is the diary copy? The first thing you must only show is the diary copy.
But only thing is not one date, my lord, was missed out.
No, we want to test that stand which you have taken.
They said it is wrongly noted as 3/9.
Where have you noted it? Where have you noted? That shows the bona fides. Yes, we have noted this is the diary. No diary, nothing of that sort. How can that be believed?
Not, we have noted down that it was 3/9 instead of 3/8, my lord.
Where?
Only submission is this.
Where?
But it is.
See, these are the things which become relevant in any case.
But
you filed 9/7 very well. On what basis? Because you were proceeded ex parte.
true, my lord. But it is
3/9. When was the next date after 3/8?
not 4, not 3/8, 3/9, there was no date. Therefore, my lord, we again not moved it on 4/9. But then not in the morning itself, not we moved the matter. The learned judge said that because the date is not given for that particular date and it is posted for judgment and you not served the other side, therefore,
Your
my lord,
noting of 3/9 was also not correct. Even if you have noted. There was no date.
but it was posted for judgment, my lord. We had verified. It was already posted for
But
judgment.
tell us even on merits, what is your case?
But
Even on merits.
even on merits, my lord, the only issue is, my lord, the nature of, my lord, business that is carried on by them is different from the nature of business that's carried on by me.
You show us from your appeal where have you taken one ground on merits?
But it's not on merits, my lord, because it's only, my lord, on setting aside ex parte.
9/13 we are not. There is no ground, there is no justification to
Can
say
I-
I have noted.
But in fact, Lord, within a span of few days, my suit is decreed. Now, Lord, my only submission is, Lord, one date that I missed. But if I missed to appear, Lord, then, Lord, the court not proceeded, Lord, kindly, Lord, please note these dates, Lord. The suit, Lord, the ex parte orders passed on 18/7/2024. The next date is given as 3/8/2024. That day, Lord, I did not appear, nor displays ex parte. Then, Lord, on 14/8 is the next date for evidence and arguments. Lord, it is posted for judgment on 22/8/2024. But only on the basis of the fact that, Lord, I have not entered appearance. Lord, within 18/7, Lord, ex parte order, 22/8 is posted for judgment.
But no, it was not pronounced.
But it is not pronounced.
It was pronounced on 4/9. Still you had a
Yes.
chance. Still you had a
Yes, Lord,
chance.
when Lord, the client has come, Lord, to the office to point out that, Lord.
You're not saying
fine.
you means you.
True,
Personally,
Lord,
you're
true.
trying.
That is how, Lord, he has come to know that the matter is posted for judgment.
That's right.
Lord, even assuming, Lord, I'm negligent, even then, Lord, I would be entitled for an opportunity, Lord, at least to contest on merits, Lord.
Why should tell us one good reason? And this is, we are in a trademark jurisdiction.
True.
Let's be very clear. 3/8, you received it, you knew the date, you don't take any steps, not even appearance thereafter.
Lord, if-
You allow it and you file the third, and mind it, when did you file 9/7?
Lord, it is filed, Lord, on 14/9,
Just imagine, no.
Sorry.
That 4/9.
4/9.
That means on the date when he was pronouncing, you don't even file before that.
Lord, before we cannot file, Lord, when the matter is not listed before the court.
But I think application, you can file it, he can
Has to be-
entertain it. It's only on the date fixed.
Date fixed, not be filed.
Then
the application.
22/8 was a date for pronouncement.
No, that day, that's what, Lord, we did not know, not until, Lord, on 3/9, that is when, Lord, we have 2/9, we have come to know. Lord, I'm only saying, Lord, I should be given an opportunity to contest the matter, Lord, because even the Honorable Supreme
You
Court
want to
says,
even see those reasons, if you have made out any case for even for contest. You're getting the point? That's what I want to wonder. Show one ground that this is the reason for which. And mind it, at least whatever averments he has made, whatever the averments he has taken into consideration, the learned judge, the kind of a turnover, from which date they have been doing everything. Prima facie, we are not saying prima facie concludes something against you. Or the order is justified, appears to be justified.
Lord, the order, Lord, is to the effect that because I have not contested the matter, it is not expired.
Right? That's the
On
reason
that
we
count,
thought,
Lord, the injunction is granted.
that's the reason we thought we will see those reasons. If you have made out a case even to contest, possibly.
Lord, we have not gone into merits because, Lord, we have not been able to contest the matter. Therefore, Lord, to say anything on merits, Lord, it would not be right because
See, we don't mind you filing an additional, but you must say so. See, what is the prejudice that will cost you? You must at least try to highlight, possibly that can be a relevant consideration, subject to what he says.
very well, Lord, I'll seek instructions and do.
You must. What do you say?
I'll file my objections to this first one.
That's the reason, and there is a decree against them.
Lord,
This is total, we
Lord,
can't. One can imagine, notice not served, I could not appear. But notice served, everything was there,
Right.
date was there, you don't appear.
Lord, can I just pass on, Lord, one judgment of the apex court, Lord?
On,
On the issue of, Lord, 913, the court says, even assuming there's negligence, Lord, should be given an opportunity to contest the matter.
reason.
But therefore,
Provided you will try to impress upon the court, look here, these are the facts. And I am sure that I will succeed. I am sure that he will not succeed, being the plaintiff there. That's how you will. Yeah, we don't mind if you want to file, let's see what is there, then we will put it to him. He will file an additional affidavit to show that what are the case on merit.
Very well.
Just say that the challenge in this appeal is to judgment decree dated 4/9/2024 passed by the court of so and so dated in COM OS number 970/2024, whereby the suit was decreed ex parte against the appellant herein. The learned counsel for the appellant seeks and is allowed how much time?
grant me about 2 weeks' time.
2 weeks' time to file an additional affidavit. Okay, at his request, re-notify.
They've already filed execution, Lord, it is posted on 15th.
We say nothing on that.
Can I at least seek for some deference of the execution till then?
What is the, you want 2 weeks? When is the date in execution?
15th of this month.
15 January. You take a date on 15 January to a date which we will fix it thereafter. Just say that we will not record it. We will take it.
29th January. Serial number
Please.
30.
Requested to be first week of February, my lords, 29 January.
Just give it.
Sir, 6th of February.
Great.
Please. Great.
Serial number 30. Okay, Srikar. 30.
An infrastructure project. Employer is state is the appellant, my lord. Appellant entrusted the work of development to the contractor of improvement of Mandya Gubbi existing highway. Now, some portions of the site were handed over. It was existing highway which had to be upgraded by increasing the breadth, etc.
Will you file your submissions, both of you?
Will file. My lord. Only thing is, I had benefit of interim order before commercial court. I had deposited 30 crores. Arbitral tribunal had awarded 35 crores to them and 9 crores to me. And I had deposited 20 crore rupees. They have not even.
It's lying there.
It is lying there because they were not able to furnish security to the satisfaction of the trial court. They have filed execution. They have not withdrawn the money, but they have filed execution. They are putting pressure on me. Warrant has been issued already. It's a government office.
My lords,
Don't execute the warrant. We will see it.
please, my lords, in respect of
Not
the,
execute the warrant.
my lords, could I just request for the entire principal amount to be deposited, my lords, before
So you
the
said 30 crores is there. This is a state entity, no?
state entity,
State entity, my lord.
That's all right.
20 crores, my lords. My lords, and just the liberty that in respect of our withdrawal, my lords, the withdrawal application is still pending. So that's before the commercial court.
My lord, in that they wanted withdrawal unconditionally. Trial court said I cannot give
My
furnished
lords,
security.
with the aspects of surety, etc., my lords, we'll discuss with the trial court. My lords, whatever the trial court directs us, my lords, on that basis, let the withdrawal application be something where we can make our
There
submission.
are two aspects. One is an attachment
Yes.
to, in any case, that around 20 crores or 30 crores, which is.
20 crores I have deposited.
That surely be more than 50% or almost.
Much more than 20.
Much more than 50%. It's
Please.
a state entity. Why
Please.
are you, no, just take don't precipitate,
Yes.
don't seek the execution of the attachment.
Please, my lords. You want to.
Just say that issue notice, so and so accept notice for the.
My lords, I'm on caveat, my lords.
Yeah, so accept notice for the, so and so appears for the caveator, accept notice for respondent number. Both the respondents?
First
No,
respondent.
only
Other-
respondent number, huh?
Yes, my lord, rest are arbitration.
The others are arbitrators.
The notice to respondent number 2, 3, 4 is dispensed with, being the arbitrators. Stop. It is agreed by the counsel for the parties that they shall file written submissions along with the judgment they intend to rely upon within 3 weeks from today. Okay, it is during the course of submission, hearing, the learned counsel for the appellant states that the respondent number 1 has filed the execution proceedings in which an attachment has been issued.
Yes, my lord, warrant, they have
Of
received the warrant.
attachment
also.
with regard to the bank account
No, my lord, to attach the immovable properties.
to attach the immovable properties. Full stop. It is, shall we record your submission?
Please, my lords. We won't take any precipitative steps, my lords.
Learner counsel for the respondent states that no precipitative steps shall be taken by the respondents to seek the implementation of the award. Okay, dated.
One second, my lord, I'm sorry.
Steve, what is the date of the award?
5th March, my lords, 2018.
5th March 2018.
My lords, could I make a suggestion, my lords?
Yes.
Effectively, my lords, the execution proceedings are currently ongoing. We won't take any precipitative steps there. My lords, we only seek that liberty may be reserved to us to argue our withdrawal application in respect of whatever surety, etc., my lords, we may have. Because in respect of whatever money is lying with the trial court, my lords, if we can withdraw that along with the surety and an undertaking saying that if this appeal were to be decided against me, my lords, there won't be any difficulty. We'll deposit the amount back.
We will say that he will not take any.
I have not opposed, my lord, trial court has considered that already.
Let me put it. He will not seek the implementation of the impugned award. But nothing will preclude the respondent to press the application which they have filed before the executing court. Before the executing court,
Before the trial court, my lords.
before the court concerned,
Yes,
before the court concerned to their application for withdrawal of the amount deposited by you.
On furnishing of,
That will be for the court to.
yes, my lord, they should not,
You will say so that you will provide any additional security. See, that need to be left to the court
I
concerned.
agree,
Yes,
my
my
lord, but
lords.
she should
that
not be
to the
interpreted to
satisfaction of the
say.
trial court, my lords, we'll.
Yes, my lord, I
consider
agree.
and take
To the
instruction.
satisfaction of trial court, this should not be interpreted to say that it should be released unconditionally.
That's what, we are also conscious, you're right, you're actually right. It should not be construed, our order to means is
Yes, ma'am.
released,
Yes.
but we are recording your statement. Just say that, during the course of hearing, it was informed to the court that the respondent number 1 herein has filed an application seeking withdrawal of the amount as deposited by the appellant herein. Instead, this order will not come in the way of the court below court concerned deciding the application. Deciding the application filed by the respondent number 1. Respondent number 1 for withdrawal of the amount deposited by the appellant with such conditions as deem appropriate. That would be fine,
Yes.
with such conditions as deem appropriate. Re-notify the appeal.
Execution of warrant is to be taken.
That we have said, so he will not precipitate he will not seek even the implementation of the impugned order. He is only seeking the withdrawal.
Yes.
Okay? That's what we have conveyed.
Obliged.
10-3,
Great.
31, Sadashiva.
For the respondent. Hearing for some time, the records were called for by this.
We have the TCR with us.
Please.
Yes.
But it is in respect of an agricultural land, right? The parties have entered into an agreement for a sum of rupees for 2,07,50,000 has to be paid by him within 6 months from the date of the agreement. On the day of the agreement, they have paid only 25 lakhs has been paid. Thereafter, even after 6 months, but they have not paid any amount. And thereafter, a notice came to be issued them, calling upon to pay the amount and get the sale deed, for which, my lord, they have responded. Then, my lord, after a lapse of 2 years, my lord, they have initiated the proceedings before the arbitration. And they ultimately, my lord, the trial court, the arbitrator court, my lord, was pleased to consider the facts and circumstances and award the amount to the tune of the amount which has been deposited by him, a sum of rupees 25 lakhs, and along with interest. As against that, my lord, suit came to be filed before the trial court. No, my lord, the trial court has also considered the same and dismissed the suit. As against that, my lord, the present appeal has been filed before this court. My lord, the time was there, my lord, 6 months they are supposed. In spite of issuing the notice, they did not bother to consider the fact. My lord, it is an agricultural person. My lord, he wanted to reinvest his property. He did not, they could not reinvest for receiving the amount. For this reason, my lord, has spoiled the entire career in the lifespan itself.
But how would you answer this paragraph 8 and 9?
Arbitration award. But within 6 months, my lord, all the records were available with the parties. The copies have been also furnished with him. And thereafter, my lord, has set up one person to file a suit for bare injunction and partition. And thereafter, my lord, they start the proceedings itself, saying that I could not alienate it. Thereby, my lord, they are stuck. If they are paid the amount and the things would have been completed and.
Who was the seller?
My lord,
The plaintiff,
Yes,
the
yes,
appellant.
Yes, my lord.
Now, come to paragraph 8 you have seen. Paragraph 8.
Yes, my lord.
execute sale deed by providing all concerned documents, RTC, mutation, sketch of the deed. Property was not free from encumbrance. As the children of the first father have filed a suit in respect of the said property. There was a dispute between the children and the.
Yes,
So-
that is thing, my lord, where after a lapse of 6 months, my lord, they set up the person to file a suit for partition and see that, my lord, it should be solved. And even on that day,
What does the arbitrator say on that?
arbitration that is not disclosed of that aspect, my lord. Only say that in view of the pendency of the suit, we could not.
So, but that, there is a pendency, no? But where is your ground taken? Wherever you taken that they were set up by him.
My lord, because of the reason, at that point of time, my lord, even after 6 months, my lord, time was granted. My lord, I was ready. I have caused a notice also. Legal notice was caused to him, saying that I'm ready. Give the
That
money.
has not been accepted.
Para 17 of the.
That has been accepted by him and he has not responded. And after lapse of 2 years, my lord, he caused a cause notice to invite him for arbitration.
Para 17 of the arbitral case award, my lords.
Yes, see that 17. The claimant has issued this. And you have not responded to that. When he sought an appointment of an arbitrator. That's basically on the. Where is your notice calling upon him to execute the agreement of sale? No. Has proved due execution of the agreements of according to agreement of sale. This is the limitation period, therefore it's stated that the respondent issued in the. Where is your case that they have, the others who have filed the suit has been set up by them? Where is your case? And it's a fact that suit was filed. When was the suit filed? Before
After
the,
6 months, after 6 months.
after 6 months?
From the date of agreement which has been entered.
Date of agreement.
Yes.
So what does the arbitrator says? Arbitrator says only refund of 25 lakhs. That is the advance which you had paid.
Please.
With interest, my lord.
Obviously,
But for the reason
how much was the delay?
20, my lord, delay is more.
So that, see 25 lakhs you can't dispute.
I can't dispute.
So your only contest is only on the interest.
Only on the interest.
That's right. How much, what do you say on
Lord,
that?
what has happened? There was an order of attachment before the executing court. Despite there being an order of attachment, they've alienated the property which was attached. I've also filed a memo on before this honorable court indicating the conduct
The
of the
same
party.
property.
The
of
same
which
property which was
Property
attached.
part
The
of.
suit was pending.
No, my lord.
No, my lord, after the arbitral award,
Acha, after
I
the
filed
suit,
an execution.
What happened to the suit otherwise?
The suit, I am not party to the suit. It is
Suit came to
between their family members.
Suit has been not yet abandoned, my lord. They have not continued the suit.
They did not proceed with the suit.
Yes, my lord.
Tell us then what is wrong in saying so?
My lord, only thing is, my lord,
Any stipulation on interest in the agreement to sell?
In the agreement to sell, it says, may I just.
How much does it say?
please.
Twice the amount,
24.
twice the amount.
How much the property must have been appreciated?
Not more than 4 times.
Then
Of the reason, my lord.
The only
Have they-
conduct of
Have they
the,
provided the money at that point of time? I would have invested the money for other purpose.
tell us with the suit being there, whether he could have gone.
Not within that time, my lord, I called the notice.
Within that 6 months,
Yes, my lord.
no, my lord, that is not,
we'll come back, we'll see it.
please, please.
Very early morning, हाँ. Court office. जज से कि 3 o'clock के बाद बिजी है कोर्ट ऑफिसर कोर्ट ऑफिसर कोर्ट ऑफिसर कोर्ट ऑफिसर मैडम हेडी हाँ मैडम सीरियल नंबर 20 हाँ सीरियल नंबर 20 is password हाँ correct but judges will take up password matters because he said like after 3 we are busy Passover after list is completion of the list, madam.
Oh, entire list is completed then only.
Yes, madam. Yes,
Fine.
yes.
Thank you, madam. Huh? Thank you.
Welcome, madam.
Thank you.
Court officer? Court officer? Court officer?
ಮೇಡಮ್ ಹೇಳಿ. ಮೇಡಮ್ ಹೇಳಿ, ಟೋಟಲ್ 2.
Serial number 45 adjourn ಆಗಿದ್ಯಾ?
ಯಾವ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಮೇಡಮ್?
First list.
ಫಸ್ಟ್ ಲಿಸ್ಟ್ 45 ಇದೆ ಮೇಡಮ್.
Adjourn ಆಗ್ಲಿಲ್ವಾ?
ಇಲ್ಲ ಇಲ್ಲ, ಇದೆ.
Okay, okay, ma'am. Thank you.
Lordship's kind permission, serial number 43, my lord. Art accommodation, my lord.
My lord,
First list.
Who is the other side?
Government, my lord. Now for the respondent employee. Sixth litigation, my lord. Went up to Supreme Court and came.
Who is the other side?
Government, they have not, Shanti Bhushan. Shanti Bhushan.
43.
Central government, house.
You informed him.
I told.
Request for adjournment is made on behalf of by the counsel for the respondents. Re-notify.
My lords, one submission.
Yes.
My lord, serial number 38. The arguing counsel is, my lord, out of station.
11/3/11. Start date.
My lord, there is presence of the ASG is required, and since I seek for a 2 weeks time, my lord.
You appear for whom?
For the petitioner.
Union of India.
Yes, my lord.
Now, the counsel for the respondent is out of station.
No, for petitioner, my lord. Counsel for petitioner. SK Acharya, sir.
Yes, sir. 38. Serial number 38.
Other side is informed, my lord.
I appear for the other side. 39, 38.
You said the request of counsel for the appellant re-notify.
So one submission, your lordship, respect to serial number 53.
Just 1 minute. We'll just come. We'll just run through it. Yes. Just show. Yes.
sir, one submission.
Grateful.
Attachment warrant has been issued against me, my lords. Hence, I am filing this commercial application memo for.
What have you filed?
I am filing for memo for posting for today, end of the list or tomorrow.
Is it a listed matter?
No, sir, no.
Is it a fresh matter?
Yes, sir, fresh matters.
Objection. When did you file it?
I have completed all the objections, my lords.
When did you file it?
I have filed in the month of July, my lords. In the month of July of 24.
In the month of
Just take it. Should you get it? Or you should have got it listed earlier.
So grateful.
1 minute. Not today. You have to see it.
Kindly comment.
You are appearing for whom?
I'm appealing for the appellant, my lord. I have served a copy to the opposite side.
When was the attachment issued?
Attachment issued on the date of December 19, my lords.
That also December.
Yes.
Is this? You're sleeping over it. Yeah, maybe day after. We'll see. Day after.
15/1,
Grateful.
Yes, come.
31, serial number 31.
Now you are only on interest. You're only on interest. What do you say on interest?
My lords, as on the date of agreement, the property was agreed to be sold for a sum of 2 crores. And I had given an advance of 25 lakh rupees. Now, after the arbitration petition was awarded in my favor, I filed an execution. During the pendency of execution and when there was an attachment by the trial court, they have alienated the property, part of the property. In respect of the other part of the property, they've entered into a registered agreement to sell with a third party as well.
Oh. When did they alienate the part of the property?
That, my lords, is on 23/1/2023.
And there was a restraint order.
There was an attachment order in respect to
Attachment
the
order.
said property.
Yes, how would you come over this?
Lord, the reasons that Lord, there was no source of income for him. Lord, at that point of time, Lord.
He was there with you.
No, Lord, they have not, let me kindly appreciate. Agreement taken into place way back in the year 2013, my lord. except paying the amount of 25 lakhs.
For how many years you have retained that amount of 25 lakhs?
My lord, I have utilized the purpose, my lord, because which was not utilized for the reason that, my lord, the amount was not paid on time. Because of that, there are.
But you will retain the amount.
My lord, definitely I have retained the
Then
amount, my lord.
What is the
For the reason,
justification?
for the reason, justification is this, my lord. There are family members are more than 10 to 15 members are there.
Okay.
He has to maintain the family and he wanted to sell the property and maintain them entire families. Otherwise, my lord, suppose, my lord, if they have agreed to pay the amount and paid the amount.
Yes.
Certainly, my lord, I have executed the sale deed. My lord, soon after the completion of 6 months, my lord, I called a notice, calling them, then I am ready to execute the sale deed. You pay the amount and take the sale deed. That he has not done for 2 years and I have not, thereafter they called a notice by an arbitrator court and my lord, the petition was filed by them.
Difficult.
My lord, otherwise, my lord, he's a poor person, my lord. Except the land is otherwise, there is no other land for maintenance of the entire family. That's what, my lord, I wanted to pay back the amount. And only thing is, my lord, interest that has to be saved by this amount.
Sorry.
One more submission, my lord, may I permit it, my lord. Let me kindly appreciate, since 2012, my lord, I directed to pay the interest, my lord. That comes to more than double of the amount.
See, we don't know. We will not go into these calculations. We are
Right.
only on a principle, that's all.
Then, my lord, one more submission, my lord. If they are come forward to pay the amount and get the sale deed, my lord, certainly, my lord, they have to, entire things would have been completed. And, my lord, if the 6 months they have waited, they have not. Thereafter, we caused a notice.
The moment you realize this gentleman is not coming forward, look here, this is your 25 lakhs, Tata bye-bye. That's all. That should have been done.
My lord,
Not like this. Two arbitrator and 34 court are against you.
true, my lord.
We are in 37 jurisdiction, you know.
That time was essence of the contract. They have, see, even after the time which was stipulated under the agreement, they have not obeyed by the conditions.
Okay, thank you. Just say, we will dismiss this, we'll pass orders.
Please.
Thank you.
Chandras.
Next.
32, Shri Hanmant Reddy.
Appearing for the appellants.
Yes.
Lord, the present appeal is as against the judgment dated 28/5/2024, rendered by the 34 court.
Served, no?
Notice has been issued, my lord, dated 16/12. I'm unaware if it has been served.
R1 is the contesting party.
Please, my lord. R2 is the.
Now. The
R1 and R2, both are the contesting respondents, my lord. R3 and R4 are the common party.
R1 and R2. You're
R1.
right. Let's see the award.
Please, ma'am. If your lordships may kindly come to page 57 of my appeal memo.
Page 57 of the paper book.
Please. Ma'am. If I may be permitted to read, madam, the honorable arbitrator, the learned arbitrator has considered 3 points of consideration, 3 issues.
Yes.
Please, madam. Second paragraph, my lord, he has considered 3 particular issues as to whether the CLD produced by the R1 and R2 before the arbitrator is applicable to the issue at hand, my lord. Subsequently, has also considered whether the provisions of
Yes.
Please, ma'am. Whether the applicant is entitled for the benefits of the Land Acquisition Act 1894 and RFCT LARR Act. My lord, the appellant is aggrieved by second point, my lord, wherein the enhancement of compensation as well as the applicability of the provisions of the RFCT LARR Act, the 2013 Act, to the present proceedings. Wherein he has considered, if I may be permitted to read, my lord.
Page,
You say on two aspects.
two aspects, my lord.
One is,
The enhancement of compensation
uh,
and the provisions of 2013 Act has been made applicable to the present
this
acquisition.
acquisition is of 2012.
Please, my lord, the acquisition, if I may give your lordship the background along with the dates and events, my lord, the 3A notification was issued dated 2010, my lord. 8/2/2010. Subsequently, the final notification and declaration under section 3D was issued dated 4/2/2011, my lord. Subsequently, the award has been passed by the competent authority dated 24/8/2011.
Now let's see on what basis he determines the market value.
Please, my lord.
Just see, come to page 57.
Please.
Sale deed document is this, wherein shop premises 6.3 undivided right in the consideration of 3 was executed by this.
On perusal of the said seal, the document is seen that Sri
The
Swaminathan.
document is seen that Swaminathan had purchased 2.3 measuring 100 square feet in the commercial owned by total consider 3 lakh. The second respondent has determined the amount of compensation in the above. The rate of 1. Commercial land.
If your lordship may kindly see the last paragraph in point number 1, my lord. Without any justification or reasoning provided, nor without taking into consideration any personal.
How much the land acquisition officer determined?
1,50,000 per cent, my lord. 1,50,000.
50.
50, please.
Okay. And
subsequently, my lord, when the application under section 3G5 was filed by the respondent 1 and 2, wide award dated 13/4/2015, my lord.
So he has confirmed the award.
Please. The arbitrator earlier, wide award dated in 2015, my lord, had enhanced the compensation to 2 lakh per cent, which was challenged by the respondent before the 34 court, and the arbitral award was set aside and sent back for fresh reconsideration. Subsequently, wide award dated 27/12/2022. The arbitrator has confirmed the earlier enhancement to 2 lakh per cent and has also ordered for the competent authority to determine the compensation, taking into consideration the provisions of the 2013 Act. The same was challenged before the 34 court.
But he has confirmed 1,50,000.
Please, my lord. He has confirmed 2 lakh per cent, my lord, which was earlier enhanced. The last para in the point number 1, my lord, if I may be permitted to.
Yes.
However, in this court's order number so and so, dated so and so, the rate of the acquired land was enhanced from 1,50,000 per cent to 2 lakh per cent, which is legal, proper, and reasonable and justifiable in all respects. In what respects has not been reasoned out, my lord, and there is no justification.
No, if you see the second paragraph.
Please.
He said 1,50,000 is legally correct and proper. But when he increases 2 lakh, he doesn't say so.
Please, my lord. 1,50,000 is something which is determined by the competent authority himself, my lord. There was a sale deed which was produced by R1 and R2, which was taken into consideration, and that sale deed came to be arrived at 1,20,000 per cent. But what was determined by the competent authority was already much more than what is to be considered.
But he relates back, or he relies upon the earlier award to say so 2 lakhs.
Please, my lord. He says so that what has been enhanced by the predecessor.
Where is the previous order, the last, the setting aside under 34?
My lord, that has been not produced along with the appeal.
Is this?
I shall produce all.
Who had filed that petition?
That petition was filed by the R1 and R2 respondents. The 34 petition.
So contesting 2 lakhs?
Contesting 2 lakhs, seeking further enhancement.
Further enhancement.
Seeking
that
further.
Was not allowed. Well, no, it was remanded back.
It was remanded back. The arbitral award, earlier arbitral award dated in 2015 was set aside and remanded back for fresh consideration.
By setting aside 2 lakhs?
By setting aside.
How do we get that?
My lord, I shall produce the order copy of the earlier arbitration. Order in the. If I may bring your lordship's attention to point number 2, my lord, kindly if I may be permitted. Point number 2, which has been considered, is the applicability of the
2013 Act.
Please, my lord. My humble submission is the 3A notification was issued in 2010 and the award has been passed subsequently in 2011 itself. The 2013 Act is not made applicable.
But otherwise, the 2013 Act applicability was after 2013 was made applicable after 1114 acquisition
2015, my lord.
was made applicable.
It was made applicable, but not to the provisions earlier wherein the award was passed in prior to 2015 itself. The learned arbitrator has misconstrued the judgment rendered by the Honorable Supreme Court here, my lord. The Tarsim Singh judgment.
Where does the 34 court refers to the earlier award, earlier order under 34?
My lord.
Come to page 33.
The 34 court has not considered the order of the earlier court. They have only taken into consideration whether the grounds made applicable.
Come to page 33.
33, please.
No, he's referring to it. Page 33, para 6, in between, just in the middle of the para.
Please.
The competent authority land acquisition determine the amount of compensation. The competent authority awarded 150%. The learned arbitrator enhanced the award from 150 to 200%.
Please.
They being satisfied amount, this court decreed the suit and remanded the matter with liberty to adduce further evidence to the parties. After hearing both the sides, the learned arbitrator upheld the award.
Please, that further evidence was this particular seal deed, which has been considered by the learned arbitrator.
But tell us one thing.
Please.
But how? See, he can't be worse placed. He got 2 lakhs.
Please.
They got 2 lakhs.
Please.
They filed 34 for a further enhancement.
Further enhancement.
The demand is only for further enhancement.
My lord,
not for determination afresh.
Please, my lord, but the 34 court had the jurisdiction to either set aside or confirm the award passed by the arbitral learned arbitrator, and they have set aside and remanded back for a fresh consideration.
Right.
Taking the, please.
What we are saying, they
Please.
could be worst place.
Please.
That I got a 2 lakhs award.
Please.
But I am not satisfied, go in appeal, or
Please.
go in 34. 34 set aside to what extent? To the extent of enhancement.
Please.
So enhancement, they say, okay, now you go back, let them relook into it.
Please.
But 2 lakhs is in any case the base amount.
1,50,000 is the base amount, my lord. That has been what has been.
How do we get that? 2 lakhs was granted to them.
2 lakhs was granted, enhanced by the learned arbitrator.
What is happening now? They are not even getting 2 lakhs.
My lord, 1,50,000% was the amount determined by the competent authority. Accordingly, the compensation was determined and the amount has already been paid to the respondents number 1 and 2.
Right.
Please.
They went to the arbitrator. Arbitrator said 2 lakhs.
2 lakhs.
They were not satisfied. You did not challenge that.
Please.
You did not challenge it.
Please.
Very well. Their case is enhancement. Otherwise, why will they go in 34? They say enhance it to 2 lakhs, more than 2 lakhs. He said, very well, this is concerned, we will go back. He should not have set aside that award. In a way.
My apologies to interrupt your lordship. In AP 89/24, we have also challenged the award passed by the learned arbitrator.
You have also challenged.
Both the matters was connected.
89.
89. They were taken into consideration as a common judgment has been.
This court decreed the suit.
Page number 30, my lord. If your lordship may kindly see page number 30, that is AP 6/23. That is the.
And you are challenging it could not have been more than that.
It could not have been more than 1,50,000, my lord, because there was no basis for such enhancement.
That we take it.
And subsequently, the appellants herein are aggrieved by the very fact that the earlier enhancement has also been confirmed with, my lord, and the arbitrator has also awarded the compensation to be determined taking into consideration the 2013 provisions, the 2013 Act. But the Tarsim Singh judgment was with respect to the payment of solatium and the applicability of the Land Acquisition Act to the acquisitions under National Highways Act. And consequentially, as a result, the section 3J was held to be unconstitutional of the National Highways Act. but it never, the Tarsim Singh judgment never spoke in respect of the applicability of
13.
2013 Act to the earlier acquisition proceedings. Please, in retrospect, it has not been made applicable, my lord. Per contra, the Honorable Supreme Court has extracted the notification issued by the ministry, wherein it has been made applicable subsequent to 1/1/2015, my lord.
And he says so 1,50,000 is legally correct and proper.
Please, my lord. He says that the amount determined by the competent authority is legally correct and proper, yet goes forward and ahead and enhances the compensation to 2 lakh % without any justification or reasoning, or not taking into consideration any personal inquiry to be held. Taking into consideration the provisions of the national
Is there
liability.
any judgment on this right to fair compensation where 2015 has been recognized, but not in the past period?
Please, my lord, please. The Tarsim Singh judgment itself recognizes the fact that the 2013 Act is made applicable to the acquisition proceedings subsequent to 1/1/2015. The Honorable Supreme Court has extracted the notification and the issued by the ministry, and also subsequently has gone ahead and clarified.
We'll allow this, we'll pass orders.
Please.
Okay, thank you.
I'm obliged, man. Grateful.
Just give it to me this. Yes, next. Last one.
33. Number 33.
Hearing for the respondent number 1, please, my lord.
Appear for the appellant, my lord.
I don't have one submission. Sorry to interrupt the learned senior counsel. My lord, there's an inconvenience today, please, my lord. I'm led by senior advocate Uday Holla, sir. I request for a date next week, please, my lord. This is a section 37 appeal which is preferred by the appellant before this honorable.
Raghavan, you will file your submissions.
I will, but in fact, I have it ready, my lord. I'll work more on it and then file it. There is a question of law, my lord, that arises. The learned arbitrator says that I cannot look into section 18 of the RERA because I have no jurisdiction. My lord, that, according to me, my lord, is a incorrect finding recorded by the arbitrator in law. I would say, my lord, in fact, the provisions of the RERA Act itself says that the remedy provided in this Act is in addition to and not in derogation of any other remedy. And the Honorable Delhi High Court has considered this very aspect and then said that a proceeding under the Arbitration Act is maintainable to enforce a right under the RERA. So that, my lord, is a question that would require your lordship's consideration. And on that ground, my lord, the learned arbitrator is sorry, I'm not giving you any compensation for delay.
Okay.
This is the question, my lord, that I would
Say that request for adjournment is made on the ground that the arguing counsel is in difficulty, personal difficulty. We notify, just give in February somewhere. Now counsel for the parties to file their written submissions along with the judgments they want to rely upon.
There's an urgency in this.
Your lordship, sir.
Request for a date next week.
My lord, I'm not, I have some inconvenience, my lord, next week. I'm not in
And
town.
we'll give you, whatever is convenient, we'll give you that.
Fourth or fifth, my lord, whatever date, your lordships.
Just
Whatever
say-
date, whatever date.
See in the matter, please, my lord, wherein there is not an executable decree in favor of the appellant. My livelihood has been choked by the appellant, please, my lord. For that reason, I request for an urgent hearing. If they are-
We'll hear you, ma'am. We'll hear you, ma'am. Please, we'll
11.
hear you. We'll give you a convenient day. We know this may take time. How long it would take, Mr.
No,
Rao?
I'll take about an hour.
See, we'll take it. We'll give you a date.
11th February, sir.
Yeah.
The date, please, my lord.
Not
11.
possible, ma'am. Not possible.
11th February.
Yes.
My lord, there is an interim order that has been passed in this appeal on 4/12/2024. That may be continued, my lord.
Yes, interim order.
Arrangement, my lord.
Whatever, my lord, whatever is order. Whatever is.
The further, whatever arrangement is prevalent between the parties shall continue till the next date of
Great,
hearing.
my lord. Great.
Next.
Court.
I appear for the appellant.
Yes,
Please, ma'am.
tell us, Mr.
This
Pra-
matter, my lord, the management filed an approval application before the industrial.
For my learned friend, presses the matter on merits. Now, my lord, this is an appeal against an order of the learned single judge in exercise of power under 227. No, my lord, whether appeal is maintainable or not, I would like to place some judgments, my lord, and then your lordship may decide that first, and then if it is maintainable, then proceed ahead on merits.
What is your case on merits?
Merits, my lord, what has happened, my lord, approval.
We have to draw a distinction between proceedings under 33(2)B and 10(1).
Yes, ma'am. Yes, ma'am. Yes, ma'am.
There, I think possibly,
Amended, sir.
which we have given recently also.
Please, ma'am.
We have given recently also, there is a distinction.
Please, ma'am. Please.
32 is only to the extent whether
Yes,
he
yes.
had the
Yes.
opportunity.
Yes.
Yes,
Yes.
and here, my lord, in this case, what the learned, what the
Aniksha,
labor
please.
code did was, my lord, labor code goes into the aspect of discrimination, proportionality of punishment, and then holds it, my lord, that the approval
But
is
did
not
you,
to be granted.
did you seek a reference or have you approached the
No,
labor?
no, so far, no.
Yes,
Then you
So
should
far.
have availed that.
Yes.
So
You
far.
should avail that.
What has happened is in present situation, my lord, I am told that the company is closed
Yes.
and they have paid compensation to
This
most.
company is
Yes, my lord.
closed?
Yes, my lord.
My lord, the Bangalore manufacturing operations are closed.
Where he was working,
But then the, otherwise, as a company is in existence.
Yes, yes,
we don't.
Work it out.
yes,
That's all.
You will work it out.
yes,
Please, please.
We say nothing. In fact,
Please.
you can. The other places it's working, you will work it out.
yes.
Once you succeed, consequence must follow.
My lord, he can raise a dispute under section 10. There, my lord, the issue as to whether the gravity of the charge, proof,
That's right.
all that will be gone into, not in these proceedings.
Suppose, let's assume he succeeds. His apprehension would be what will, how will be the award implemented?
My lord, it's a 150-year-old company. Company is there, my lord. Bangalore
That's
operations.
what I'm
But then
told that.
only one thing which possibly we can foresee for his, then they, where will he seek the reference?
Yes.
My lord, here only.
Sure.
Yes, my lord.
No objection on
No
that. count.
objection on that, my lord.
Now let me,
No
let me,
objection on that.
give me some time, my lord.
We'll have it tomorrow, day after,
Next week, my lord.
Monday, re-notify the request of
Tuesday,
counsel.
Tuesday.
Tuesday, the appellant re-notify.
Please.
See, that would be better.
Yes.
Otherwise, law is
I'll
well
just-
settled on this.
I'll just.
It's on that basis, my lord, the learned single judge is allowed, because inquiry is held fair and proper, charges are held true. Inquiry officer's findings are not disturbed.
That's right. Okay. Next, we just give it Tuesday. now.
21, sir.
Next,
Please.
35, PBL Sanjeev.
you issue notice in this. Yes. Issue notice. Obliged. Both on the stay, both on the delay, everything.
2nd of April. Serial number 36, government advocate.
Appear for the
36.
Where is this 2022 circular?
My lord,
2022 circular. See, now you have
My
in
lord, this is-
supersession, to the
This is
earlier
regarding the
circular.
building safety and fire safety measures to be adopted by all the educational institutions.
You're right, we will look into it. Obviously, there is a larger interest of the
Please,
children
my
is
lord.
also need to be seen.
Please, ma'am.
But where is that 2002? See, can you say that you may be right? Suppose structurally some changes need to be undertaken. That cannot be fastened on you. But there are certain measures which need to be taken by every school for the larger interest of the children. That need to be followed.
We are doing it because Lordship may pass on
That's
the,
very well. Now, do you have that 2022 instruction?
no, 2022 circular.
Huh?
We have to question it actually, basically. Before that, the learned single judge has said, as far as these circulars are concerned, it cannot be made applicable to old schools, 2017-18.
But that cannot be
No, no.
complete
Why I
circular
am saying, Lordship, the judgment of the apex court may pass on.
of 2008.
Why we are not questioning? Because now your Lordship may make one submission. All the institutions which are represented by the association, about
And
3,000.
moreover,
we
my
all-
lord, these guidelines
we
are
all
not
put all the file application, trained the concerned staff, finally see only short, because the operative portion of the order of the Honorable Apex Court is very clear, Your Lord. Paragraph 47, Your Lordship. That is the direction given, 47. Because we are all definitely concerned about the safety of the children and all things.
That's
Because
right.
not like that, we can't just give a go. In view of what happened in Lord Krishna Middle School in district Kumbakonam, where 93 children were burnt alive and several similar incidents had happened in the past. Therefore, it has become imperative to direct that safety measures as prescribed by the National Building Code be implemented by all government and private schools functioning in our country. We direct that before granting recognition of affiliation,
The state government and union territories concerned are directed to ensure that the buildings are safe and secure from every angle and they are constructed according to the national safety norms incorporated in the code. All existing government and private schools shall install fire extinguishing equipment within a period of 6 months. The school building be kept free from inflammation and toxicity.
Okay,
storage.
yes.
These things we are doing.
Very well. If
We are
you are
doing-
doing this, very well. Structurally, you can't change it. There is a building. Ma'am, what is the challenge now?
My lord, before the learned single judge, my lord, they had challenged the circular, my lord, dated 10
Yes, we have
2020.
seen that.
That circular, my lord, nowhere it distinguished about the old and the new
But
buildings.
tell us one thing.
Please, my
There
lord.
is a building which is in existence.
Please, my lord.
Now they say that you will create this. Structurally, the building has to undergo a change. How will they do it? And even the Supreme Court also says all existing private schools shall install very well. So what is the intent was?
Yes.
Intent was anything which was in existence before 2000. In fact, the state government implemented in 17 and 18.
Please, my lord.
You can argue that this law was in place from 2008 or 2009. They were to undergo or they were to follow those, conditions.
Please, my lord.
But how will they undertake the structural changes in a building? Or suppose structurally it is not possible. Then how will they undergo the changes? How will they make the changes?
Apex Court, my lord, even has held that even existing buildings, my lord, they have to comply with the building safety, my lord.
How do we get that? No, building, you're right. If
Yes,
you
ma'am.
see paragraph 47.
Please, my lord.
So we are basically 47(1).
Please, ma'am.
Before granting recognition affiliation, it is not applicable to the past schools.
Yes, ma'am.
The state government unit concerned are directed to ensure that the buildings are safe and secure from every angle and they are constructed according to.
Please,
It is
ma'am.
not such a case which will be applicable.
Please.
This is for future.
After, that's what.
My lord, in clause 2, my lord, all existing government and private schools shall install fire extinguishing equipments within a period of 6 months.
Right?
Yes, ma'am.
The Supreme Court drew a distinction between those which are in existence, those which will come in future.
Yes.
Definitely, we all have to follow it. We have to, because we reference or
But ultimately, my lord, what matters is building safety, my lord. If
We
tomorrow.
are with you on that.
Yes, my lord.
We are with you on that. You suggest whatever structural changes, whatever Supreme Court has said
Lord,
in this paragraph.
My humble submission would be that, my lord, these private schools, my lord, they can shift their schools, my lord, for compliance of these guidelines, my lord.
Shifting of a school is not so easy.
Lord, if anything
You
happens,
see paragraph 41.
please, my lord. Safety standards are enumerated here.
judgment.
Old equipment training schools. We'll show you. Now, yes, 3.3, the next next page.
Please, my lord.
Supreme Court judgment.
Brick, stone, masonry walls, RSC, the
Madam.
nursery.
School
elementary,
building
story
specifications.
building, the school building shall be staircase of the existing escape routes. Now come to this, 3.3.
School
Yes.
building shall be free from inflammable. and
A-class
toxic
construction, brick, stone, masonry, walls, RSC roofing, which is not possible. Right? Roofing only non-combustible, fireproof, heat resistant. The nursery element should be housed in a single story. The school building free from inflammable, and
Even class
toxic
1.
materials. And just see the next one, 4.
Please,
The
my lord.
staircase which act as exist or escape route shall adhere to the provisions specified in the National Building Code of 2005. Ensure quick evacuation of children. The orientation of the building shall be in such a way that proper air circulation, lighting. You show us anything which has come after this judgment before the Supreme Court. Supreme Court has made applicable to even the past schools also.
Please, my lord.
Just show us from any of the judgment which has, and I am sure that after this, the matter must have gone back to the Supreme Court. Supreme Court must have said also, this must be an issue like, this has been raised. The schools which have come up in the past or before this judgment
Please, my
and
lord.
the schools which will be in future. According to maybe many of the schools, they say this will only hold good for the schools which will come in future. But other things like movable aspects which need to be looked into for the safety of the children, for extinguishing fires measures,
Please, my lord.
that they say they are complying with it. But you show us, look into it, that this judgment has gone back to the Supreme Court and Supreme Court also clarified. That what would be, or this would hold good even to the schools which were in existence before that. Show us any judgment of that,
Only insofar as building safety.
of any.
Yes.
All the conditions will be applicable to the schools which were in existence before the date of judgment.
Please.
You show us one judgment. Getting the point?
I got it.
The learned single judge only draws a distinction between the schools which were in existence before that and which will come in future. So he said it will be only for the schools which will come in future. That's his interpretation. Show us, okay?
Yes, ma'am. It may be taken upon Wednesday.
Yeah, we'll just, at the request of counsel for the appellant to re-notify.
In fact, learned single judge, page 33.
Yes,
has
we'll
specifically
just.
observed that as far as the government schools or other schools, there is no such.
You're right. See, we are concerned with the safety of the children. So we should not want any untoward. To the
Definitely,
best of the
yes,
possible, you should take all measures.
Yes, sir, all precautions we are going to take, see that, because there is already a child safety law, child commission has been set up now. Accordingly, the guidelines have been issued by the, based on the request filed by us, guidelines have been issued by this Honorable Court. Based on that, it has been implemented. There is a booklet is also printed that has also been sold to the learner single judge. So based on that, the learner single judge passed, because we are having all the safety, we are concerned about children. This.
Right, you know, the Kumbakonam, that incident which happened, there was no escape route. Everyone got trapped. That eventuality need to be also obviated. Serious thing. Okay. We just give it.
But my lord, if they
Give it
follow
February, any date. Give.
In fact,
building safety, my lord, they have to obtain it. Otherwise, my lord, there is no chance for, there will be no, they can't adhere these guidelines at all, my lord.
Right, ma'am, right, but the issue is whether those, at least that's the reason any building need to undergo a change. Will it be applicable to them? You say that they have to shift to another place, construct a new building. We need to look into it, whether the Supreme Court had considered again afresh, also had given any further direction. Just look at.
I'll look into it.
13 to.
Apply.
What is the direction here? 47(1) is future. You will ensure it. All the building bylaws, everything are adhered to. The directions of the Supreme Court are adhered to.
Please.
For giving recognition, affiliation, everything. That's
Yes.
what for future. For the past, what would be the issue?
what is the before granting recognition or affiliation? Very clear law. And we are not coming there because all the future schools, we are already asked for the requirement of the.
We will, yeah.
Court.
Just give a date.
13.
Come, Mr. Kamath, who is the other side here? Was the counsel who appeared on that?
Mr. Patil is.
Mr. Patil is here.
59. 59.
Mr. Amresh, just wait.
Yes.
What is the issue, Mr. Patil?
Please.
Just.
In brief, the appellant herein was the president of Shimoga DCC Bank. On 17/7/2014, it was noticed that in one of the city branch of the DCC Bank, there has been embezzlement, etc. And therefore, Managing Director of DCC Bank files a complaint. FIR is registered. In that FIR, initially, it was only employees of that city branch who were the accused, but police included the present appellant as an accused. As an accused at A15. Accused number 15. He was taken to custody. All those things happened. Thereafter, charge sheet was filed against some of the accused. They continued the investigation under 173(8) CRPC. Ultimately, final report was filed as per Annexure C, in which, as regards the present appellant, they dropped the charges, saying the material available does not implicate, there is no material available to implicate the present appellant as a accused. This went on for some time. After the change in the ruling party, again, a second complaint was filed against the present appellant, to whom charge sheet was not filed. That I challenged before this honorable court. That complaint proceedings itself was quashed. Then the investigating officer made an application, it appears, before the court where the original prosecution was pending, for continuing in further investigation under 173(8), and pursuant to that, a charge sheet was again filed as against the appellant. The offences for which the charge sheet is filed are available at kindly see page 274. Offences alleged are 409, 202, read with 36 IPC. It was at this stage, when this second charge sheet, the cognizance is yet to be taken. It is filed before the court, but cognizance is yet to be taken. It was at this stage, the present summons at Annexure A, page 91, translation is at page 92. ECIR was, a reference is made to ECIR, and the petitioner was asked to attend the proceedings with several information, etc. They had taken it to his village house. Fortunately or unfortunately, on that day he was not there, he was in Bangalore. Therefore, by making a panchanama, they gave it to the caretaker of the house there. And they searched the house. A bank locker standing in the name of appellant's wife's sister was seized. All those things had happened. It was at that stage I filed the present petition, pointing out three things. The predicate offense as against me is not one of the schedule offense. Therefore, ED case cannot be registered. 409, 202 read with 36 is not one of the predicate offense, schedule offense. 409, 202 read with section 36 IPC.
Okay.
I also pointed out, even as against other accused, against whom originally charge sheet was filed with regard to that case, they were discharged by the magistrate.
How many?
There were about 9 persons.
Who were similarly placed like you?
No, they were all employees of that city branch.
Of that bank also? Whatever.
Of that bank, city branch. employees of that branch where the embezzlement took place.
How many? 9 you said,
9, I'll just verify the number, my lord.
were discharged,
They were discharged.
but no charge sheet against them.
That annexure C charge sheet, though it was filed, they pleaded for discharge. Discharge was done. Against that, the prosecution as well as the bank took up the matter in revision before the Sessions Court.
Hmm.
Order of the magistrate was set aside and matter was remanded. Against that, some of the accused therein, primarily one Shobha, the branch manager of that branch, she had filed 3 writ petitions.
She was also an accused.
She was the prime accused. She was the branch manager of that branch. She had filed that ultimately it appears while filing the charge sheet, they split it to year-wise and 3 charge sheets were filed for the same complaint. 3 charge sheets or something of that sort was filed, which resulted in Shobha filing writ petitions challenging the order of the Sessions Court. And also one criminal petition. Criminal petition 3600 of 2021.
3600
2021.
2021.
2021. And the writ petitions were page 17, your lordships would, I'm sorry, my lord, it would be 3006, not 3600. 3006 of 21.
This is other than those 3. Additionally, other than those 3 which were filed by Shobha.
I'm not sure about that because no, I'm not a party in any one of those things. Those
No, you
petitions.
may not be, but you said refers to Shobha has filed 3 writ petitions.
3 writ petitions and also this criminal petition.
This also.
This also.
Okay.
3 writ petitions and this.
She filed under 226, 227, 482, those 3.
482, those 3 writ petitions. And the one criminal petition 3006 of 2021 against the same proceedings. I don't know what orders were challenged in that. They had the benefit of an interim order. When I filed this petition in 2023.
What happened to those petitions? No idea.
No, they were, I will come to that in a minute, Lord. In this writ petition, when I filed the writ petition in 2023 against the ECIR, I pointed out, the present appellant pointed out, as against him, charge sheet is not filed, and a second charge sheet which is filed is not in respect of schedule offense, and even that in respect of which some charge sheet is filed. Proceedings are stayed by this honorable court in this WP and criminal petition. Therefore, learned single judge, while granting the interim order, referred to these petitions. Then, as those petitions were to come up before, roster-wise were to come up before another court, matter were posted along with the present writ petition. Matter was posted before that court in view of a circular, I am told, where it is said if there are connected matters, senior most of the judges, it should go. Like that, it came up. Then vacating application was moved. Then the matter was taken up for hearing only in respect of the writ petitions. In the meanwhile, as a matter of precaution, I also filed a writ petition against the second charge sheet which is filed against me, though that is not of schedule offense. I filed a writ petition That was also the learned single judge called for that petition. That was also taken up along with these proceedings. The respondents did not file statement of objections as such, nor did they give a copy of ECIR to me, but they produced it before the court, and the learned single judge says he has looked into that. Now, while making submission, they also made a submission that against this appellant, earlier to all these proceedings, there is another case under the Prevention of Corruption Act. Therefore, that is taken as schedule offense, was one of the ground made out. I may bring to your lordship's notice, as a matter of abundant precaution, against that FIR, against that FIR and the CC, I have now filed a writ petition, and the proceedings in that case are also stayed. But that was after the disposal of the present petition. Now the learned single judge narrates the facts as common to all, then your lordship may kindly go to page 34. Para 13 at the bottom of page 34. In the amended petition which I have given, my lord, the paging etc. is with reference to the, because at the time when I filed the original appeal, order copy, except the order sheet that petition is dismissed, other things was not available for about a month. But the ED started taking action and again issued a summons. Therefore, I was forced to file the appeal without the order copy. Later, I produced it. Now with the amendment, I have given the para 13. This writ petition is filed by accused number 15 in CC number so and so on the file of first additional civil judge and JMFC for quashing the final report dated 37/2021 filed against him in crime number so and so. The petitioner contends that a case of crime number was registered by Shumoga Town Police, which was transferred to CID. After investigation, charge sheet was filed on 18/10/2014, where his name was dropped. Nonetheless, the proceedings were pursued in crime number so and so, and separate cases were registered in CC number 2634. 2775, 2776 of 2019. He contends that in CC number there were only 2 accused, while in CC number so and so there were 9 accused, and CC number 2775 there are 11 accused. He contends that some of the accused pleaded for discharge, and the first additional civil judge Shumoga by an order dated so and so discharged all the accused, and an order dated 6/3/20 and by another order dated so and so. He claimed that as against these orders of discharge, state government as well as the DCC bank filed revision petition which were allowed by the order dated 11/11/2020. He contends that the accused in the said case have filed criminal petition and writ petitions before this court challenging the order so and so, and where this court had granted an interim order of stay. Petitioner claims that at the elections held to the board on so and so, he was elected as director, later elected as president. He claimed that he had contested the election of Karnataka State Legislative Assembly from Tirthalli constituency but was defeated. He claimed that elections to the state assembly held in so and so, he again contested, and election from Tirthalli constituency. He contends that after the formation of the government in 2018, an investigation was initiated in the affairs of DC Bank through cooperative department, and an order of disqualification under 29C was passed against the petitioner alone, which was challenged in so and so. This writ petition was later dismissed, relegating the petitioner to alternate remedy under section 70 of the Act, consequent to which petitioner filed an appeal before the additional registrar of Cooperative Society Bangalore, which was allowed by an order dated so and so. The petitioner claims that when he tried to seek reinstatement as director of DCC Bank, his tenure as the director of TAPCMS Shumoga had expired, and therefore he ceased to be a director of DCC Bank under section 18B of the Act. When elections were held to TAPCMS Shumoga, petitioner was again elected as a director of the society. In the meanwhile, one of the elected directors of DCC Bank resigned on so and so. Petitioner was co-opted as a director. Board of Directors of DC Bank exclusively moved a no confidence motion against the president, and hence the post of president in DCC Bank fell vacant. Petitioner contested the election to the post of president and was declared elected. The petitioner contends that when all the efforts by his political rivals failed, they initiated prosecution against the petitioner by seeking permission under 173(8) of the code to further investigate. Ultimately, a charge sheet was filed against the petitioner alleging offences punishable under section 409(202), read with section 36 IPC. Petitioner is therefore before this court challenging the said final report registered against him. The learned counsel for the petitioner submits that the entire case is at the instance of the authorities and officers other than CID, which appears to be based on directions by the state government. He contends that a plain reading of charge sheet shows that there is no offense committed by the petitioner under section 409 IPC. In this regard, he relied upon the judgment of so and so, so and so. He contends that the essentially.
Sorry, just 1 minute. Lord, my learned friend is reading about WP 22,980.
That I think you only confined to that.
Yes, it is not our writ petition. Our writ petition is 22,780. And the only issue is he has challenged our summons. Whether a writ petition is maintainable against a summons, my lord, is a well-settled issue.
He was petitioner in that batches of appeal, in the batches of the petition which he is reading.
No. I am
He filed one petition, my lord, but it is different, my lord.
I am reading this only to show that one of the grounds that I raised is even under the provisions of this thing, the schedule offense or the other cases registered out of which the proceeds of crime have arisen are not supposed to be jointly tried and heard. But the learned single judge makes it a point to take them jointly, hears them jointly, passes a order. For the purpose of facts, he confines it to the same for all the cases and then passes individual order in each writ petition. I am not challenging 22809 in this appeal. I am reading this only to show what was urged before the court.
Lord, the question is writ petition lies against a summons or not, my lord, if we can confine to that.
Yes, Mr. Patel.
Please.
But you would only confine to what is the issue.
Yes, my lord, your lordship may kindly go to page 44, para 23. It is now settled in view of the judgment of the Honorable Apex Court in the case of so and so that an offence under PML Act would be attracted only when any of the offences mentioned in the schedule to PML Act is registered. The authorities under the PML Act cannot prosecute any person on notional basis or on the assumption that a schedule offence has been committed unless it is so registered with the jurisdictional police or pending inquiry or trial by way of complaint before the competent forum. It is also equally well settled that the registration of ECIR cannot be equated to registration of FIR, as the said document is an internal document for the purpose of the Enforcement Directorate. The proceeds of crime as defined under so and so is dependent on illegal gain of property as a result of criminal activity relating to a schedule offense. The position of law is well settled that when once the accused is acquitted in the predicate offense, or if it is quashed by the court of competent jurisdiction, or if he is discharged, there can be no offense under the provisions of PML Act. With these prefatory notes, if the case on hand is perused, petitioner was chairman. I will stop at this, my lord. Then your lordship may kindly see the ultimate order that the learned judge passes.
This is 22780.
Yes.
If you see the reasoning,
Para 26, ink page 56, or typed page 40 of the order.
but this relates to this writ petition?
Yes, my lord. It starts from para 23 in respect of
Yes,
this writ petition.
23.
The reliance placed by the learned senior counsel for the petitioner on the judgment of the Honorable Apex Court in the case of Balaji, that stay of a predicate offense eclipses a schedule offense is inapplicable to the facts of this case, as the summons is not issued by the respondents on the premise that a schedule offense is registered against the petitioner. First reasoning, that summons is not issued on the ground that there is a schedule offense registered. Then, likewise, judgment relied upon by him in the case of Ramesh Jelly is also inapplicable, as section 13 was made a schedule offense by virtue of Act 16 of 2018. Even otherwise, there is nothing on record to prejudge the case whether the summons was issued in respect of charge sheet filed against the petitioner under 13(1)(e) read with 13(2) of the PC Act 1988, or to take further steps in the matter of investigation into the offences against the co-accused. The learned judge does not accept the case of the ED that if this schedule offense case is not available, there is another case against the petitioner under 13(1)(e) and 13 this thing under that. The learned judge says he is not accepting that. I'll read that sentence otherwise, my lord. Para 56, page 56, last sentence. Even there is nothing on record to prejudge the case whether the summons was issued in respect of the charge sheet filed against the petitioner under section 13(1)(e) read with 13(2) of the PC Act, or to take further steps in the matter of investigation into the offences against the co-accused. Therefore, all the contentions urged by the learned senior counsel for the petitioner in assailing the summons issued to the petitioner are liable to be rejected and accordingly rejected. Consequently, WP 22-780 of 2023 filed by the petitioner lacks merit and is dismissed. I am putting my case on this footing, that in respect of the schedule offense case, it is not that I was not made an accused there. I was made an accused. I was discharged saying material does not support the case.
So the first limb goes.
First limb, the learned judge says, it is not in respect of schedule offense at all. Then in that very case, again they filed a second charge sheet against me. That offense is not a schedule offense. 409(202) read with section 36 is not a schedule offense. If the learned judge has accepted the fact that without there being a schedule offense case, as per Vijay Chaudhary case, ED cannot proceed, register or reissue summons, etc. Ultimately, there has to be a case of schedule offense from which the proceeds of crime arose. If I were to be a third party and a case is registered against XYZ, case of the enforcement director, that in that case registered against XYZ, there is proceeds of crime which is dealt with by the present petitioner. Therefore, we are registering a case against him. Yes, an argument could have been advanced. But in this case, I was made an accused. Charge sheet was not filed saying material is not sufficient. In that case, of course, there is 420, 469, etc., which are schedule offense as against other accused. Then second charge sheet was filed, which is not schedule offense. If these facts are undisputed, I would respectfully submit.
Why is this reference to 13(1)(e) and?
That's what I submitted. Altogether earlier, of course, it was stated at the time of argument that there is a case pending against, there is a case registered of income or the assets more than the disproportionate assets case is registered. It is that which is the reason which can be taken as schedule offense for this. That was submitted at the time of argument, though it was not the case made out. But the learned single judge does not accept that also. He says, even otherwise, there is nothing on record to prejudge the case whether the summons was issued in respect of the charge sheet filed against the petitioner under 13(1)(e) or 13(2) of the PC Act. If the first one is not the schedule offense to which I can be connected, they put up a case saying that it is in respect of, there is another case that is a schedule offense, therefore we have issued. Now, my lord, as I said, I will file that, this thing. I challenged that sanction with regard to proceedings under 13(1)(a) and 13(2). That proceedings are stayed by this court. So now, at this juncture, I stand in a position where I was named as an accused in a case which involved schedule offense. At the time when the learned single judge was hearing the petition, there was a stay order. He could have said, I have dismissed those petitions yesterday. Therefore, there is no stay order. Today, I am dismissing your petition. There was an interim order of stay. Those proceedings were also stayed.
In which petition?
In
Shobha.
Shobha. In those petitions. Then, at any rate, in that case, I was made as an accused. There were schedule offenses with regard to other accused. First, it was said, they don't have material to file charge sheet against me. Then they filed a charge sheet, which is the offense is 409, 202 read with 36, which is not schedule offense.
Okay.
Therefore, there is no schedule offense. They cannot, on assumption or presumption, as learned single judge courts, issue a summons. It is not a case where summons is issued to a third party or anything. Summons is issued
Then
to...
tell us, why did they dismiss this? Why did he dismiss it?
I'm at a loss to say that. Probably only thing from the tenor of the judgment I can gauge is, you have approached at a preliminary stage. The highest that could be, though that is not actually the sentence, but that is that appears to be the tenor.
Even according to you, Mr. Patel, even there is no predicated offense connected. Even investigation would be barred.
Yes.
The investigation is under the PMLA. That's what you are saying.
That's what I'm saying. Probably there is one more angle, that is, there is a predicate offense to which at the offense stage I am not connected. It is filed against XYZ. Thereafter, the case is registered against me saying, with the proceeds of crime in that case, you have dealt with it. Therefore, a summons is issued, could have been a case. But in my case, they cannot do that because In the predicate offense case, I was arraigned as an accused. Initially, charge sheet was not filed against me. When they filed the charge sheet, they have filed charge sheet in respect of offenses which are not predicate offense, of which even cognizance is not taken. Therefore, I stand on a different footing as a case where it is quashed or a case where I am discharged of the predicate offense. Now the offense against me is altogether different.
But how relevant would be this observation with regard to section 13(1)(e) and 13(2)?
Yes, my lord. Of course, they claim a privilege that they will not divulge the information. As far as that is concerned, for a moment assuming this offense, this is also a schedule offense, therefore it could be on the basis of this case which is registered. Now, as on date, by the time this appeal was filed, I have challenged that there is an interim order of stay granted by this honorable court. I challenged the sanction.
But will that mean that they can't go?
Yes, my lord.
Will that will have
Yes,
effect?
the courts have taken the view when the proceedings in the schedule offense are stayed, as on that day, so long as stay order is in vogue, there is no predicate offense.
Okay.
On that ground, it is done. That writ petition, I'm sorry, my lord, I should have filed it with a memo that has been, I will only give the number and then I will take a certified copy and produce it, my lord. That is WP 10108 of 2024. Interim order was granted on 4/4/24. I will get it filed, my lord, just for reference, your lordship, may kindly.
No, you have said so, it has been stayed.
Yes.
That's enough. Your statement is there. The stay is continuing.
Yes, ma'am.
13(1), this PC Act would be a predicated offense?
Yes. 13(1) and 13(1)(a) and E and 13(2) are predicate offense, which is now stayed.
So what have you challenged in that petition? In that petition?
In that petition, the sanction.
Oh, sanction.
Sanction for prosecuting.
Okay.
Because they seek to bring me in on the ground that I was president of a cooperative bank. With regard to PCARD banks, that is Primary Agriculture and Rural Development Bank, there are two decisions of the Supreme Court saying presidents of those banks would be treated as public servants. But at the same time, in respect of another cooperative society, Supreme Court itself has said this, all of them cannot be brought in as a public servant unless you show that that cooperative society is an assisted society where government investment, etc. So and so is that. But it's a matter yet to be heard. It is.
But that will not have any relevance here.
It will have relevance to the extent if my learned friend is to press that even if this schedule offense is not to be taken as a predicate offense, that would come into picture, would be the case.
Now the 13(1)(e) would come in.
Come in, that it is enough. There is one case.
But in any case, Mr. Patil, you also proceed on that premise. Even Mr. Kamath also says so. You both agree on this. 13(1)(e) and 13(2) are the predicated offense.
Predicated offense.
The only issue is now there is a stay.
There is a stay.
whether they can go ahead. or
Yes.
not.
And the argument that it is at a stage of summons, therefore you cannot come at this stage, would not be applicable in the present case for the reason. In the schedule offense case, I was an accused. Schedule offense case is registered against all other accused. As against me, schedule offense is not registered. Therefore, to say summons may be as a witness, summons may be for any purpose, etc., will not apply, because I was made as an accused in the schedule offense case, but schedule offense is not registered against me. In that regard, the observations made in Vijay Madan Lal Chaudhary case, etc., would come into picture, Mala. First thing with regard to maintainability, I would respectfully
But
submit.
how would you clarify this schedule offense case made against you, what you have said, the last submission, but not registered against you, or something like that? What is
Yes,
the
ma'am.
distinction you are drawing?
Initially, the offenses in that case were 409, 465, 468, 471, 201, 120B, read with section 37, etc., were the offenses, and even 420.
Lord, that, my lord, those offenses may not be material at all, my lord. I am on a totally different line of argument.
Okay. Very good.
The
Fine. Then go
registration
ahead.
of any,
So that we can hear him.
yes, but I just need about 15 minutes, my lord.
Some of the offenses which were alleged in which I was made as an accused were now scheduled offense. Charge sheet is not filed against me in respect of those offenses. Initially, totally I was given up, but later under 173(8) again further investigation and a charge sheet is filed, that is at Annexure C. The offense alleged is (226). It starts at page 226.
Where have you urged the grounds which you are now arguing, Mr. Pathak?
These are the writ petition. My main case was with regard to the schedule offense. I was given up as an accused. And even otherwise, there is a stay of that case. I was not knowing till the arguments started that they are making a reference to 13(1)(e) case. It was at argument stage they said that. For that, I orally argued that that is not what is the reason for ECIR. Now they are trying to tag on, etc. But anyway, now I have raised that ground also. Apart from Vijay Madan Lal Chaudhary case, I relied upon the case of Balaji to say if there is a stay of the proceedings, it keeps the entire proceedings in a suspension till interim order is vacated or something else is done. It is not available for anybody to enforce or take action on that ground. It's only after that. For that, the learned single judge says that will not apply to your case, is how he has said, fine. But that will apply now in respect of 13(1)(a) and 2. The other reason by the learned single judge is that in that case, I was made as an accused. For against me, the case is not registered for any schedule offense, is not something which is dealt with by the learned single judge. Probably though he does not give any reason, what is sought to be said is probably, I will not say it is so, that it is at a preliminary stage, might be. Even that is not the reasoning. In Vijay Madan Lal Chaudhary case, with regard to any proceedings being taken up by ED, issuing of summons or anything of the sort, if it is to be taken up, of course, I had already given a set of judgment copy. First, your lordship may kindly go to last operative portion. Conclusion that starts at para 467. Para 467. Page is given in a very small print, my lord, at the left hand top. It would be SCC online. Below that, page 248. 248 would be the page.
253. Is it 253?
Conclusion starts from
253. No, you said 267.
Para 467.
467.
Para 467.
That yes.
Corresponds to page 253. You could either. 248 idea.
Illi.
Vijay Madala Chaudhary 101 page.
Oh. Para 467, my lord.
Yes.
In the light of the above analysis, we now proceed to summarize our conclusion on seminal points in issue in the following terms. The question as to whether some of the amendments to the Prevention of Money Laundering Act could not have been enacted by Parliament by way of Finance Act has not been.
That's not relevant.
Yes. The 2, 3, 4 are to be looked into, my lord. The expression proceedings occurring in clause NA of section 21 of 2002 Act is contextual and is required to be given expansive meaning to include inquiry procedure followed by authorities of ED, the adjudicating authority under special court. Expression investigation in clause NA-21 of the Act does not limit itself to the matter of investigation concerning the offense under the Act. It is interchangeable with function of inquiry to be undertaken by authorities under the Act. The explanation so-and-so of the 2002 Act does not travel beyond the main provision predicating tracking and reaching up to the property derived or obtained directly or indirectly as a result of criminal activity relating to a schedule offense. Then kindly go to 5B. Roman 5B. Independent of the above, we are clearly of the view that the expression and occurring in section 3 has to be construed as or to give full play to the said provision so as to include every process or activity indulged into by anyone projecting, claiming property as untainted property would constitute an offense of money laundering on its own. Then, my lord, your lordship may kindly go to that continuation D. The offense under section 3 of 2002 Act is dependent on illegal gain of a property as a result of criminal activity relating to a schedule offense. It is concerning the process or activity connected with such property which constitutes the offense of money laundering. The authorities under the 2002 Act cannot prosecute any person on notional basis or on assumption that a schedule offense has been committed unless it is so registered with the jurisdictional police and pending inquiry by trial, including by way of criminal complaint before the competent forum. If the person is finally discharged, acquitted of the schedule offense, or the criminal case against him is quashed by the court of competent jurisdiction, there can be no offense of money laundering against him or anyone claiming such property being the property linked to the stated schedule offense through him. Of course, the concerned paragraphs with regard to this observation would be para 45, 49, 77 and 150 of the judgment. Then, my lord, your lordship may also kindly see Roman 15A in the next page. Roman 15A.
Yes.
The process envisaged by section 50 of 2002 Act is in the nature of an inquiry against the proceeds of crime, is not investigation in the strict sense of the term for initiating prosecution, and authorities under so and so are not police officers as such. This I am pointing out for the reason that office had said whether it is maintainable is one of the aspects that may have to be looked into. Then in the next page, Roman 18A.
Yes.
In view of the special mechanism envisaged by 2002 Act, ECIR cannot be equated with an FIR under 1973 Code. ECIR is an internal document of ED, and the fact that FIR in respect of a schedule offense has not been recorded does not come in the way of the authorities referred to in section 48 to commence inquiry, investigation, or initiating civil action of provisional attachment of property being proceeds of claim. Supply of a copy of ECIR in every case to the person concerned is not mandatory. It is enough if ID at the time of arrest discloses the grounds of such arrest. However, when such arrested person is produced before the special court, it is open to the special court to look into relevant records presented by authorized representative of ED for answering the issue of need for his or continued detention in connection with this so and so. This I am pointing out only for the reason, though at the time of filing the writ petition, I quoted 226, 227, read with 482. But that by itself would not determine the jurisdiction under which the order is passed. As in respect of a ECIR, till a complaint is filed under 14, none of these proceedings under the PMLA Act are treated as proceedings under the criminal jurisdiction or the code is applicable. Therefore, 482 is also not available till section 14 complaint is filed. Therefore, dismissal of the writ petition cannot be traced to section 482. It is dismissal of a writ petition under 226, which is appealable and therefore my appeal is maintainable as such because 482 is not the one. The judgment of this honorable court, which the office has made a note of, is in respect of a proceeding under 482. Reasoning of the division bench in that case was, if a petition is filed under 482, there will be no appeal to the division bench. Just because you file it as writ petition, you cannot take an appeal, was the reasoning basically.
Why settle now? You have to see the substance.
Therefore, it is to be, what is to be seen is substance, and the provision I quoted need not be the correct provision. To trace the order, it should be to a correct provision which is under 226. Now, my lord, with regard to the I'll just point out the correct paragraphs in Balaji's case.
How long you would take, Mr. Patil?
Of course, my lord.
We thought we'll complete it. We can hear Mr. Kamath.
I am not going to touch upon any of his allegation about there being no offense alleged against him. I am not going to touch that. My arguments will be completely independent of that. So therefore, if I may commence, my learned friend can come back in the
Just
reply.
wait.
Please,
Let's wait.
let him.
Yes.
Yes.
Go ahead, Mr. Kamath.
Lord,
So what you are saying is no predicated offense, nothing.
that is immaterial. That is immaterial. Lordship will hear me out. Lord, the object of the PML is a twin object. It is not only to punish someone for committing the offense of money laundering, but also very importantly, to prevent money laundering. Now, how do we prevent money laundering? There are various means. One of them is also attaching and confiscating the proceeds of crime. And in this regard, we can summon any person who has information or any document in respect of the predicate offense or the proceeds of crime. So therefore, my opening remark would be that every person we summon need not be an accused. It can be any, in fact, I'll take your lordship through section 50. The language used is any person. The authorities can summon any person. So merely because we have summoned the petitioner, he need not think that he is the accused or he has committed an offense. Because we are conducting only investigation. I'm grateful to my learned friend. He read out in the end, he read out Roman 15a, where, my lord, in Vijay Madan Lal Chaudhary, their lordships say, the proceedings under section 50 don't consider it as an investigation, it's only an inquiry. So the summons that I have issued on 6th of October 2023 is a mere inquiry. I want to know, this gentleman is the chairman of a bank. The admitted fact is, he has admitted in his writ petition, this is chairman of the bank, which means he is in possession of information.
Privy.
Yes.
Privy. Okay.
Yes. And therefore, there are a couple of provisions in the PMLA, my lord, which, my lord, please have a look at section 2U, which is which is at the heart of the act, which is the proceeds of crime. My lord, 2U, section 2U.
Yes.
Proceeds of crime deals any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense, or the value of any such property, or where such property is taken or held outside the country, then the property equivalent in value held within the country or abroad. Explanation: for the removal of doubts, it is hereby clarified that proceeds of crime include not only property not only derived or obtained from the scheduled offense, but also any property which may directly or indirectly be derived or obtained as a result of any criminal activity relatable to the scheduled offense. So A and B may commit cheating. But the proceeds of crime may go to C, he may pass on to D, and it may land up in the hands of E. So C, D, E are in no way responsible for cheating, but can be held responsible for money laundering. So the non-attachment of an IPC offense or any other predicate offense alone does not give a clean sheet under this Act. Now, my lord, please have a look at section 3.
So for AB relevant become, predicated offense become relevant?
Yes, it may become.
Okay.
But see the expanse of that offense, in the sense, it is not only the person who commits the predicate offense, but so long as you are holding it, not 3 will bring more clarity there. Please have a look at section 3, which is the main offense. Offense of money laundering. Please look at the sweeping language. Whosoever directly or indirectly attempts or indulge or knowingly assists or knowingly is a party or is actually involved. What follows is important. Any process or activity connected with the proceeds of crime. So if you're a bank chairman and then if you're associated with the process, you may not have committed it if you're associated, including its concealment, possession, acquisition or use, and projecting or claiming it as untainted property shall be guilty of offense of money laundering. For the removal of doubts, it is clarified that a person shall be guilty of offense of money laundering if such person is found to have directly or indirectly, kindly mark these words, attempted to indulge or knowingly assisted or knowingly is a party or is actually involved in one or more of the following processes or activities connected with the proceeds of crime, namely concealment, possession, acquisition, use, projecting as untainted property, claiming as untainted property. Now, my lord, this is what the law says. Now, please have a look at section 50, which your lordships will have to interpret as far as this case is concerned. Section 50 deals with the power of the authorities. The title of section 50 is Power of Authorities regarding summons, production of documents, and to give evidence. The director shall, for the purpose of section 12, have the same powers as are vested in the civil court under the CPC while trying a suit in respect of the following matters, namely discovery and inspection, enforcing attendance of any person so and so, compelling production of records, receiving evidence on affidavits, issuing commissions for examination of witness and documents, any other matter. Subsection 2 would be relevant. The director, additional director, joint director, deputy director, assistant director shall have power to summon, my lord, please mark these words, any person whose attendance he considers necessary, whether two options, to give evidence or to produce any records during the course of any investigation or proceedings under this Act. It does not say a person who is accused. It says any person.
Even if you see the earlier 1B, 3(1)(b) enforcing the same page.
Yes, sir.
Enforcing the attendance of any person, including any officer of a reporting entity, the examining him on oath.
Yes, sir.
See, any officer of a reporting entity.
Yes, sir.
What is the reporting entity?
That's defined. Reporting entity.
Reporting entity means a banking company, financial institution.
Yes, it's a defined term.
Defined term.
So
what it says is enforcing an attendance. Anybody, including an officer of a reporting entity.
Yes. So it is quite wide. Any person who has information. Lord, for example, in this case, admittedly, the petitioner claims that he is the chairman of the bank. Now, my lord, the allegation against him is very serious. As a chairman, if you look at the FIR and the charge sheet, as a chairman, when he was the chairman, a whole lot of fake gold was brought into the bank, and based on fake gold, loans were issued. And a large number of recipients of the gold loan were all his relatives. And this man, before he took on over as the chairman, he had only 1 or 2 properties. And by the end, we have a large list of properties, some about 32 different nature of property he has acquired. But that is the allegation against him. There are various allegations against him. Now, under these circumstances, my lord, when the FIR was registered, there were a couple of predicate offenses. Section 471 was there, and 120B was there, and Section 13 of the PC Act was there. It doesn't matter if there are any, if the petitioner is booked or not. So long as there is a predicate offense, we can register a ECIR. So after registering the ECIR, we issued a summons. Now please have a look at the summons which the petitioner has produced along with the writ petition.
No, but you have registered against him also.
We have registered this. I'll take your lordship through the ECIR as well. I have registered the ECIR against him because, my lord, he's the chairman. He's the chairman of the bank. My lord, his property, as I mentioned before the investigation was, he had only some 30 guntas of land. After, my lord, we produced a list before the learned single judge. He had some 30, 40 different nature of properties, a whole lot of properties. Now, please have a look at the page number 16. After the registration. Please have a look at our summons at page 91. Page 91, Lordship. Whereas I, so and so, being assistant director, making investigation provisions of the PMLA, and whereas I consider the attendance of Sri so and so, who is the writ appellant before Lordship, necessary in connection with the said investigation. Now, therefore, in exercise of the powers conferred upon me under subsection 2 and subsection 3 of section 50, I require the said so and so to appear before me in person or through the authorized representative in my office on 9/10/2023 at 11 a.m. Along with the following documents: original Aadhaar card, passport size photo and passport, details of immovable property held in your name and in the name of your family members, details of all bank accounts and movable properties held in your name and in the name of your family members, copies of the ITR filed by you from the last 15 years along with the annexures. After this, my lord, we summoned him to appear on 9th. He did not come. He did not appear before us on that date. And in the meantime, we conducted a panchanama at his residence, which your lordship will find at page 93 on 5th of October. Yeah, we conducted the panchanama prior to issuance of the summons. Now, when we went there to conduct the panchanama, he was not there. We have recorded that. Last paragraph would be relevant at page 94. The search started at 7:50 a.m. and on 5/10/2023 and concluded at 5 p.m. on 5/10/2023. As a result of the search, no material record was seized. The search was conducted in a peaceful and orderly manner. No damage was done or caused to any person or property, and no religious feelings were hurt. This panchanama has been typed at the request of so and so, so and so. The writ petitioner was not available then, so we recorded that. This is all that was happened. Thereafter, my lord, the writ petitioner rushed to the learned single judge, and he challenged our summons. And the prayer, please have a look at the prayer in the writ petition, which your lordship will find at page number 88. Issue a writ of mandamus or other appropriate writ or direction, calling for the records from the office of the respondents connected with ECIR number so and so. Issue a writ of certiorari or any other writ. Quash the summons dated 6/10/2023 as illegal and bad at law. Consequentially, issue a writ of certiorari or any other appropriate writ or direction, quashing all consequential and incidental proceedings action initiated. We have done nothing. After that, we have done nothing because anyway there was a stay. We have done nothing. So since 2023 November, my lord, this particular man has withheld our entire investigation. It is still at the summons stage. Not, we have merely asked him to produce.
There are other accused in the affair.
Yes, there are other accused also.
For them also it stayed.
No, all of them were dismissed together. The learned single judge heard, and he dismissed the writ petition.
Court is asking whether in the ECIR there are other.
In this ECIR?
In this ECIR?
No, this is only against him. In the same ECIR. In the same ECIR, there are others also. And they challenged, and their challenge also was turned down with the learned single judge.
Okay, but in any case, insofar the petitioner is concerned.
Yes.
What you are saying is these summons have been issued only to elicit.
Yes.
Carry out not an investigation, but.
No, not at all. Not at all. This exactly falls under what my learned friend read, that para 15 in the concluding.
Predicated offense there or not is irrelevant.
Yes.
That's what
it is only to investigate we have called it.
Even 13 you are not bringing in.
No, nothing. We have said, please come. I mean, there is some material information we want to investigate. And no, this is all that has happened.
No, but in any case, but how do you answer this 13 has been stayed?
Yes.
13.
That
has
doesn't
been
deter
stayed.
me at all.
That would not.
That
This
would not-
would be, what you are saying is independent of.
Completely independent of that. Completely independent of that.
Provisions would be independent of anything which has been registered against him?
Yes.
Or any stay has
Yes.
been granted by.
We are at a very preliminary stage. We are only investigating. The petitioner should come and at least depose before us for us to find out what is the level of his involvement.
But tell us one thing, Mr. Kamar. Suppose in 13 you have registered, it's a predicated offense. Okay, there is a stay.
Yes.
Are you not under by arguing, by saying so, that you have the power to at least carry out an inquiry, unlike an investigation under these provisions, would effectively overcome that stay order under 13 as a predicated offense and carry out?
In fact, there are several judgments. I'll produce this particular.
I hope we are clear.
Yes, we are clear.
Stay there. but
A
forget
mere
it.
stay, my lord, there is a very recent division bench judgment of the Honorable Madras High Court. A mere stay, my lord, is not sufficient for me to stop my investigation.
Very well.
A mere stay of the predicate offense is not sufficient
But
to
otherwise,
deter me from carrying on with my investigation.
otherwise this would happen there. There is a
If
stay.
only if it is quashed. My lord, if my registration of the ECIR itself is quashed, then my lord, I cannot proceed. A mere stay of the predicate offense is not sufficient. My lord, what have I done? My lord, my lord, which is why I said there are two kinds of proceedings under the PMLA. One, my lord, is to punish under Section 3. The second, my lord, we have to prevent further money laundering.
You're right.
It is one of the avowed objects of the Act.
You're right.
Yes.
But what would happen now, what is being said is there is a stay in so predicated offense. Insofar as others are concerned, there is no predicated offense according to him. The only predicated offense which can be connected to this possibly ECIR is 13.
Against him, there are 3 predicated offenses. Today, he may refer to the
13 only, but he says the others are not there. Even 409 and
471 is there.
471.
471
Yes,
is also
it is
predicated
there.
offense.
Yes, that's a predicate.
71 is there. 409, 202, read with section 36.
But why do you say that that being a predicated offense?
So that is not a schedule
That's
offense.
not that's not.
My lord, please turn to page number, please have a look at the charge sheet, page 95. Please have a look at page 95.
95.
Yes.
We are in 95. 173.
Please have a look at page 95. Item 5 there, sections.
409, 465, 416.
Section 471 is present. 120B is also there. These are, both are predicate offense.
Which one? Which one?
Item 5 at page 95. Item 5, page 95. There are 2 predicate offenses there.
No, but is there any stay here?
No, this is against Shobha. I don't know my.
But his name was added later. Petitioner's name was added.
Your Lordship may, for the on facts clarification.
We have what? We have to be clear on facts.
Yes, on facts clarification, page 95, what my learned friend is pointing out. The translation starts at page
132.
Page 132. That was the offense in which I was arraigned as accused number 11. 15. Accused number 15. Then this charge sheet specifically said, as against the petitioner, there are no material and therefore charges are dropped. That is.
So against this 132, you say charges have been dropped.
Dropped. That is page 112 in Kannada. In this thing, I'll just point out. Accused number 8.
Which page you said?
I will, in Kannada, it is page 112. Translation, I will give the page, Miller.
Where is subsequent?
153.
50, okay, that is page 152, it starts, accused number 15. At 153, then on further investigation, they file a second charge sheet against me at annexure G,
Against the same FIR.
in the same FIR,
Okay.
page 260.
216.
260.
Huh.
In that, kindly go to page
260.
273.
Encircled open. This is the page number. Is it the encircled one?
Alla, innondu.
Okay, the open one. Okay.
At 273, bottom, accused number 15, RM Manjunath Gowda, father's name, etc., etc. Then the offenses are Roman 12 at page 274.
409.
409, 202, read with section 36 IPC.
They are not.
They are not schedule offenses.
They are not schedule offenses. We'll continue day after tomorrow, Mr. Kamath.
My lord, day after this on Friday, my lord. I am before the Dharwad bench day after.
Oh, we'll have it on Friday. We'll see morning if it will, we'll take it up. Friday, we'll have it on Friday. Just say we have heard Mr. Patil, learned senior counsel, and Mr. Kamath, learned ASG. For some time, re-notify on Friday.
Into
His own case is predicated offense is only one. So what he's saying is the other FIR, no predicated offense, only 113 which has been stayed.
My lord,
Simple.
he need not be. I can,
Okay,
under
well-
section 50, my lord, it's only a mere, only to verify whether he has committed any offense or not. So we have the right to summon him.
Oh. Friday. Ma'am, call the next man. Complete it.
number 37.
Ma'am, just keep it here. Yes,
There is a
Mr.
delay.
Amare, what is this?
Yes, there is a delay of 74 days. It happened.
74 days.
74 days delay.
37. Okay, okay. You are for whom?
I am for the appellant.
The employee?
Employee employee was before the Sanal Court against the orders passed by the bank withholding the entire gratuity.
Oh, that is not payable.
Yeah. Here, already there was a departmental inquiry.
You're right.
Departmental inquiry, punishment of compulsory retirement was imposed. And in the OSR, Officer Service Regulations, the inquiry was conducted. The Officer Service Regulation itself provides whether he is entitled for gratuity or not. And if there is no action taken by the disciplinary authority while passing the punishment order, withholding the or recovery, ordering any recovery from his salary or gratuity or any other terminal benefits, if he has not exercised that option under OSR, he cannot invoke the provisions of Gratuity Act after his retirement.
How much loss has been caused?
There is no, actually, it is a probable loss. Your Lordship may kindly have a look at the punishment order. Your Lordship may kindly see. The loss
has not been quantified. Loss, it was only a probable loss.
Where is the order?
Your
Final.
Lordship, I kindly see page 99, my lords, the of the paper book.
Yes.
99 and 100 is the operative portion of the punishment, my lords. 99, your Lordship may come to the last paragraph, my lords. Last paragraph, the findings of the disciplinary authority. To me, the participation of the CSO in the fraudulent activity with a few other is beyond question. The amount of probable loss is huge, and the CSO has not shown any inclination for the well-being of the organization, which has
What is the charge? Show us the charge.
charge was, your Lordship may kindly see in the page 69, that's an extra R1. Last charge was only this much during a core banking system was introduced of late during some 20 years back, minutes in the banks. Every check we present before the court will go to minutes online clearance. Here minutes there are certain account holders who are basically traders in this branch. Minutes. They all produce the checks for the clearances. Now the checks are sent for clearance to the drawee bank. And some of the temporarily, when they present the checks for the payment, plus we have to create their accounts. Temporarily, that amount will be credited to the account of that customer. Later, if any of the checks comes back, that means not paid. Checks are returned or bounced. In those cases, those checks are to be, they have to write off those checks. That means that amount involved in the returned check is to be cancelled or it is to be debited to the account of the customer, which was not done. Plus the system was introduced very newly. That time certain clerical mistakes have taken place. Not only the applicant, this petitioner, there is another branch manager also responsible for act. And the
fact remains.
Yes, yes.
The charge also talks about the loss cost to the bank.
Yes.
They could not able to quantify it.
Yes.
But there is a loss.
Yes.
Very well.
Yes.
Now these charges have been proved.
Proved.
Okay. Upheld also. Did you challenge it?
No, I accepted the punishment.
Then it's all right. Then
Accepted the punishment of compulsory retirement. Plus compulsory retirement will not automatically forfeit the entire service benefits.
You're right. But they invoke 468 of the Gratuity Act.
That is what I am asking.
One of the conditions is if you lost cost to the bank, you will not be paid gratuity.
Yes.
And you have accepted that position.
What I accepted is that the punishment I accepted because I had hardly any service left.
Right.
Therefore, I accepted the punishment gracefully.
So Amresh, charge includes the loss to the bank.
Right.
Which have been proved.
Yes.
Which you did not challenge. The loss, it's as good as saying the loss has been proved, which you have accepted.
But this court and division bench judgment says that not only allegation of loss, here it is only probable loss. What the decision
Obviously,
says.
they could not quantify. See the
It is
figures.
to be-
How much is the figure?
Right, it is a larger figure. But it is to be quantified. What is my role? Whether my mistake or my misconduct itself has resulted in so much of.
You are right. Provided you had challenged it.
That there I agree with
There
that.
is
That punishment
a charge loss to the bank is part of the charge which was framed against you, which has been proved you did not challenge.
Right.
So there is a loss to the bank because of your misconduct or misdemeanor. That's enough to attract 468.
Number one. Number two, what my basic ground is that in case if you have initiated the action under YSR, Officer Service Regulations, the regulations itself provides for forfeiture of the gratuity and also what pension is to be paid to a person who has compulsory retired, which you have not invoked at the time when the punishment was imposed.
But the gratuity is paid under the Payment of Gratuity Act.
Right. But when you are not officer, I was an officer, not a workman. So you have.
Right, but they have stopped it at the stage when you retired, when you were compulsory retired.
After 6 months, they issue a show cause notice and then
Right.
initiated this.
No, I think the learned judge was right.
I leave it to
even on the aspect of pension.
Yes, I agree. Pension, it is left to him up to 2/3.
You are getting 2/3?
2/3, yes, that also he has questioned, but our London, there is
You are
33.
getting 2/3.
2/3 I already taken. I'm already taking.
That's, I don't think.
I am great.
The challenge in this appeal is to an order dated
November, yes.
7 November 23, passed by the learned single judge in writ petition number 8576 of 2015, whereby the learned single judge has dismissed the petition filed by the appellant herein. Full stop. The petitioner, the appellant had filed the writ petition for seeking the entire gratuity amount and also claim a full pension as against the against the respondents who had forfeited the complete gratuity amount and granted the pension at the rate of 2/3 of the full pension. Full stop. Considered position is that a charge sheet was issued to the appellant under the conduct rules. Full stop. The charges have been proved by the inquiry officer, which included that the misdemeanor has led to loss to the bank. Full stop. It is also a considered position that the appellant herein had not challenged the findings of the inquiry officer in any proceedings. Full stop. Based on the conclusion drawn by the inquiry officer in the inquiry report, the disciplinary authority has imposed a penalty of compulsory retirement on the appellant. Full stop. It is in this background, the gratuity was forfeited and the pension of the appellant was fixed at 2/3 of the full pension. Full stop. The learned single judge, while rejecting the two contentions, rejecting the aforesaid two grounds of challenge in the writ petition, as in paragraphs 6 onwards, has stated as under. Full stop. Though the submission of Mr. Amresh and a counsel for the appellant is that when the order of compulsory retirement was passed, the disciplinary authority has not stated that the gratuity shall stand forfeited, the respondent bank could not have forfeited the same. We are unable to agree with the said submission of Mr. Amresh for the simple reason that the forfeiture of the gratuity is because of the operation of Section 4(6)(a) of the Payment of Gratuity Act. In other words, the provision itself contemplates that in the eventuality the loss to the employer is proved, the same can entail forfeiture of the gratuity. Even the plea of Mr. Ramesh with regard to payment of 2/3 of the pension, 2/3 of the full pension is concerned, the learned single judge has relied upon the relied upon Regulation 33 of the regulations governing the compulsory retirement pension, and said that in view of the said regulation, the employer, that is the bank herein, was within its right to grant pension only to the extent of 2/3 of the entire pension, not full pension as admissible to him otherwise. We agree with the said conclusion. We do not see any merit in the appeal. The same is dismissed.
I am grateful.
Next. Ma'am. This call will run through the list. Oh, sorry. See, we have to get up. Rest, I think, they will be giving dates.
My lord, if I may just mention serial number 40, I made a change.
Can we just run? Yes. Just run through the list. just after this.
39, 38 urgent, 39.
Who is in 39? Just re-notify me.
For the petitioner.
Just re-notify, just give date in 39.
6-3,
Much obliged.
40.
40.
My lord, in this matter, there's a change of land use application that I made in the year 2018. And the learned single judge has dismissed it by misreading the index in the master plan. It's a short matter within a very short conspicuous.
Just re-notify, just give it in February or so.
My lord, an earlier date, if my lord would consider.
Possible,
72, serial number 41.
Next.
My lord, in this case, my lord, even though there is a stay order, my lord, the employee is relieved from the service, my lord. So hence it is urgent. Even though there is a stay order.
But the tribunal has dismissed it, no? Just give it in February.
Next week, my lord, any date, please.
My lord, I apologize for imposing and re-mentioning, but it's just that this is the third round of litigation that.
We'll have it in February. We'll take it up, man. We'll take it up.
42, Shri Kulkarni.
42, I beg to appear for petitioner, my lords.
Yes,
The respondent.
just re-notify.
28th February.
43, we have adjourned.
Urgent,
44,
serial number 44,
re-notify.
24-2, 45.
45, my lord.
45.10. This is group matter, no?
Yes, please, my lord.
Regularization in the university. You need to hear this. Next, just re-notify.
They have completed more than 30 years.
But you are working now. You're working.
Temporary appointments, my lord. I appear for the
Interim
applicant.
order.
Please, my
Yes,
lord,
madam.
that's an
There is
interim
an
order.
interim order.
Just give it in first week of March also.
I'm grateful.
10th of March.
Let the interim order wherever it is there.
Wherever there is an interim order, shall continue. Just check up, please.
So grateful, my lord.
Next,
46. 46.
just re-notify. Who is appearing for the applicant? Where is Mr. Krishnan? Only Krishnan.
Krishnan.
Just re-notify.
4-3.
Next,
47, Shajay Kumar.
For the appellant.
re-notify. File your submissions.
Please.
Counsel for the parties to file their written submissions.
10-3,
Great.
48.
48, Shri Chandrasekharaya.
Respondent.
Re-notify.
11-3, 49, Shivekulla.
For the appellant.
Appearing for the respondent, may I request for
There are
20.
two connected matters now.
Yes, Mr.
Yes, bro. Hold on, me, both of us appear, bro.
May I
Just
request for
re-notify.
25th, my lords. I'm led by Mr. KG Raghavan. May I request for 25th of February?
We'll just see that 25th suits us.
5th of February. 25th of February.
Obliged.
Please.
Re-notify.
50,
Appearing for appellant.
Just re-notify, ma'am.
27 to 51.
My lord, 14%, my lord. 11 long years, I'm in the court. There is no relief. I am very burdened. Please, my RTA matter, my lord. Please, 5 minutes.
Who is for the appellant?
I'm appearing for that.
Yes, you are for
14% respondent, my lord.
respondent, no?
It arises of RTA. Next week, my lord. Don't hearing me, the single judge passed the order.
Just give it in February, ma'am.
My lord, next week, my lord, please.
No, not possible. Next,
18 to
next.
50, 52.
Appear for the appellant. Suit for possession, madam. Ejectment.
Just give it, ma'am. Next, maybe possible.
There is an interim order.
March
There is
also.
an
I'm
interim
urgency, my lord.
order.
I'm a senior citizen, my lord. I'm urgency, my lord. I'm a senior citizen.
Let's take a date which will be purposeful.
Yes.
You know, getting the point.
Yes.
Yeah.
There is an interim order.
Okay, they just give it in February, last week or so.
27 to
Next,
Interim order, may kindly.
interim order if any to continue.
Please.
53.
So for the appellant in this matter also.
6, 11 and 13, your lordship.
Pardon?
I'm appearing for R1, 2, 6, 11 and 13.
You are for the appellant?
Appellant.
Just
There is an
re-notify.
urgency in this matter, your lordship, because the appeal itself is not maintainable as it is in
So on the
contravention
last
of the PTCL.
Why?
It is in contravention. The sale agreement was done in contravention to the rule act, PTCL rules. It is a granted land.
hence kindly, short date maybe.
So on the last day,
Just
the
give
interim
it
order was
to-
modified to a certain extent that.
That's right, we have seen that.
Please, Your Lordship. Your Lordship, but that is only with respect to ongoing construction, Your Lordship. The order was modified to that extent. But they're starting new constructions, are laying down foundations for a new construction in the same schedule.
We
premises,
say
Your Lordship.
nothing. Whatever is the worth of, whatever is the order says, that will hold good.
Much.
Your Lordship, actually, the order was like to permitting us to finish the ongoing constructions. But the submission was like there was so much of material given for advance and it is all land are partitioned among the family
No,
members.
we will not take that. Let's be very clear. Whatever is order there, that will hold good, simple. We can't correlate to the material.
No, it is all with regard to the next construction only, but now the appellant is every day coming, even in the ongoing
Okay,
construction.
Just give
So
a date,
he's
ma'am.
20th February.
Next,
Interim order may be extended. Your Lordship.
interim order,
Your
if I need to
Lordship,
continue.
Short date.
Appearing for appellants.
Yes.
Kindly seek the-
54, re-notify.
54, my lord, I appear for first respondent.
Okay.
Senior
27
counsel
to
is engaged. my lord.
55,
55.
for the appellants, re-notify.
54 date.
Not in this matter, my lord, please. Since there would be, use arrears would be accrued. That this is with regard to ejection, my lord, please, in respect of it, hear the complaints.
You can hear one only. Yes,
My lord, I am for the appellant, my lord, in first period. That the honorable trial court was pleased to grant interim damages of ₹25 lakhs, my lord, which the respondent came in writ petition for the honorable single judge, came to be confirmed and the honorable Supreme Court also confirmed. My lord, the honorable trial court judge while rendering the judgment, final judgment, my lord,
okay.
has reduced to
Re-notify.
5 lakhs and granted 2 years time. 1 year period has already. Kindly have it on 15th or 16th, my lord, please.
Sweet. Re-notify, just say that.
25th February,
Next.
serial number 56 to 58. Objection.
Serial number 59, my lord. Interim order making. In serial number 59, my lord.
59, interim order, if any, to continue. Where is
Pass
Mr.
over, ma'am.
Deshpande? This is the same where Mr. Patil had argued? Just check up that.
Pass over matter 23rd. Pass over.
12 was passed over.
Just give it, let's get up.